My lord, yesterday this matter was mentioned by Mr. Homi Ganguly, my lord, the Ganesh Puja matter that was supposed to appear in the top of the list, but it is not appearing.
Is it appearing in today's list?
No.
Not appearing at all. My court officers take holidays sometimes. So therefore, I am in difficulty. My regular court officer has found time to come. But he had intimated to me that he was advised bed rest by his doctor. I don't know how he is now here. So that is the difficulty I'm facing actually. You should also know, because you are also officers of the court, they are also officers of the court. So he was supposed to be on bed rest. I asked him to bring his medical certificate today, so he is there. So that is the difficulty I am facing.
Can it appear?
It will appear today. Please give another slip.
Sorry for the indulgence.
If he is, gracious enough to come on Friday, then it will appear. Otherwise, Ganesh Puja will have to go without Ganesh Puja.
The problem is that we have already intimated.
I understand the problem, fully agree with you, but hand over the slip. If he has the mercy of coming on Friday, it will appear on this.
Sorry for the indulgence, my lord.
No, don't compel yourself. Come back on Monday.
The petitioner is a pensioner, my lord.
No, not like this.
My lord, kindly, my lord,
I said
react
no.
for a moment. My lord, State Bank of India, my lord,
Why didn't you mention on Mondays?
May I seek leave, my lord, due to
What
an
is that,
emergency? My lord, on billable offense, my lord, my client was arrested on 28th. My lord, on the next day, my lord, I was enlarged on bail. My lord, thereafter, Bar Association of that particular court, my lord, took taken resolution that nobody will appear for me. Since my lord 29th, I am unable to furnish bond. My lord, I am unable to get any certified copy.
Hand over. Leave is granted.
Grateful.
It will appear Friday at the top of the list. Give notice to your other side.
all the pension amount, my lord, deducted by the State
Sorry,
Bank
no.
of India.
My lord, item number 84, my lord.
Call on the list, please.
My lord, item number 84,
No.
my lord.
Jalpaiguri matter, item 1.
Yes.
I've
This is
mentioned the matter.
my
Your Lordship.
application.
May or may not have become running reports. I am seeking, my lord.
So, please use the microphone. Just put it on.
Sorry, I'm sorry. It was
Yes,
switched off. It's a recalling application, my lord, of your lordship's interim order, which your lordship had been pleased to pass, my lord, on the trust that I had been served. My lord, this is in respect of, my lord, that CBWD, my lord, the bio-waste facilities.
Yes.
Now, my lord, if your lordship kindly takes, my lord, the order, which is, my lord, at, my lord, page 32. Kindly take can 1, my lord.
Lordship,
My application.
if I may, Lordship, I have mentioned the matter. If I may be permitted to make only one sentence, Your Lordship.
Yes.
This matter had appeared, and when the interim order was vacated, on that day, can 1, can 2 both had appeared, Your Lordship. Without hearing me, Lordship, an order was passed, Your Lordship, only on one sentence, that there was inadequate service and there was the trust of the court has not been kept. Lordship, I was
Well,
not
may I
being
just
allowed
place-
to
may-
even
no, no,
place
I-
that on
may I
30th
just
when the
place
order
my
was
application?
passed.
May I place my
All
application?
the
It will
parties have
it will
received.
become clear, my lord. It will just
So
become
either I
clear.
take
Give me
up the-
5 minutes.
Either I take up the matter today or I.
My lord, give me 5 minutes
again to
because
Jalpaiguri.
I'll tell your
If
lordship
it's
why.
your application, I'll hear you first.
Yes, my lord,
Lordship,
it's my
the
application.
order has been vacated.
Kindly, my lord, bear with me for 5 minutes. Kindly, my lord, take the interim order which your lordship had been pleased to pass at page 32 of can 1. 30th of June, my lord, 2023.
Yes.
If you take this order, my lord, the recommendation which was granted, my lord, had been stayed.
You are the writ petitioner also.
No. I
You
am
are
the
the
respondent. I'm the respondent number 10.
Right.
Kindly, my lord, turn over to page 33.
Hmm.
My lord, the third paragraph, this is in my absence. There shall be a stay of operation, lordship has it, of operation of the recommendation granted to the respondent number 10 for setting up a biomedical waste treatment facility in terms of recommendation annexed at page 174 of the writ petition.
Hmm.
The respondent authority shall further remain restrained from granting. This is not my concern. Then, my lord, the interim order shall operate till 31st August 2023 or until further orders, whichever was earlier. Time has already, my lord, expired. Then, my lord, this is very important. It may be recorded here that the order has been passed on trust, since learned counsel appearing for the petitioners submit that the copies of the writ petition sent to the petitioners respondents have been duly received by them. Affidavit of service shall be filed during the course of the day. Now, my lord, kindly, my lord, take, my lord, page 48.
48 of that.
Sorry. 28, my lord, which is Lordship has that. My lord, kindly have a look, my lord, the tracking report. This is of my lord 30th of June.
28 is not the tracking.
My lord, kindly take annexure A, my lord. I'm sorry.
Which
my lord.
annexure?
18, page 18.
It should be, my lord, page 18. It's annexure A, right? First annexure, my lord, after the petition is.
Affidavit portion.
First annexure. already,
Yes.
yes.
It's a
Yes.
tracking report. Lordship has that. May I kindly see at the on the right hand, delivery confirmed on 30th of June 2023. Item delivered at 3:47. And the matter's been taken up, order passed by your lordship on trust that I have been served, delivered to me on 30th of June at 10:30 in the morning.
So it was vacated on that ground.
My lord, it was now what happened, my lord. Respondent number 11 and 12 moved. I also filed CAN 1. Unfortunately, my lord, it was not taken up. CAN 2 was taken up, which was by 11, my lord, or 12, I can't remember. 11, my lord. Order was vacated on that ground. Cost was imposed. That's a separate issue. My lord, my learned friend's clients went up in appeal. My lord, in appeal, only the cost component was reduced, and my lord, the remarks were somewhat watered down. I'm not on that. My lord, my difficulty is, as on today, my lord, learned friend is absolutely correct. There's no interim order. My lord, my difficulty is this, and why, my lord, I'm still pressing this application.
2 is your recall application. 2 is your
One. CAN 1.
I think you're pressing 1.
Yes. 2 is, my lord, 11, which
So
has
that
been
order was passed on somebody else's application.
11. CAN 2, 11. That was taken up in appeal, my lord, and
Right.
disposed of.
Scan 1, why are you pressing?
Yes. The reason I'm pressing CAN 1, my lord, is there are certain other issues on which, my lord, one was the trust that your lordship proposed. That's a different issue. My lord, on facts also, on law also, lordship has made certain comments and certain
The
observations. which
entire
have-
order has been vacated, then
No,
nothing.
no, it's only, my lord, that bit on that ground only.
Whatever makes the ground, the effect is the order is removed. Order is not there.
The order is in respect, only in respect of 11 that was vacated.
Ad interim observations to
My
not.
lord, ad interim, but only, my lord, insofar as 11 is concerned.
Not
it
only
was
ad interim, expertise also in your absence.
expertise, my lord.
The expertise, the observations are not binding at any stage.
I
of the
agree, my
matter.
lord. I agree, but
I'll observe that.
kindly do that. I'm grateful.
What was the observation by
Yes,
the
my
way?
lord, kindly see at page 33.
Yes.
My lord, the second paragraph is a bit damaging for me. And that may not be correct also, my lord, because
Yes.
however, in contravention of Rule 7.3 of the Biomedical Waste Management Rules, the respondent number such and such are on the process of getting recommendation to set up facilities within a distance of 75. It is submitted that 10 has already been granted such recommendation. That's me, my lord. 10 is me. Whereas recommendations proposed for 11 and 12 are in the pipeline. Since the petitioners have made out a strong prima facie case regarding apparent contravention of 7.3, the writ petition is required to be heard in merits. My lord, this,
Yes.
my lord,
I'll make it weak prima facie case.
my lord, kindly say that
Not strong, weak prima facie case?
there's no prima facie case, if I may.
No, no.
If I show you the rule, my lord, I'm more on suppression. There's
That-
a rule
that is the-
8.3
that
which
is the
qualifies, my lord,
That is the
7.3.
reason why the matter was directed for hearing, not decided.
Lordship.
But my lord, if there's a,
Lordship.
because the recommendation for me, my lord, has already been
No, I'll
given.
say that you dispute these submissions and these
Very
proposals.
well, very well.
I'll have to record that.
Yes, kindly do that. my
Lordship,
lord.
Lordship,
I'll dispose of the recall application. I'll observe what I said. That
Lordship,
these are
if I
prima
may-
facie.
Lordship, if I may be made to place this, your Lordship, this is with regard to the respondent number 11. What has just been made, the submission made on behalf of respondent number 10, that on 30th, the matter
Has
was,
attained finality after the order of vacating and challenged in appeal.
Lordship, if
I cannot reopen this envelope.
Lordship, on 30th,
I'll direct the writ petition. to be
Lordship,
received
in
before
that
the
event,
bench.
your Lordship, I'll make one submission, your Lordship. Your Lordship directed, since this is an interim order, your Lordship, there was direction
Please
for
ghost, how
filing.
much cost was imposed?
10 lakhs was imposed,
It
And
was
I-
reduced to how much?
1 lakh, and I've already
Should have
paid.
been more. Should have been more. More than 1 lakh.
Lordship,
Should have been more.
Lordship,
I think 10 lakh was the more appropriate amount. Learned counsel for the petitioner in CAN
1, my lord.
1 of 2023 submits that despite the order dated June 30, 2023, passed in WPA 1374 of 2023, having recorded certain submissions of the petitioner, and that the petitioners had made out a strong prima facie case regarding apparent contravention of Rule 7 within bracket 3 of the 2016 rules, comma, such contentions are disputed by the present applicant stroke respondent number 10 in the writ petition. First up, it is no, it is not. Learned counsel for the present applicant controverts the submissions made on the said date by the petitioners. Full stop, next para. It transpires upon hearing learned counsel for both the sides that the order dated June 30, 2023 was vacated on the on another ground, comma, at the behest of respondent number 11 in the writ petition, comma, since apparently, comma, despite it having been recorded in the order that the copies of the writ petition were served on the respondents, comma, on the basis of submission of learned counsel appearing for the petitioners, comma, such service had not been effected on all the respondents on the said date. Full stop, the said order vacating the order dated June 30, 2023 and imposing costs of rupees 10 lakh was subsequently challenged in an appeal, comma, where the order was sustained, comma, thereby maintaining the vacating of the order dated June 30, 2023, but reducing the costs to rupees 1 lakh. Full stop, next para. As such, comma, as of today, the order dated June 30, 2023 is no longer in existence, comma, having been vacated subsequently. Full stop, thus, comma, the findings rendered therein do not have any bearing, comma, in any event, comma, on the disposal of the writ petition. Full stop, however, comma, since the present applicant expresses apprehension that the recordings in the said order might have a bearing in the final hearing of the writ petition, comma, in order to allay such apprehension, comma, it is hereby recorded that all observations made in the order dated June 30, 2023 within bracket before it being vacated, bracket closed, were on absolutely a prima facie basis and tentative in nature, comma, based on the submissions made by the petitioners, comma, at the ex parte stage. Full stop, hence, comma, as well settled, comma, the said findings cannot have any manner of finality at all at the stage of final hearing of the writ petition. Full stop, next para. Accordingly, there is no reason to interfere further, comma, more so since the order sought to be recalled has already been vacated. Full stop. Accordingly, Can 1 of 2023 is disposed of in the light of the above observations. Full stop. WPA 1374 of 2023 be listed before the appropriate bench in the oncoming Jalpaiguri circuit.
Grateful to your lordship.
My lord, I am appearing for the state. My appearance may be recorded.
Give your name.
I filed the affidavit of service.
Yes. Order has stands vacated, nothing is there. So I'll have to take up the আচ্ছা একটা যেখানে আগের সেন্টেন্সে দিলাম না, the writ petition be placed for hearing যেটা বলেছি, placed as a motion before the appropriate bench, Jalpaiguri.
Grateful to your lordship.
Give your names, please.
Grateful to your lordship.
Grateful, my lord. My lord, I filed the affidavit of service, my lord, of Can 1. Grateful.
Yes.
Grateful.
সাড়ে দশটা আগে ডাকো, সাড়ে দশটা।
Item 7, fixed at 10:30.
Yes.
My lord, yesterday, my lord, when I'm praying for leave to file one supplementary affidavit, because my lord, I have wrongly understood the instruction of a learned junior sister. Today is not the last date of submission of the application. Today is
The
the,
last date.
no, it was already been over. That I have stated in my supplementary. But on Friday onwards, the admit card, the interview process for the oral test, that is going to be initiated. My lord, we
What
have,
have we challenged here?
my lord, may I hand up to this lordship? Well, there is a Anganwadi worker ICDS project, my lord.
Yes.
We were engaged and is a post and these vacancies were declared for the promotional post. And my lord, we have also applied. Out of 33, 22 was the general and rest are some reserved candidates. Well, our allegation was that when the result has come out, we have not been selected. We have made one application and also came to want to know from the authority, please hand over our answer script so that we can assess. On the ground that there was we have got the news that some of the reserved candidate, those who did not yet get a good marks, but they were treated as a general candidate. By this way, the remaining vacancy for the general candidates, as they were chosen from the reserved categories, but we have not been, perhaps or may not be chosen.
Chatterjee, this requires a hearing. I won't pass any interim order.
No, my lord, we are not asking for any interim order.
Direct copy, sir.
Only one lordship, we're praying for lordship. If the answer script can be given, so that we
This is
can.
the final relief you have asked for.
No, my lord, subject to kind sanction, my lord.
Answer script.
I'm not
We'll
installed.
have to see whether there is any provision for that or any bar for regarding that.
My lord,
Because in university examinations, there sometimes are specific regulations.
yes.
If those are not satisfied, then there is no direction, no
But
scope
my
of
lord,
direction.
subject to kinds in under this category of selection process, my lord.
Yes,
In
yes.
some of the matters, I have made one RTA application. The authority
Disclosed.
it was disclosed and it was handed over. Because my lord, I cannot ask for the installation of the process, but we are only praying that let the copy be handed over, assist us so that I can come back before your lordship once again.
Chatterjee, you have challenged what? Their refusal to hand over the answer scripts? or the-
Answer script as well as by
the
not
process.
considering these applications, they are going to install another separate proceedings. Filling up the
let
posts.
them come, we'll consider whether I'll give you an inspection or
I'm only appealing the
copies may
short-
not be handed over, inspection may be given.
Lordship.
Learned
Well, short date may kindly be given.
Very well. Learned counsel for the petitioners submits that the petitioners are Anganwadi workers and duly took an examination for further promotion. Full stop, next para. However, it is alleged that the petitioners did not succeed in the said examination primarily because some candidates falling within the category of scheduled castes and scheduled tribes were treated to be general candidates, thereby curtailing the participation of the general candidates. Full stop. On such score, the petitioners also sought copies of the answer scripts, but were refused to be given the same. Full stop, next para. Since the prima facie case has been made out, the petitioners shall serve copies of the writ petition on the respondents, indicating that the matter shall be listed for hearing on September 12. I'm sorry, not September 12. October 10th. On October 10th, 2023, under the upgraded hearing. Affidavit of service shall be filed on next day.
And my lord, I'm tendering unconditional apology, my lord. Yesterday I have
No, no.
taken the leave. I have wrongly
You
understood.
have mentioned. আর একটা লাইন অ্যাড করে দিয়ে উপরে যে supplemented affidavit filed to be kept on record are serve copies of the writ petition as well as the supplementary affidavit. Right?
Madam, I'm grateful.
Extension of interim order, item 1.
I appear for the
When
petition.
does it expire?
Milord, it had expired on 31st of August, Milord,
31st
2000.
of-
I am for the Union of India led by Mr.
What was the interim order granted?
Milord, there was an issue, notice was issued, Milord, directing upon me to refund, Milord, certain amount which I have received, Milord, pursuant to a scheme, Milord. That was directed to be refunded and that later was stayed, Milord.
Very well. I'll extend the interim order. But don't spend that amount. If
No,
ultimately, if you lose, then you will be in a jeopardy. The interim order granted earlier is extended till October 19, 2023 or until further order, whichever is earlier, full stop. The matter shall be listed for hearing on September 25, 2023.
25th September. Great.
Top item, item 2.
Well, I appear on behalf of the petitioner.
I
appear for
Punjab Financial Corporation.
But the respondents were to file their affidavit in opposition. They have only handed over the affidavit in opposition yesterday.
I've been instructed. May I be given 2 weeks
Does
time?
not remain under the top category.
Kindly, Lordship will keep it under, kindly, Lordship kindly keeps it. But I could oppose that if they were out of time. But they
My
only
lord, the
submitted.
council appearing in this matter, my lord, is suffering through various illness, my lord. Kindly keeps it any
My lord,
day.
the council was unwell, so I'm not opposing to that,
What
Lordship.
is the urgency in the matter in any event?
My lord, the substantial sum of money invested by the employees of the Kolkata Port Trust, which is now Samapada Port Trust, was invested with the respondent, Punjab Financial, in bonds. They were supposed to return the money sometime in 2016. They defaulted. We approached this court. They hand over the principal amount, but still the interest they're not paying. But that is the position. That these are the money of the employees. The employees of the.
Very well. The affidavit, you're filing the opposition.
My lord, the
An adjournment is sought on the ground of learned counsel for
copy
the
has been served online, my lord. The firm copy will
for
be
the
there with
respondent,
same.
full stop. Time for filing opposition as well as reply is extended till September 25, 2023, comma, when the matters shall be listed under the same heading.
Grateful, Lordship. I'm led by Mr. Mitra.
Right.
Item 3.
Yes.
For the state, Lordship.
What was the matter about?
Lordship, the only difficulty I'm not briefed in this matter. In this matter, Mr. Somrat Sen and Ms. Malali Ali are appearing. Earlier, she has appeared and she told that the state sought for time to get instruction. But today I have been informed that
Report was to be filed.
yes, Lordship.
What happened to her?
Lordship, he couldn't make out to come to court because she is ill. What I have been informed, Lordship.
None appears for the petitioner at the time of call. The state also prays for an adjournment on the ground of absence of learned counsel for the state on personal grounds. Full stop. Accordingly, let the matter stand adjourned and shall next be listed on September 26, 2023 under the same heading.
Grateful, Lordship.
Thank you. Actor line add করে দিও, the time for filing the report as directed earlier is extended till the next returnable date.
Grateful.
Item 4.
Item 4, I'm for the respondent number.
My lord, I beg to appear on behalf of
Yes,
the
Mr. Gupta, what is the matter?
petitioner. This is my affidavit of service.
Right.
Here the petitioner applied for a gold loan. On the basis of this loan was sanctioned, amount was given.
Right.
There was some default on the part of the petitioner at that point of time. After that, the petitioner went to the bank and also made a representation that she want to pay all the dues of the gold loan, entire due, and take back the gold. Bank said in their representation that they can take the money, but they are unable to release the gold.
Did they give any reason? Any reason given by them?
There are reasons which was that there was another loan. My lord, that loan is not amalgamated with this loan. That loan was regard to a property which lies section 17 before the DRT. 13.2 was initiated.
You are the borrower there also.
There I am also the borrower. My lord, may I say, this proceeding was drawn up under Indian Contract Act. This proceeding. Under 176, if the loanee wants to pay up the dates, then they have to redeem it and return all the gold. The NPA which was declared in that account, here the NPA, there is no letter of NPA when the NPA has been declared or anything. If your lordship
in this matter, you are willing to repay the entire amount.
Yes, the 25 lakhs, which
Therefore,
is.
you say they are duty bound to pay back return the gold.
Yes.
They cannot have a lien on regarding that.
Yes, lien 171.
What is the stage of that section 17?
Section 17, they have issued 13.2. After that, they have issued 13.4. we are going to file the section 17 application as because in that I have also annexed
You
the
have not yet filed section 17.
no, there is a 45 days time.
You have not yet filed any section 17.
No, I have not, but 13.2 I have replied to, I have objected to as because the NPA which was declared in that matter,
That's a different issue.
that is a different issue. I am not saying after filing of this application before your lordship, they issued on after receiving the writ petition, they issued a letter stating that they are going to, which I have mentioned before, and I have supplemented the affidavit because after filing of this application, this letter was given to us.
You have given a copy to the other side?
No, just now I have supplemented.
What is the letter? What is the letter?
The letter was issued by them that
To the
on
state.
15 September, they are going to auction the sale,
Gold.
gold.
Well,
But in that letter,
yes.
they have not said what are the amounts. The amount due, I know it is about 24 lakhs. 24 lakhs is the amount due.
That is regarding the other property.
No. Only for the gold.
No, they are going to sell the gold to realize the other dues.
No. Only for that
Show me
I
their letter. Show me their letter.
not I. This is the
Give a copy to Mr.
yes. There are 3 letters of 3 accounts of the gold loan.
Same, similar.
Similar. One loan was issued on June 2022. The next was 24th August.
Are they referring in this to the other loan or this?
No. My lord, I have annexed to the other loans paper also.
They refer to the present loan here.
Only the gold loan.
They say now there is due and payable by you to the bank under credit loan facility a sum of rupees 4,60,684. You agree to this?
No, I am agree. That is for the gold loan. 4,60,000. There are 3 gold loans. 3 letters has
So
been
they have
given.
called upon you to pay that amount. In default, they'll sell. So pay the amount tomorrow.
I will be paying that I
But understand, Mr. Gupta, their letter says we finally call upon you to pay to the bank the said sum of rupees
Yes,
4,60,000
yes. When we are going to
with interest.
when we are going to the bank, they are saying, okay, you pay it,
I'll give them a direction subject to hearing, your learned friend.
and they will not release the gold. Yes.
This is inclusive of interest. All right. Let me hear him. Yes.
And as per 176, it says
What does it say?
that 176 says that if a time is stipulated for the payment
Contract
of
tax.
contract.
প্রথম বইটা দেখতে পাচ্ছি আমি 176
176, 177. 176 is the default clause, and then 177 is the defaulting owner's right to redeem.
Yes.
If a time is stipulated for the payment of the debt or performance of promise for which the pledge is made, and the pawnee makes a default in payment of the debt or performance of the promise at the stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them.
Yes, they are also asking for
Yes, actual sale of them to redeem it.
Let us not continue this argument, Mr. Gupta. It's very clear. Let them answer.
Yes.
What is
Excellent.
your answer?
My lord, there is a gold loan policy of the Canara Bank which says that any amount receivable from the auction, after applying it to the gold loan, then it should be applied to the other loans standing in the name of the borrower. And this has been agreed by the borrower at the time of taking the gold loan.
Please.
May I? Kindly come to.
Please give a
clause
copy
8.
to him.
Yes. Kindly come to clause 8 at page 126 bottom. Kindly see the
Right.
auction of gold jewelry.
Yes.
Kindly come to subclause S at page 127. Bottom.
Right.
The balance amount, if any, after adjustment of all our dues, should be credited to the SBA current account of the borrower under advice to him. A provision to this effect is incorporated in the gold loan application. This has been agreed upon at the time of taking the loan. For any reason, if for any reason such balance amount could not be credited to the account of the borrower, it must be credited to so-and-so account, specifying the loan number and other particulars. But this is one of such clause. Then, Mala, kindly come to W, next page. in case the borrower is having overdue stroke NPA in any of his direct liabilities and indirect liabilities, the excess amount has to be appropriated towards the same after giving due notice. My lord, she has gotten another account which has become NPA, which is more than 75 lakhs or 80 lakhs. My lord, the point is, my lord, any excess amount here, if it is receivable, then my lord, that should be applied to the other loan account in her name. My lord, she wants to redeem this particular account, leaving the other accounts. My lord, kindly come to this has been informed to him also.
That question arises
Yes,
only if you auction the gold jewelry.
Yes, in the event I auction the gold jewelry.
He's wanting to redeem it. Redeeming comes before auctioning. You are not allowing the redeeming and you are direct, asking.
No, my lord. In the meantime,
Yes.
that other accounts have become NPA.
No doubt on that. Suppose those dates are there, they have those dates with you. But can you enforce this? I mean, before, if they want to redeem,
No,
they're
once
trying
it
to
is-
bypass that auction, obviously.
Yes.
But can you refuse that and
My lord,
go
if
to
it is-
auction
it ha-
directly?
if it has become already NPA, other accounts, my lord, then my lord, my right to adjustment comes, my lord. Kindly come to this W. Let us read, my lord. In case the borrower is having overdues stroke NPA in any other. If it is NPA in another, if it is not NPA in any other account, my lord, I cannot adjust. I think, my lord, I made myself clear.
Yes.
If it is NPA, my lord, I have a right to adjust.
Right.
If it is not NPA, my lord, it's running account, my lord, then I cannot adjust. My lord,
Anything else? Yeah. No, let him come.
Oh,
please. Yes. I'm sorry.
May I take a hypothetical case, my lord? There is no other dues in any other account or NPA. Other accounts have not become NPA.
Yes.
My lord, the clause S says that I have to sell, adjust the amount due in this account and refund the amount.
Right.
But W qualifies the thing if there is another accounts NPA and it has been agreed upon by the borrower at the time of taking loan.
Right.
This is my submission. Well, I can put it on affidavit, this particular
I'll
policy.
keep it on record.
My lord, may I submit one thing? With respect to my learned friends, if there was a surplus of the security in that NPA account, there is a security of 1 crore 27 lakhs out of 75 lakhs due. If your lordship kindly come to the sanction letter, because the sanction letter was issued after this gold loan was
This is on the other loan.
other loan.
You are disputing the quantum, the liabilities regarding the other loan.
Yes, no, not that. As per the submission of my learned friend, they said that if there is a surplus to that, we can adjust it. There is no surplus in that loan. Because if they take the whole, they have the security of two flats, one at South 24 Parganas at Taliganj and one at Howrah.
So for those loans, you have already given security, which can be realized.
Yes, and also the plant and machinery is also there. And my lord,
We are not on the dispute.
no, I am not disputing that.
I get your point. Since those are already covered by security, you are
It's
saying.
covered by
But
security.
that in any event,
And in the
based on
13th
interpretation on of this.
and in 13.2 and in the sanction letter, this loan was earlier, gold loan. They could have said, this is also a limit to that. No limit has been, that account has not been amalgamated with that sanction letter. The sanction letter which is been annexed here, the sanction letter is of 2023.
Right.
This is an extension. It is at annexure P4, page 34. That is of 16 to 2023. It has been enhanced time to time. The last sanction letter is of 16 to 2023, where the valuation is also been given by their valuer to the property at page 38. Page 38, the flat is of 56 lakhs, which has, it is of 2018, 2023.
This is the collateral for the other loan.
Other loans, 59 lakhs and another is 27 lakhs.
If I can add only one
No,
sentence.
reply, Mr. Dash. Yes, you add if you want. Shunani? Yes.
Only thing, there is a concept of general lien over all the accounts. The NPA was, I have given a reply. The bank has given a reply to their legal notice
Right.
that the NPA was declared on borrower wise. The concept of NPA is a borrower wise. My lord, kindly appreciate, my lord. If I can recover, this is a gold loan auction, and I can recover 25 lakhs or 28 lakhs. I may not recover the other loan in its entirety. That's why I have a general lien over this. What I can, kindly appreciate, my lord, that is at page 32. This has been given reply. They have disputed this and they have given reply. We have the bank had given reply to this. Due to non-payment of all dues, all loan accounts held by your client has been classified as non-conforming asset, my lord. So NPA, concept of NPA is I have to recover the loan.
My lord, then they have to declare this account also in NPA through a official letter of NPA. No official letter of NPA has been.
This account has not been marked as an NPA.
Yes.
No, this is a secured
It
gold
has to be
loan.
marked specifically.
Yes.
No,
Has it been marked as an NPA
No.
account?
my
a
lord,
gold
kindly,
account?
kindly see
This
this.
is a general clause.
No, kindly see. My lord.
The
We have given them option to pay.
Then
They did not pay. That's why the auction
they
has
are
come.
wanting to pay.
My lord, only difficulty is,
So
my
has
lord,
a gold loan account been marked as an NPA? They are all along wanting to pay it.
They are only saying the overdue amount to be paid, overdue amount and the payment of. There is not saying that they classified NPA. In their letter of
I
page
was
50.
relying on this W.
No, W is there. SW are there.
I can put it on affidavit also.
The
All these documents.
petitioner's challenge is against non-return of the secured gold assets lying with the respondent bank. It's a bank or
Bank,
Canara Bank.
Canara Bank.
Canara Bank.
respondent bank, comma, despite the petitioner wanting to repay the entire debts of the bank. Full stop, next para. It is submitted that the bank has so refused on the ground that the petitioner has other loan accounts, comma, which have been marked as NPA. So it is submitted that proceedings under section 13 of the SARFAESI Act 2002 have already been taken with regard to the said other accounts, and the petitioner is contemplating filing of an application under section 17 of the said act in that regard. So moreover, comma, it is argued that under section 176 of the Contract Act, comma, read with section 177, comma, if time is stipulated for payment of debt or performance of the promise, and the pawner makes default in payment of the debt or performance of the promise at the stipulated time, comma, he may redeem the goods pledged at any subsequent time before the actual sale of them. Full stop, next para. In the present case, comma, it is argued, comma, the petitioner is seeking to repay the amount, but the bank is not taking it on the one hand, and, comma, on the other, comma, with a letter dated August 10, 2023, comma, the bank has written to the petitioner that the petitioner is required to pay all dues, including the interest. Full stop, next para. With regard to the last submission, comma, learned counsel relies on a document annexed to a supplementary affidavit, which is filed in court today with leave of the court. Full stop, next para. Learned counsel appearing for the respondent bank cites a gold loan policy of 2023-2024 of the respondent bank. Full stop, it is submitted that the said policy was a part of the agreement to which the petitioner consented at the time of pawning, PAWNIN, the gold in question. Full stop, next para. As per clause 8, comma, subclauses S and W of the said policy, comma, the balance amount, if any, comma, after adjustment of all dues of the bank, comma, should be credited to the SB stroke current account of the borrower under advice to him. Full stop. More importantly, comma, it is argued, comma, in case the borrower is having overdues stroke NPA within bracket non-performing asset bracket closed in any of his direct liabilities and indirect liabilities, comma, the excess amount has to be appropriated towards the same after giving due notices. Full stop, next para. Learned counsel also places reliance on clause on paragraph 6 of a communication of the
Reply to the legal notice.
of the bank to the petitioner in reply to a legal notice of the petitioner, comma, dated July 21, 2023, comma, where the bank reiterates that due to non-payment of dues, comma, all loan accounts held by the petitioner has been classified as a non-performing asset. Full stop, next para. It was thereby informed that since the NPA is classified borrower-wise, comma, no single account can be settled against repayment of dues. Full stop, next para. Thus, comma, the bank insists that unless the petitioner repays all the dues from the petitioner to the respondent bank, comma, the secured gold in the current account cannot be released. Full stop. In fact, comma, the bank is contemplating holding an auction sale with regard to the gold to satisfy the dues, comma, to the extent possible regarding all the loans between the bank and the petitioner. Full stop, next para. The policy cited by the respondent bank, comma, it is not disputed, comma, was in full knowledge of the petitioner. Full stop, next para. However, comma, clause 8, comma, relied on by the bank pertains, comma, even as per the caption thereof, comma, to auctioning of gold jewelry. Full stop, next para. The question of auctioning, comma, again, comma, is subservient to the previous clause, that is clause 7 of the policy. Full stop. Clause 7 provides for steps to be followed for recovery in gold loans when the interest stroke installments become overdue. Full stop, next para. Thus, comma, the scope of holding an auction of the gold jewelry deposited with the bank as security of a gold loan arises only when the borrower fails to repay the amount. Full stop, next para. However, comma, in the present case, the borrower has specifically sought to repay the amount along with all interest. Full stop. Therefore, comma, the bank is seeking to jump by attempting to hold an auction of the gold jewelry, comma, despite the petitioner's specific request to repay all the dues along with interest to the bank, comma, even in terms of the letter of the bank. Full stop, next para. Clauses small s and small w only come as sub-clauses under the broad heading auctioning of gold jewelry, comma, which is only a corollary to the process of recovery of gold loans. Full stop. Since the petitioner seeks to repay the entire amount of loan along with interest, comma, there does not arise any question of the said stage having come as yet. Full stop. The provisions relied on by the bank, comma, being that the balance amount, if any, after adjustment of all other dues should be credited to the account of the borrower under advice to him, and that in case of the borrower having overdues, comma, the excess amount being appropriated towards the same after giving due notices, comma, only refers to auctioning of the gold jewelry, comma, in the event the petitioner does not repay the entire amount. Full stop. The double inverted with the excess amount referred to in subclause small w of clause 8 of the policy of the bank refers to the excess amount upon the gold jewelry being auctioned, comma, which stage, comma, as indicated above, comma, has not yet arrived in the present case. Full stop, next para. Insofar as the reliance of the bank on paragraph 6 of its communication dated July 21, 2023 is concerned, comma, the same is misplaced. Full stop, next para. The bank, comma, in paragraph 6 has sought to advance a proposition that there is a blanket classification of non-performing asset in all accounts. Full stop. The exact statement of the bank is that due to non-payment of dues, comma, all loan accounts held by the borrower has been classified as a non-performing asset and that the NPA is classified within double inverted borrower hyphen wise. Full stop. However, comma, such concept is alien to the RBI circulars regarding classification of accounts as NPA. Full stop. Such classification has to be on an account basis and cannot be blanket, comma, on a borrower base. Full stop. Next para. In the present case, comma, the question of invocation of NPA regarding the gold account has not yet arrived, comma, since the basic prerequisites for such classification have not been satisfied. Full stop. 90 days has not crossed after the borrower failed to pay the amount, comma, even after the bank waiting for a prior period of equivalent amount, comma, subsequent to the borrower having made the account overdue. Full stop. Next para. In the absence of any satisfaction of court that there was an overdue in the gold loan itself and thereafter the bank waited for a subsequent period of 90 days, comma, as required by the concerned NPA circular of the RBI, comma, it cannot be said that the blanket reference to all accounts of the borrower also applies to the gold loan account. Full stop. In particular, comma, since the petitioner is fully agreeable to pay the amount, the entire amount, comma, the respondent bank cannot withhold the return of the same on the pretext of other accounts of the petitioner having suffered the fate of becoming NPA. Full stop. In any event, comma, certain secured assets have been mentioned by the bank itself in its proceedings under Section 13 of the 2002 Act pertaining to the other loan of the petitioner, comma, which is allegedly overdue. Full stop. Hence, comma, the gold loan, the gold ornaments or the gold deposited by the petitioner in the context of the present account cannot be deemed to be a secured asset pertaining to the other loan account, comma, to enable the bank to withhold the return of the same. Full stop. In fact, comma, the concept of within single inverted general lien is not available to the banker, comma, since the clauses of the policy relied on by the bank are not applicable to the petitioner for the reasons as enumerated above. Full stop. In such circumstances, comma, the respondents are duty bound to return the entire secured gold to the petitioner, subject to the petitioner paying rupees 4,60,684, which is the claim of the bank with a letter dated August 10, 2023, comma, and includes all interest on a compounded basis from the on the principal amount. Full stop. Next para. Hence, comma, WPA 19071 of 2023 is disposed of by directing the petitioner to repay the entire claim of the bank in connection with the gold loan account.
Three gold loan.
There is three
Gold loan account.
3 gold loans, and the amount will be not 4 lakhs, it will be total 24 lakhs.
তাহলে 4,60,000 যেটা
ওইটা that is for only one account. There are 3 letters for 3 accounts.
all equivalent amounts.
No, all are different.
তাহলে ওই অ্যামাউন্টটা কেটে দাও, অফ অ্যামাউন্ট সাচ এন্ড সাচটা কেটে দাও। কি বললাম? WPA by directing the petitioner to entire claim of the bank
With regard to gold.
in connection with the 3 gold loans in question, comma, within
15.
a fortnight from date, full
Yes,
stop. Upon such payment being made, comma, the respondent numbers, which respondent, Mr.
Two, my lord.
Respondent number 2 shall return the secured gold lying with the bank, comma, in connection with the said 3 gold loans to the petitioner at the earliest, comma, positively within a week thereafter. Full stop. No arrest to cause service.
My lord.
Affidavit of service filed to be kept on record. প্রথমে একটা file. Thank you. Next.
I am appearing for the Union of India.
Very given. Yes.
Item 5. Item 5, I appear for the petitioner.
What is the matter, please? Service. Savitivity service.
All served?
All served.
Yes, what is it?
What the state
The State Bank is the main
Bank is
answering.
not appearing.
State Bank is the answering respondent.
You forgot?
No, I appear for the response. I was just outside the court.
Yes, what is it?
Your Lordship, the petitioner
Please take your seats. Yes.
has filed this present writ petition being aggrieved by the action on the part of the respondent bank in unilaterally debit freezing his savings bank account, his fixed deposits without putting the petitioner prior notice or without any opportunity of hearing or in any communication whatsoever. Now, certain facts, certain dates I need to indicate to your Lordship. What happened is that the petitioner on 30th June 2020 entered into a partnership form with one person. Now, due to the behavior of that person, which the petitioner did not like, the petitioner resigned from that partnership by a letter dated 30th June 2020, which was subsequently accepted.
Same date.
I'm sorry, Lordship. The petitioner entered into a partnership on 1st April 2006. And he resigned from the partnership on 30th June 2020. And that resignation was accepted on 18th January 2021.
Registered partnership firm.
Registered partnership firm. And that resignation was accepted on 18th January 2021 by the other partner. Now, what happened, Your Lordship? From 2021 till 2022 December, everything was fine. Suddenly, in the month of December 2022, an amount of rupees 1,47,615 was deducted from the petitioner's savings account. Now, the petitioner did not know-
Deducted by the bank.
deducted by the bank. Now, when the petitioner approached the bank as to why have you debited such amount, I have not given consent for, I have not signed a check. The bank says, no, this is a payment that has been transferred to Aditya Birla Finance Company for a loan, which was taken by my erstwhile partner. Now, the petitioner was shocked.
Account was in the name of the partnership firm.
Yes,
Partnership firm.
yes, the account was in the name of the partnership firm. The bank,
Why
State
do you
Bank
say
of-
your account has been frozen?
I'm telling you, Lordship. The State Bank of India Chodungi branch holds the partnership firm's account.
Right.
My account, my savings bank account is in Deshopriya Park branch. Now they say that that amount has been transferred to Aditya Birla for a EMI or a loan purpose, for repayment of a loan. Now, subsequently, I received an award under an interim award under Section 17 of the Arbitration Act, whereby an award was passed in Mumbai by an arbitrator, from where the award I come to know that I have been roped in as a guarantor by my erstwhile partner, and he has purchased a flat for himself. And along with me, a few other persons have been roped in as a guarantor. I immediately, there is no doubt that even the signature, that is a forged one. That will be a forged signature because I never consented on becoming his guarantor. I immediately lodged a complaint before the Deputy Commissioner of Police and the Tollygunge Police Station. Obviously, they did not, for some reason known to them, they did not take any step. I filed an application under Section 156(3). The learned magistrate directed them to take to
Your
initiate-
account has been frozen pursuant to the order of the arbitrator.
No. To initiate action, 156(3) application was allowed, FIR was lodged. Now, Your Lordship will kindly see page. I requested the bank several times that why have you, give me a reason that why have you.
Show me the reason.
Yes, the reason Your Lordship will find at page 57.
Yes.
I requested the bank several times and made several representations. Let me know why have you debit freeze my savings account. It's not the partnership firm's account. It's my savings account. So they say on page 57, this is their only communication.
What is the meaning of this?
The only reason perhaps.
What is the meaning of this? Set hold from SMCC?
Yes, with reference to a letter number nil dated such and such relating to account number. This is a savings account. We would like to inform you that the captioned account has been set hold from SMECC. SMECC, Your Lordship, is Small Medium Enterprise Credit Center, Kolkata branch, the Strand Road office, the head office. On 22nd May 2023. In view of the above, we request you to kindly take up the matter with our SMECC. I visited the SMECC. No reason, no written communication whatsoever has been served on me as to why my savings account.
SMCC is a party here.
SMECC is a party, the head office is a party, the Deshopriya Park branch is a party, the Tollygunge PX is a party.
Right.
Now,
so let me hear their justification.
Yes.
Let me hear their justification.
Only one thing I would like to, one thing just before
Yes.
I learn a senior make submission. Even if there is a loan,
even if an arbitration is pending, that is the partnership firm's account. That is not my
So if you're
saving.
a guarantor, it
Yes.
extends to your.
But for that, an investigation is pending by the Tollingage police station
How can the writ court interfere then?
because my signature.
If you're a guarantor, it's an allegation you are a guarantor, you challenge the signature. But if that is
Yes.
sub judice, the writ court cannot interfere.
But
You have
for-
to go before the appropriate authority. Let us see whether there is any appropriate order from any authorities to justify theirs.
But only one thing is how can the bank debit freeze my savings account and my fixed deposits? I could
They
have-
will say the how. Let them tell. Yes, you are for the SMECC.
I am for the state respondents.
SMECC is covered by state.
No. The SMECC is the bank, state bank's branch.
Your one. So what is your answer?
Lordship, the entire fact has
Please
not
take
been
your
told.
seat. Yes.
Kindly, my lord, takes page 42 of the application. Lord, it is his letter. Only, my lord, the last portion of the paragraph of the letter I read. That in such circumstances, kindly freeze the accounts where my name is shared along with Ajay Kumar Thanvi with immediate effect.
Who wrote this? He
Lord,
wrote.
this is the petitioner.
Acha.
Lord, he himself requested the bank to freeze my account. Lord, there is a dispute in the partnership firm. He resigned from the business. Lord, the partnership firm.
This is the partnership account.
Lord, this
Niranjan
letter.
Avenue is a partnership.
Yes. Lord, that may be, but he is one of the partner. He himself has requested the bank to freeze my account.
Freeze is that
Partnership
account.
No, Lord, there are
Don't get excited. Take your seat.
there are other accounts.
Personally cannot do anything.
Lord, there are other accounts also. Now, my lord, in 2010, he was sanctioned. The partnership firm was sanctioned.
This is an entirely different concept. He wanted the freezing of the partnership account. You will act on that or not act on that. That is your prerogative. You do that.
Yes.
But why freeze his account? That is my question.
Lordship, kindly sees, my lord, there is a loan of in 2010, which was subsequently renewed in 2023, 22 and 23. You know, there, my lord, the outstanding amount is around 60 lakhs and odd.
Who took the loan? Partnership or
The
him?
partnership firm, he was a guarantor there.
In that loan?
Yes.
Have you got
lordship,
that loan
lordship,
document?
Kindly, my lord, let's take that thing.
Stapler দাও। আর একটু গল্প না করে ওদিকে দাও।
My lord, it is very, because
আমি খাবো ওটা। দাও। Give a copy to them also.
I will certainly, my lord.
Certainly means you don't have.
My lord, I do not have right now, my lord.
So these are similar.
My lord, your lordship will sign the signature at the bottom. There he signs that as a partner.
Yes.
Kamal Kumar Ganguly.
This was 2020.
At 20, my lord, one is 2010
No.
and
How do I get that he's a guarantor? I mean, you say it's personal because it's partnership. He's a partner, coextensive.
yes, another, my lord, there is 171 of the Contract Act. The banker's lien. That is there, my lord. My lord, banker's
You mean
lien.
to say the money is goods bailed to you?
Lordship, if the
Money is not bailed.
my lord, if the account, one of the account turns to be NPA, my lord, the one which was your lordship was dealing with the last one.
Same principle applies.
My lord, same principle will lie. Here, my lord, what has
This is regarding bail.
my lord, here what will happen? Here happen is, my lord, he has taken a loan. The partnership firm has taken a loan. The partnership firm has dissolved.
Get an order of recovery from a court
Lord,
of law.
that we are doing. Lord, we have only put a hold on these FDs. Lord, he is not entitled to take
You
that.
don't have a banker's lien on money.
Lord,
The general
that's it.
banker's lien, please see 171.
Lord,
Without 171.
When 171 says the general lien of bankers, factors, what means attorney and public brokers. Bankers, factors, what means attorneys of high court and policy brokers may, in the absence of a contract to the contrary, retain as a security for a general balance of account any goods bailed to them, but no other person have right to retain as a security for such balance.
This is not a security, not something which has been kept by them as security.
My lord, the FDs are, my lord, we are
Lien on money.
my lord, lien on money, my lord, here, my lord, it says, my lord, in a syndicate bank judgment, it says a banker's lien on negotiable securities has been judicially defined as implied pledge.
Yes.
Now, my lord, if
Quote from syndicate bank itself, the same book.
no, my lord, if my lord, if he has a loan whether there is no security, now there is a dispute between the partners, the bank will be at loss, my lord, if I do not freeze that account. my lord, after my lord,
To file a appropriate suit.
that we are doing, my lord, that we are
Do
doing.
that, get an order there, then you cannot freeze his account.
Lord, if I do not freeze, my lord, he will.
Bank cannot become a court of law. They think nowadays that they are courts of law, but they are.
But my lord, if your lordship kindly takes page 42, its own letter. My lord, he cannot run away.
42 is getting a different account.
Lord,
He can very well run away. He can jog. He can
Lord,
walk on a treadmill. He can do whatever.
There he is a partner of that firm. Now, my lord, he is resigned from that partnership firm. That partnership firm has defunct. Now, bro, we cannot
He has
get
resigned long back in 20.
that we were not informed.
What can be done? You cannot hold his account, his personal account like this. You are not a court of law.
But I am not.
You can apply for a court, an order of court, or before any forum, any legal forum. Yes, put an order of attachment. You did not do that for so long. You chose an oblique fashion. That's why they'll win this writ petition.
We have a right to hold below the lien. We have a right. We are not.
I'll explain this to you.
Lordship.
In my order.
We are not.
In my order.
Lord, we are not taking away the money. It is on the hold. Lord, whoever tomorrow.
You're looking at the color of the money. You're not taking away the money. Bank is not returning the money. You're not taking away the money. It has been invested somewhere else.
No, Lord, it has not.
Notionally, it has to be.
Wait,
Otherwise, you're not a bank
that,
at all.
That is it. That has to.
Anyway, the petitioner has challenged the withholding, the freezing of an account of the petitioner. Where is this branch situated?
Deshopriya branch. State Bank of India,
At the Deshopriya Park branch of the State Bank. First up, it is contended that the petitioner was a partner in a partnership firm, but had resigned from the same on June 30, 2020. First up, next para. The said resignation was accepted according to the petitioner on January 18, 2021. First up. However, subsequently in December 2022, an amount of rupees 1,47,615 was deducted by the bank from the petitioner. First up, they have frozen your account now.
The savings account has
After this 1,47,000 deduction,
yes.
so 1,47,000 you'll have to recover from them. But the present freezing I'll reopen.
He is also not a
savings bank account has been frozen and 4 fixed deposits have been put on hold.
What's the next para? It is submitted that the savings bank account standing personally in the name of the petitioner has been frozen, and 3 fixed deposits.
4.
And 4 fixed deposits of the petitioners have been put on hold. First up, next para. It is argued that no prior notice for the same was given to the petitioner. First up, next para. Learned counsel for the bank argues that the bank has a general lien under section 171 of the Indian Contract Act 1872. First up, it is submitted that the petitioner himself, by a letter as annexed at page 42 of the writ petition, had sought for a freezing of the account of the partnership firm. First up, next para. Since the bank has substantial claims against the partnership firm, of which the petitioner was admittedly a partner, it is argued that the bank is entitled to put a freeze on the accounts and fixed deposits of the petitioner. First up, next para. A perusal of section 171 of the Indian Contract Act shows that it pertains to general lien of bankers, factors, wharfingers, attorneys and policy brokers. First up, next para. It is provided therein that the entities as indicated above, including bankers, in the absence in the absence of a contract to the contrary, retain as a security for a general balance of account, any goods bailed to them, but no other persons have a right to retain as a security for such balance, goods bailed to them, unless there is an express contract to that effect. First up, next para. Section 171 of the Contract Act pertains to special contracts and falls within chapter Roman 8, which relates to indemnity and guarantee. First up, next para. The concept of general lien applies to goods retained as security, comma, and refers specifically to goods bailed, B-I-L-E-D, within double inverted, to the banks. Full stop, next para. The money lying in the account of the petitioner, comma, that too in his personal account and not that of the partnership firm, comma, cannot be deemed to be a bailed good. Full stop, next para. Learned counsel for the bank sought to rely on Syndicate Bank versus Vijay Kumar, reported at AIN 1992 SC 1066, where it was held that in marketized system, the bank has a general lien over all forms of securities or negotiable instruments deposited by or on behalf of the petitioner of the customers in the ordinary course of banking business. Full stop, next para. In the present case, comma, the account of the petitioner has been frozen by the bank, comma, which does not come within the category of security. Full stop. At best, comma, the bank could argue that the fixed deposits of the petitioner were frozen by them in adjustment of proceeds regarding dues to the bank. Full stop, next para. However, comma, since the petitioner disputes that the petitioner is still a partner in the partnership firm, comma, it is at best arguable, comma, whether the petitioner has any liability as a partner or as a guarantor with regard to dues of the partnership firm to the bank, comma, for the bank to freeze the fixed deposit accounts held by the petitioner in his personal name. Full stop, next para. The remedy of the bank does not lie in section 171, but in an appropriate proceeding before an appropriate legal forum, comma, where the bank is in any event at liberty to ask for specific reliefs. Full stop, next para. However, comma, the mode in which the bank has operated, comma, freezing unilaterally the fixed deposits and the running account of the petitioner held in his name personally, comma, is has to be deprecated. Full stop. The said act has also been done without prior notice to the petitioner, comma, which shows that the petitioner has every right to assail such unilateral action of the bank. Full stop. In such view of the matter, comma, WPA 20613 of 2023 is allowed, comma, thereby directing the bank to immediately defreeze the account held by the petitioner in his own name with the Deshopriyo Park branch of the respondent bank, as well as to defreeze the fixed deposits of the petitioner, comma, held in the personal name of the petitioner, comma, also with the respondent bank. Full stop. Such defreezing shall be done by the respondent bank latest within 1 week from date. Full stop. It is, comma, however, comma, made clear that it will be open to the bank to apply before the appropriate legal forum for appropriate remedy against the petitioner, comma, if the bank is of the perception that the petitioner has any liability towards the bank, comma, in any capacity pertaining to the partnership firm in question. Full stop. Nothing in this order shall prevent the bank from doing so. No orders to cause such a circumstance.
I'm great, fine. Lordship wanted to see the guarantee agreement. I have the guarantee agreement.
No, because you have not given any notice. Ask for orders before the appropriate.
Lordship.
They were guarantors
They were
of that loan
guarantors.
also. You have got a claim. Make a claim before any authority. Pray for interim orders there. You can do it within a week also.
I'm grateful. Grateful.
Please take back these. I have not referred to this, so this will be necessary in the next.
Item 6.
6.
My lord, I am appearing for the writ petitioner in this matter.
Yes.
My lord, I am being led by Mr. Anirban Ray. My lord, he is not well today, so he could not come.
No adjournment in top upgraded matters, so it goes down in the list. You have to move the matter. This is a top matter.
My lord,
the matters are being not being added because of these matters.
My lord, can I just ask for a short passover in this?
No, you have to start the matter. Unless you start the matter, I'll put it down the list.
My lord, I'm seeking an adjournment just for a day.
An
my lord.
adjournment is sought by the petitioner, full stop, next para. Since the matter is appearing under the heading top, comma, depriving other matters which are equally urgent, comma, let the same go down in the list and be listed tomorrow, listed day after tomorrow, in the normal course. এটা টপে থাকবে না। Next.
Yeah.
Electricity matter, item 8.
Yes, Ms. Halder.
Last occasion, Malar is submitted.
The report was filed.
Sahara report
Yes.
was here.
What does the report say?
Report say that the premises is the only place
Oh, you wanted shifting of a transformer?
transform from my house to the just opposite of my premises on the road.
It says it is completely segregated from your house.
No,
The report says it is complete. The transformer is completely segregated from the petitioner's house.
that
And
is
all the
the-
four corners are covered with walls.
My lord, that is not the Malar. Kindly see the picture.
Page 25.
Page 25 is the picture.
Yes.
This is not segregated, my lord.
Pink one is your house, purple.
Yes, 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 yes.
It
Just
is it is walled and segregated.
it is
It has to be
like-
situated somewhere, sir.
No, no, this is the, I went there. Let it be, Mala, decide by the district magistrate. Mala, it will help us. Mala, others, my lord, just in front of my house, there is a
Very well.
corner plot.
The petitioner, none appears for the CAC Limited at the time of call, full stop. It transpires from the report filed by the CAC Limited on the last occasion when the matter was taken up, that the transformer in question is situated, comma, according to the CAC Limited, comma, in a technically suitable position and is completely segregated from the petitioner's house and in a safe position. Full stop. Learned counsel for the petitioner, comma, however, comma, relies on the photographs annexed to the writ petition and reiterates that the transformer is situated immediately adjacent to the wall of the petitioner's property. Full stop. Accordingly, the same is dangerous. Full stop. Next para. Since a dispute on factual premise has arisen in that regard, comma, the matter is required to be adjudicated by the district magistrate concerned. Accordingly, WPS 16079 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned district magistrate with the grievance as iterated herein. Full stop. If so approached, comma, the district magistrate shall decide the issue in accordance with law as expeditiously as possible, comma, positively within 6 weeks from the date of such approach being made by the petitioner. This court has not entered into the factual merits of the respective contentions of the parties. None appears for the CAC Limited.
I'm sorry, extremely sorry. I wasn't there court number.
Item 9.
But I pay for the petition.
I'm for the limited.
My lord, tenant in respect of the premises, my lord, this lady had a cardiac ailment. She had undergone a bypass surgery. My lord, landlord disconnected the line. She applied for a new
Supplied
connection.
properly,
My
landlord.
lord, yes, yes,
I mean,
delivered,
served properly.
delivered.
Landlord.
No, my lord, my lord,
I
thereafter,
thought the
CSC, my lord, went to install the, my lord, meter. It is only because of the objection of the landlord, CSC was.
What do you say? You are agreeable?
My lord, according to that application letter, we went for the inspection, and after
Without reading it, without reading it.
Just read it. I'm taking the date, I'm reading the date. We went for the inspection of the said.
You are agreeable or not?
Yes, we are agreeable, but the private respondent gave us the inherent.
Not the entire thing. Please stop. Yes.
But the private respondent did not disconnect them. What happens here, my lord?
Let her get this line. This line.
There was an electricity connection. They did not pay the, my lord, amount for which it has been disconnected by the authority itself. My lord, let them pay the outstanding and let that particular line be disconnected, reconnected, my lord.
Not a proper mode.
Lord, you will kindly see this bill once. Because
Learned counsel for
My
the
lord,
petitioner.
One thing, my
argues
lord, our
resale,
representative.
breaking padlock.
My lord.
That's why I told you to stop. I know what it is.
Concerned police station has given one report.
Please file it. Learned counsel for the petitioner contends that the petitioner is a tenant in respect of the property in question and has survived a cardiac arrest. Full stop. The ailing petitioner sought an electricity connection as a tenant of the property in her own name, but the same could not be given by the CAC Limited due to objection of the respondent number 4 stroke landlord. Full stop. Next para, learned counsel for the CAC Limited submits that the CAC Limited went to give in such connection, but was prevented by the private respondent, for which the CAC personnel require police assistance to give such connection, comma, if so directed. Full stop. Next para. Learned counsel appearing for the respondent number 4 submits that the petitioner is incorrect in submitting that the respondent number 4 disconnected her electricity supply. Full stop. It is contended that the petitioner was duty bound due to her dual relationship with the landlord, comma, to pay the electricity charges. Full stop. In default of such payments by the petitioner herself, comma, the electricity could not be paid for and was disconnected. Full stop. Learned counsel for the respondent number 4 submits that the landlord is agreeable to reconnect such supply to the petitioner in the event the petitioner pays her dues to the landlord. Full stop. Next para. The mode which has been resorted to by the landlord, comma, as it transpires from the submission of parties, comma, is not sanctioned by law. Full stop. In the event the landlord seeks to oust the petitioner or to exact the landlord apostrophe's claims of alleged dues from the tenant, comma, the landlord has several recourses in law. Full stop. However, comma, forcible disconnection of electricity supply to the tenant is not a legally acceptable option. Full stop. In any event, comma, even if the landlord has chosen to do so, comma, the petitioner as a tenant and occupant, comma, is entitled to get her own electricity connection. Full stop. Accordingly, WPA 18381 of 2021 is allowed, comma, thereby directing the CAC Limited to give electricity connection to the petitioner within a fortnight from date in her own name, subject to compliance of formalities by the petitioner. Full stop. Next para. It is made clear that if the CAC personnel are obstructed in doing so, comma, it will be open to them to approach respondent 3, the officer in charge of the Gorfa police station, who will act on a server copy of this order and give such connection, such assistance to the CAC, comma, if need be, comma, breaking open any padlock or other hindrance in the process. Full stop. Next para. It is, comma, however, comma, made clear that nothing in this order or the connection, comma, as and when given to the petitioner, comma, shall create any special right or equity in favor of the petitioner, which she does not otherwise have in law. Full stop. Moreover, comma, such electricity connection shall be without prejudice to the rights of the respondent number 4 stroke landlord to assert his claims in all regards, comma, in the capacity of landlord, comma, against the petitioner, comma, before an appropriate forum. Full stop. No address to cause.
18381 of 2023. It has gone down as 2021.
Oh, that's
And my lord, only one thing, my lord.
18381 of 2021.
But 23.
21 is the caption written here.
First page when it is there, wrong there in the.
It's a wrong print.
Wrong
Acha, 2023.
Great.
Thank you.
My lord, only one thing, my lord, lordship.
Acha, arekta line add kore daw. The report filed by the state be kept on record. Yes.
My lord, lordship has recorded that I disconnected, my lord. I never disconnected. It is the my lord, respondent, my lord, electricity authority who disconnected the line. I never, my lord. She would kindly record this because this has been, my lord,
That question. Learned counsel for the respondent for ki boleche she can jagah take.
My lord, we did not disconnect the line, my lord. What is your document? We have disconnected the line.
my lord, this is the document that they have.
We have not disconnected the line. We are
Legally fight out between yourselves outside court.
My lord.
Mr. Das will be the referee. Bolo ekটু khanda.
We have not disconnected.
You me বলছো করেন না
Due to her usual address. No, I haven't said you have disconnected.
Lordship,
Was disconnected.
My lord has said that this is the my lord, recourse that the private respondent has taken, my lord, is not supported.
Oh, acha, that.
Well, I never, my lord, because the lady, my lord, who was the my lord, private respondent.
Anyway, whatever I've held.
She has, my lord,
No.
83 years of age, my lord.
Very well.
The lordship will kindly, my lord.
Who is 83 years?
The private.
Maybe,
respondent,
maybe.
the real landowner who passed away in this meantime.
Next matter, please. Yes. Wait.
Item 10.
Yes.
May it please the lordship, I am for the petition. My lord, I have served the private respondent and
Certain
applic-
feasibility.
Yes, I have, on the previous day before yesterday, we, my lord gave the order, and according to my lord's order, we have given the objection letter given by the private
Yesterday.
respondent. to
The
the
possession is
petition.
disputed.
Possession is not disputed.
No, you purchase the property, possession, you are a third party, and section 44 of TP Act goes against you.
My lord,
Let it be decided by the
case is pending, one case. and
Suit.
Mutation.
Suit or case.
Suit.
Who has filed the suit?
Private respondent. I have
I am
some
the
copy.
respondent number 4.
Yes, what is the, you have obtained an injunction order in the suit?
No injunction, nothing.
Is not received. Milord, the matter
Only
is
pending,
very,
next
it
date
is
is
a dwelling house
6th March.
and there was one partition suit. It is still pending. There is a
Partition suit filed by you,
filed by the
other co-owners.
by the owners.
They are not a party there.
They are not the party.
During pendency, they purchased.
During the pendency that purchase and also the particular by dint of a gift deed, they have purchased the property. That gift deed was allowed by the lower court and then it has gone to the appellate court and that is also pending there. In the meantime, they have purchased this property. The title deed.
Not purchased, got by gift. You said.
No.
There was a gift deed also.
There are also gift deed. The gift deed, the vendor from whom they purchased the property, the vendor by virtue of a gift deed sold out the property.
Very well.
And that gift deed was challenged in the lower court. We were defeated. Then this was
Appeal, pending in the appeal.
that pending is there. And on the basis of that, apart from that, the section 44 of the Transfer of Property Act, and also we have challenged the matter before the court.
Say they are not in possession at all.
They are not in possession. They are the trespasser. They are trying.
Trespasser is in possession.
No, actually, what happened?
Have they entered into possession as a
Yes, they have-
trespasser?
No, Milord, I will not misguide the honorable court. Milord, the matter is that they have taken all sorts of.
Mutation is there, my lord. I am in.
The mutation cannot establish the right title interest. The possession. Section 44 says that in a dwelling house, the third party who is not the member of the family cannot jointly possess it. And apart from that, there are already existing 4 meters. There are existing 4 meters. And the room.
Which portion was sold to them?
The deed is very different one.
They are in possession of which portion? They have entered illegally
But
to which portion?
they are entering illegally. They are entering into the first floor, and there is also meter. There is also light, and they apart from that, this is a dwelling house. But they have applied for the.
So this will be without prejudice to their rights, but
Fine.
to your rights. But they are entitled to electricity even as
There
illegal.
is there. The electricity is there. My lord, what is my?
I'll make it clear. This will not create any right in their favor, and
Fine.
without prejudice to your rights in the suit.
No.
That has to be.
There has to be.
My lord-
I am not telling all these things. What I am telling that they are asking for the urgency. What is the urgency? There is no electric supply. But I am telling that they are.
I'll direct the CSC Limited to disconnect your client's electricity supply. You don't understand that.
No, I am not disconnected it.
They're not getting it at all.
They are getting. There are 4 meters and
Achha, you say that they're already enjoying from the existing.
from that particular meters.
Have you asked for a transfer of your vendor's name to your?
They are gone for the commercial meter. It is.
Well, I'll take care of that.
My lord, one thing, my lord, we are unable to inspect the said meter because the private.
I won't
respondent-
allow you to inspect.
No, sir, mine, sir.
Without inspecting, you'll have to give them. Learned counsel for the petitioner submits that the petitioner is a purchaser of a portion of the property in question and seeks an electricity connection there, which cannot be given due to obstruction by the private respondents. Full stop, next para. Learned counsel for the private respondent contends that the private respondent has challenged a gift deed, executed by one of the co-owners of the property in favor of the vendor of the petitioner. Full stop. Upon such challenge having failed before the first court, an appeal is now pending at the behest of the private respondent before the appellate court. Full stop, next para. It is submitted that as such, the purchase by the petitioner from his vendor is itself suspect and sub judice. Full stop. Next para. It is further contended that Section 44 of the Transfer of Property Act debars the petitioner, being a stranger, from entering into this is a total dwelling house, entering into a dwelling house by operation of law. Full stop. As such, the petitioner is not entitled to have an electricity connection in the petitioner's own name. Full stop. Learned counsel for the private respondent further argues that there is no urgency for the petitioner to have an electricity connection in its own name, since there is already existing electricity connection at the disputed property. Full stop. Next para. Learned counsel for the CSC Limited submits that the CSC Limited is required to hold an inspection prior to giving a quotation to the petitioner. Full stop. Next para. It transpires that although the legality of the petitioner's possession of the property is squarely disputed by private respondent, the petitioner is in occupation of a portion of the property, be such occupation lawful or unlawful in the eye of law. Full stop. Next para. It is well settled that a person in settled possession is entitled to electricity under Section 43 of the Electricity Act 2003. Full stop. Next para. Needless to say, such connection cannot create any special right or equity in favor of the petitioner and or prejudice the contentions of the private respondent in any court of law in any manner whatsoever. Full stop. However, the petitioner as an occupant is entitled to get electricity, if otherwise the petitioner complies with such due formalities. Full stop. Next para. Accordingly, WPA 19368 of 2023 is disposed of by directing the CSC Limited to hold an inspection for the purpose of ascertaining the feasibility of giving an independent connection to the petitioner at the premises in question within a week from date. Full stop. The CSC Limited shall, if it is so feasible, raise an estimate within a week thereafter and issue a quotation to the petitioner. Subsequently, the petitioner shall comply with all due formalities, and within 2 weeks, within a fortnight from such compliance, the CSC Limited shall give electricity connection to the petitioner at the premises. Full stop. On either occasion, at the time of inspection or at the time of giving connection to the petitioner, if the CSC's personnel face any hindrance from the respondent of 4 and or his men and agents, it will be open to the CSC to approach respondent number 3, the officer in charge of the Behala police station, who will act on a server copy of the order and give adequate police assistance to the CSC Limited at the cost of the petitioner, if need be, by breaking open any padlock or other hindrance to give such access to the CSC personnel. On both such occasions. Full stop. Next para. It is, however, reiterated that the said connection, when given to the petitioner, or anything in this order shall not create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have in law, or legalize the occupation of the petitioner. Full stop. The connection shall be without prejudice to the rights and contentions of the private parties in any pending or to be filed a hyphenated legal proceeding before any court of law. No arrest to cause.
Matter item 11.
Lordship, I am for your petitioner.
Right.
Lordship, yesterday when the matter was called on, my learned friend appearing on behalf of the respondent number 1 and 2 informed that there was a previous writ petition filed by the same petitioner. And Lordship advised me to consult with my client, and Lordship, my client instruction is that she does not want.
Please take the microphone just here. She does not.
She does not want to proceed with the matter filed in the year 2020. And she only wants to continue with the instant matter. And Lordship, she already has engaged my learned friend and given him a letter.
Yes.
This is the letter, my lord.
Keep it with you. Yes. So that says that you're not to proceed with that other matter.
Yes.
I'll record that in this order also.
Lordship.
Very well. Get that matter dismissed for non-prosecution. In the meantime, I'll hear this then.
Lordship.
Mr. Palchudar will hear this then. I'll record that they are not proceeding with that.
Lordship.
Yeah, what is the matter?
Lordship, in this instant matter, the grievance is that petitioner.
Give a copy. This is an extra copy, that instruction. Yes. They hand it over. I'll keep it on record. Let me pass an order on this and then I'll take up the immediately now.
Lordship.
Learned counsel for the petitioner, on instruction, submits that although a similar writ petition was preferred subsequently, being WPA 3620 of 2020, the petitioner does not want to proceed any further with the said matter and chooses to move the present writ petition. Full stop. A copy of a written instruction in that regard is also handed over in court today and kept on record. Full stop. On such undertaking of the petitioner not to proceed with the other matter and to have WPA 3620 of 2020 dismissed for non-prosecution, irrespective of the outcome of the present writ petition, the present writ petition is being taken up for hearing. Full stop.
Grateful, Lordship.
So even if you lose here, you won't be able to revive that
Lordship,
again.
Lordship.
That I've made
Lordship.
that clear.
Lordship.
Move the matter. Yes.
Lordship, this instant writ petition is against the information sought from the bank and post office. Lordship, your petitioner and the respondent number 5 is the mother and daughter, and respondent number 6 is the sister of your petitioner. Lordship, the father of your petitioner died in the year 2017. And after the death of your petitioner's father, being one of the legal heirs, your petitioner moved an application under the RTI Act before the State Bank and the post office, seeking information of the fixed deposits and lockers and etc. from the two authorities concerned. And Lordship, these RTI applications were filed by your petitioner in the year 2019. And Lordship, post office gave some answers that some of the fixed deposits have been withdrawn and some of the fixed deposits have been transferred from Howrah to Bengaluru. And Lordship, the State Bank answered that your petitioner is not a legal heir. And Lordship, in the year 2023, again, your petitioner applied again to the State Bank, given some documents to prove that she is also one of the legal heirs of her father. And Lordship, I have filed the letter and their answers in the form of a supplementary affidavit.
Copy?
Lordship. No, copy. আপনার জুনিয়র নিতে ডিনাই করেছে আমি কপি সার্ভ করেছিলাম গেছিলাম
If you have the receipt, hand it over to me. I'll keep that on. Yes.
আমার কাছে এক্সট্রা কপি আছে এই তো কপি
What does it disclose here?
Lordship, here kindly come to Lordship page number 13 of my supplementary affidavit. Lordship, post office replied that their contention is the same what they replied in the year 2019. And Lordship, kindly come to page 14, the reply of the State Bank. The State Bank is seeking the account number of my father from me. Lordship, my prayer before your Lordship is that if I have the account number and locker number with me, so what is the necessity of my application before the State Bank of India? Lordship, my simple prayer before your Lordship, kindly pass and direction upon the post office and State Bank to disclose all the financial assets.
Post office has already done.
Post office has already done, Lordship, but I need the current latest information, whether the fixed deposits have withdrawn or not. And Lordship, the State Bank will also disclose the lockers and fixed deposit, if any, What have?
No, post office, postal authorities have already disclosed. State Bank will come.
Disclose, Lordship, but Lordship,
You have to take steps now according to that.
Lordship, then Lordship kindly pass an order upon the State Bank.
State Bank, what is your stand on this?
Yes, my lord, he filed application in the year 2019 on 20th April 2019. And thereafter first CPIO refused, and thereafter he filed appeal. And appeal authority has directed the authority to disclose all these things. And accordingly, this disclosed. Kindly see that. Kindly see her application and my reply to that. Ultimate reply to that.
Give copies to him.
First letter is his application, and last letter is their bank's reply. It was done in 2020.
They've given the account numbers, so take steps. I'll dispose of the writ petition by keeping these on record.
Lordship,
Account numbers have been disclosed by them.
Yes. And he has.
You have got copies of these documents, right?
no, Lordship.
Give copies to them.
My lord, there is a dispute between mother and daughter. Mother already.
That is some other dispute, not this.
My lord, she is already.
Yes, what do you say? Have you looked through those?
Her mother.
Have you got the 23rd March?
Lordship, then we shall act accordingly.
Yes. What about mother, sister?
Mother has already, my lord, I have.
You are for which performer, which respondent?
I am for the postal department, man. My lord has, mother has already disclosed her unwillingness to disclose the ID, regarding the facts of the account to the petitioner. My lord. I have that instruction.
Mother doesn't have any right to do that. You don't need to act on the behalf of the mother. Everybody, every legal heir has a right to know. You are the postal authority. You have not yet disclosed. Let us see your answer. Where is their answer?
Lordship, their answer is
Page.
Lordship, page 16 of my writ petition.
Why didn't you give the 1 and 2 informations? Due to mother's objection.
Yes.
But you otherwise have the information.
That instruction I don't have right now. My lord. Then I have.
You are appearing in them, but you don't have instruction.
Well, I have the.
This is a basic instruction you should have.
Whether that information is lying with them or not, because there was another respondent, my lord.
Learned counsel for the petitioner submits. Oh, ready. Learned counsel for the petitioner submits that the petitioner is the daughter of the deceased, daughter of late Sunil Chandra Mukherjee.
Lordship.
Full stop, next para. The respondent number 5 is the widow of the said deceased, and respondent number 6 is one of the other daughters, one of his other daughters. Full stop. The petitioner approached the respondent authorities, comma, being the postal authorities as well as the respondent bank, comma, for appropriate appropriate information regarding all bank accounts held by the deceased father of the petitioner. Full stop. However, comma, having met with inaction on the part of the authorities, comma, the petitioner had to take out an appeal. Full stop, next para. Till date, comma, appropriate information has not been disclosed, comma, it is argued. Full stop, next para. Learned counsel for the bank submits that the matter went up to the appellate forum, and ultimately the respondent bank, that is the State Bank of India, had duly furnished information regarding the accounts held by the petitioner's deceased father with the bank. Full stop. Learned counsel hands over a photocopy of a communication dated March 23, 2020, comma, by which purportedly such communication was made to the petitioner. Full stop. It is seen from the same that the accounts of the petitioner's deceased father are disclosed therein. Full stop. Next para. Learned counsel for the postal authorities submits that information could not be furnished due to objection on the part of the respondent number 5, that is the mother of the petitioner and the widow of the said deceased. Full stop, next para. However, comma, the one of the heirs, that is the widow of the deceased account holder, comma, is not entitled in law to instruct that even information regarding the accounts or other assets of the deceased shall not be furnished to the daughter, who is one of the other legal heirs. Full stop, next para. Hence, comma, the said ground of refusal on the part of the postal authorities is not justified in law. Full stop. It transpires from the annexure A2 at page 16 of the writ petition that although some information was furnished by the postal authorities, comma, as to query numbers 1 and 2 of the petitioner as appearing in the said annexure, comma, no information was alleged to be available with the postal authorities. Full stop, be that as it may, comma, since the postal authorities now take a different ground of objection, comma, it is the bounden duty of the postal authorities to ascertain as to whether any other information is actually available with the postal authorities, and comma, if so, comma, to furnish the same to the petitioner. Full stop, mere furnishing of information does not create any right in the property, and comma, as such, comma, the respondent number 5 has no locus standi to object to the same being furnished to the petitioner. Full stop, next para. Accordingly, WP 18965W of 2019 is disposed of by directing the respondent numbers 1 and 2 to furnish all available information, comma, if not already furnished, comma, regarding the securities stroke accounts, comma, any other assets held in the name of the deceased father of the petitioner, late Sunil Chandra Mukherjee, comma, by a written communication to the petitioner, comma, positively within 4 weeks from date, full stop. Insofar as the bank is concerned, comma, since the learned advocate for the bank has handed over copies of details regarding the accounts held by the deceased with the said bank, comma, a copy of which has also been served on the learned advocate for the petitioner, comma, the same would suffice. Full stop, next para. The petitioner will be at liberty to take appropriate legal steps, comma, if the petitioner so desires, comma, in accordance with law, comma, with the information so furnished to her. No rest to cause urgency.
The self-same government at 3620 of 20.
You entered late. Mr. Palchudhir, please appraise him. Selling on the same boat. They will withdraw that. I've recorded and kept their instruction on record. They'll have to have it dismissed for non-prosecution. But please take care of that, the other matter. Do I have jurisdiction?
Yes. Lordship has jurisdiction.
Acha, give us, make a formal slip. It to be mentioned.
Lordship.
Give a formal slip so that it appears and I'll show me this order and I'll dismiss. Thank you.
Item 12.
Item 12, my lord, I am placing, my lord, a peculiar case, my lord, where petitioner who is a practicing advocate has been denied of, my lord, domestic connection for his chamber on a very flimsy and arbitrary grounds. That is my case.
What is the ground?
Flimsy, my lord, grounds, my lord, kindly come to, my lord. I have, in the meantime, my lord, it is need to say, I have already deposited the fees. They have carried on inspection. Now, my lord, kindly come. Annexure P3 45 page.
My lord need not look into all these documents. Already he is enjoying connection in his name in the premises.
My lord, please. My lord, I have purchased the flat, first floor, in first floor. My lord, I have chamber in the ground floor. Now, my lord, I have already all stated in my petition. I have, my lord, connection in the name for the first floor. But what I submitted just before, my lord, I want domestic connection for my chamber. Now, my lord, kindly come to their, my lord, rejection order. May I read, my lord? Subject, rejection or dated, my lord, 24th June 2019. Subject and reference to the above, the undersigned would like to inform you that we have received your application for new domestic service connection at the.
Splitting of load. Yes, yes.
My lord,
Splitting of load. Yes.
splitting of load.
Right.
My lord, that means, my lord, kindly suppose, my lord, for sake of argument, if I have two flats in the same building, my lord, in one flat, I have the only person of the family. My lord, I have a electric connection for the one room, and my lord, why I want to take another connection in my name for another. My lord, can I not get, my lord?
You
My lord,
can't.
kindly consider, my lord.
You can't. I'll give you liberty to approach the GRO. Grievance redressal officer.
My lord, in this
Tell the
connection, I want
grievance
to submit
redressal
one-
officer you are a lawyer, then
Yes,
may
my lord.
help there.
My lord,
But not
may I,
before
may I submit?
Ombudsman.
We have approached the consumer forum. Consumer forum.
Does not have. Anyway, what did they say?
It is,
What did they say? What did it say?
Consumer forum uphold, my lord, our order in our favor to direct the, my lord, authority to supply along with other orders. My lord, they have preferred, my lord, appeal before the state. State has, my lord, rejected. State, my lord, has overruled the order, set aside the order.
Take the connection, use your connection which you already have. That is standing in your own name.
How can I, my lord, unless the authority will,
No, we have no problem. He is enjoying electricity. Let him enhance his
You have electricity. You have a service connection.
my lord,
You have a service connection. This is another room in your house. Connect that.
then, my lord, kindly direct them to, my lord, bring connection from that room to my chamber.
Why will they do it? It's inside your premises.
That, my lord. Otherwise,
What?
I want, my lord, a separate meter, my lord, from same supply. Maybe my supply may be same, but I want, my lord, separate meter.
Learned
Kindly
counsel
consider.
for the petitioner submits that the petitioner is a practicing advocate and his practice is being hampered due to refusal by the WBSCDCL to give a new electricity connection for running the petitioner's advocate's chamber. Full stop, next para. It is submitted that although the petitioner has an existing connection at the premises, comma, he wants a separate meter to to cater to electricity supply to his chamber. Full stop, next para. It is argued that the petitioner has a right in law to get such separate connection and the refusal of the WBSCDCL is unjust and dehors the law. Full stop, the petitioner also approached the appropriate consumer forum and got an order there. Full stop, however, comma, in an appeal, comma, the said order was set aside.
Yes, my lord.
The said order was set aside. Full stop. Learned counsel appearing for the petitioner places reliance on the refusal letter of the WBSCDCL, which cites the ground of apprehended splitting of load. Full stop, next para. Learned counsel for the WBSCDCL submits that in law, comma, the WBSCDCL is entitled to give such objection. Full stop, in any event, comma, the petitioner is already enjoying an electricity connection in the same premises and there is no bar for the petitioner to use such connection for operating his chamber as well. Full stop, next para. Splitting of load is a valid ground under the regulations framed by the WBERC within the aegis of the Electricity Act 2003, comma, for refusing connection. Full stop, next para. It transpires from the facts of the present case that the said objection is valid in the present circumstances, comma, since the petitioner is already enjoying an electricity supply in his own name at the same premises where a new connection is sought. Full stop. Next para. There is no occasion for the petitioner to seek a new electricity connection, comma, metered or otherwise, comma, in the same premises to cater to merely another room in the premises where the petitioner notionally seeks to run a chamber. Full stop. There is no division for the purpose of consideration of the apprehension of splitting of load, comma, insofar as the user of a particular room as a chamber or for domestic purpose is concerned, comma, if the consumer is the same and the building is also the same. Full stop. Such being the case, comma, the apprehension of the WBSCDCL regarding splitting of load is perfectly justified. Full stop. The petitioner evidently seeks such connection merely to get an undue advantage from the WBSCDCL in reducing the electricity charges payable. Full stop. Hence, comma, the stand taken by the WBACTCL has the sanction of law. Full stop. Accordingly, WPA 19613 of 2019 is dismissed. Full stop. Can 1 of 2019 within bracket old number can 11909 of 2019 is also disposed of accordingly.
My lord, I want separate connection, separate
Won't get
meter,
it.
my lord.
Grateful.
And my lord, my chamber is, my lord, outside the, my lord, in common passages of the flat, my lord, of the building, my lord.
Aage dispose hole can tete hobe.
My lord, kindly record my chamber is, my lord, outside.
The matter is over. Thank you.
Item 13.
May it please, your lords. But I
Hearing
appear for the
35.
petitioner, which is a school in Patna.
Right.
My lord, petitioner number 2 is the principal of the school.
Yes.
If your lordships kindly see the earlier order passed by Justice Mantha, when I moved the motion, lordships asked me that school is in Patna, banks are in Patna, you want operation of the banking account, why in Calcutta?
Yes.
My lord,
Advocate is in Calcutta.
no.
Advocate
That-
also goes to Patna for matters. Yes.
My lord, division bench of Patna High Court, there is a civil litigation pending in Calcutta, in City Civil Court. Originally, the school was affiliated to Sadnasam Seva Sangsad, which is situated in Bidhan Saroni, Calcutta. And that is why civil suits are being instituted in City Civil Court. And in one of the order by the division bench Patna, ordered that anything related to school has to go to Calcutta. One has to go to Calcutta. And I have annexed that order. I'll come to later on. And that order is unchallenged. My lord, the Sadnasam Seva Sangsad then decided in his meeting that now it's difficult for them to look after the affairs from Calcutta to Patna. So a local body in Patna should look after the school, and thereafter the Bengali Association of Patna is looking after the school. Now there is a dispute between Bengali Association of Patna and Sadnasam is going on. Well, Sadnasam Seva Sangsad filed a suit in City Civil Court and obtained an ex parte order of injunction, injuncting the operation of 5 bank accounts. There are 6 5 accounts in of the school in Patna. Now that order has been vacated by the division bench of this honorable court by Justice I.P. Mukherjee's division bench. I'll come to that order, which says that operation of the bank account can be made by the petitioners, the school authority. Well, after that, we wrote to the bank that after this order, you should allow us to operate. State Bank of India has already allowed, but the Punjab National Bank and Bank of India, these are the 2 banks where my 5 accounts are there. They are not allowing. Now, Justice Mantha in his order, my lord, asked me to serve notice on these 2 banks and asked, and I have complied with that order. I believe my learned friends are appearing. My lord, if they don't have any objection, because they can't stand in my way because order has been vacated. Injunction order has been vacated. I have been allowed to operate the bank account.
Yes, take instruction. I'll.
May I just, my lord, I appear, my lord, for Bank of India, respond number 3 and 4. But I was not served with the entire set. Mr. Sinha has just now served me, my lord. I have to take instructions, my lord.
Okay.
I have just been served with the
What
entire.
about the PNB?
My lord, there was no specific instructions by that order referred by my learned
No,
senior
not.
friend that bank has to operate the account, my lord. The account was kept frozen from since the year of 2011, your lordship. Lordship, I have to seek instruction as to why the operation of the account was stopped. Since this operation has been stopped quite a long time back, I'll pray for a short period of time before your lordship, and I'll file my instructions on affidavit, your lordship.
Mr. Sinha, I'll keep it, give them 2 weeks for this.
Lordship.
I'll keep it at the top after 2
My
weeks.
lord.
So let us be, if we can thrash out from here,
My
let's
lord,
take instruction.
my lord, instruction is sufficient. I don't think affidavit is required.
No, no,
My
it's
lord,
not
bank
like
has
you can
no.
file written instruction. I
Lordship,
don't think also
Lordship.
affidavit is
My
required. File a written instruction just to save your backs. I
Lordship.
mean, so I'll keep it 2 weeks after.
Lordship.
Learned counsel for the petitioner submits that although there has been raised an objection as to territorial jurisdiction of this court, comma, there is an order of the division bench of the Patna High Court in the context of a suit of the petitioners, comma, whereby it was observed that all litigation connected to the petitioners shall be filed in Calcutta. Full stop. Be that as it may, comma, it is submitted that The present cause of action pertains to refusal by the respondent banks to defreeze an account, 5 accounts of the petitioners, which were initially frozen due to an injunction order passed by a civil court in Calcutta. Subsequently, the said order having been vacated by a division bench of this court, it is argued that the said amounts be defrozen, as such, even keeping open the point of maintainability of the writ petition here, since the writ petition may be disposed of with an innocuous observation, upon the banks taking appropriate instructions on the issue in contention, the matter is being entertained for such limited purpose, keeping open the issue of maintainability, territorial jurisdiction, maintainability, Learned counsel for both the banks seeks some further time to take instruction as to the reason for freezing of the accounts in question and as to whether the accounts may be defrozen in view of the submissions made by the petitioners. For such purpose, the matter is adjourned till September 26, 2023, September 27, 2023, when it will be listed at the top for passing appropriate orders. So please file written instructions. And Mr. Sinha, please have you disclosed this vacating order and all the details?
I have
writ petition
yes,
itself.
in the writ
So
petition.
please take instruction.
I'm grateful, Chair.
If it's possible, without going into this question of
Yes,
jurisdiction,
yes,
we'll just dispose of the writ.
Otherwise, my lord,
If it's
again,
there.
I have to bring my lord's judgment, India Power Corporation MP board.
No, then
recent
I like
judgment.
to rely on my judgment to say Patna High Court is binding on me.
Yes.
Because 226(2). Patna High Court is prior to
226(2),
my.
yes,
So
yes.
I am bound by that. Therefore, I mean, anyway, that would unnecessarily complicate situation. This is basically we have no territorial jurisdiction.
That's the view taken by
Calcutta
Justice
High Court
Mata
does not have territorial jurisdiction at all in this matter. So if they agree, then it can be.
I'm grateful, Chair.
Item 14.
14, yes. Yes, Mr. Van.
My lord, I am being told Mr. Galib along with Mr. K.M. Hussain is appearing in this matter on behalf of state respondents. My lord, I am seeking a short pass over. My lord, subject.
Yes, Mr. Banerjee.
Look, could I start?
My lord,
Because
Mr.
it will
Banerjee,
take some time. It's coming after a final hearing. So after
May I take up after coming back from Jalpaiguri? You are enjoying any interim order in this?
No, nothing, my lord. There's certain amount that had to be disbursed under a scheme. My future, along with future of candidates who we supposed to place, that's also in jeopardy here.
See, if there are short matters, I won't be.
So Passover might be difficult that I.
Passover is very difficult.
Could I come back on Friday then?
Friday come back, yes, I'll keep it in the list. Same position. An adjournment is sought by the respondent state. First up, let the matter stand adjourned for the day and shall be listed under the same heading on Friday, on 8th, September 8th.
Well, there is a lot of pressure on me to make a request. If it could be placed on the top and taken up on Friday.
Resist the pressure.
Very well.
In any event, it is fairly at the top. I mean, unless some other tops come. Yes.
I'll resist the pressure.
Yes. Next.
Oh,
15. My lord, in this matter, my lord,
This is
I'm
my
appearing
application.
on behalf of state respondents. I know in this matter, I am at the receiving end because there is a direction from the coordinate bench to file affidavit in opposition. Long back, I admit 7 months.
Receiving end, you are now on the paying end.
My lord,
You pay costs and
my
file
lord,
that.
my lord kindly appreciates my lord. My personal difficulty only yesterday I have received this after change of panel from the office of the learned government pleader.
Fully
My lord,
comment
I'll
that
be
personal difficulty.
my lord, my lord, I'll be.
When was the direction given?
My lord, the direction was my lord on 17th February 2023. My lord, I know there is inordinate delay. So my lord, that
Pay
may
some
be-
costs.
My lord, kindly on my personal
Mr.
ground, my
Gupta,
lord,
give a
kindly.
copy of your photocopy of your bill, whatever you raised to your client, to him.
My lord,
That will be the cost.
my lord, kindly.
That will be the cost. We have to. That is the basis of assessment of cost.
My lord,
Then
kindly.
I have a leader.
Legal fees and all.
Then I have a leader.
My lord,
Mr. Jishnu Chaudhary. Then that.
My lord, the interest of the petitioner, my lord, is
We'll
being
have to
protected. My lord,
protect the interests of the state then.
My lord, the interest of the writ petition is protected.
But
I understand from the from the
I am
order passed
sure
by the coordinate bench.
So thick matters by.
there are 5 deeds which we have annexed. I'll give your lordship kindly give
What
me
is the urgency in there?
My
no,
lord.
no, extreme urgent. I'll just give me 2
Extreme
minutes
urgency
of it.
because you are appearing.
No, no, no. I give me 2 minutes.
My lord.
My lord, your lordship would my lord, love to take up this matter. I'll tell your lordship why. My lord, this is a matter where a dead person has been a deed has been executed in the name of a dead person that he has sold to somebody. He had passed away in 2019. Somebody else having the same name, his Aadhaar card has been used by and a deed has been registered to sell in on registration on commission. That's the first set of deeds. The second set of deeds is the petitioner. The first deed I'm talking about is the father of the petitioner, who is no more, passed away in 2019. His deeds purportedly executed in 2022, selling his property. The second set of deeds, there are 5 in number, which has increased the volume, where the signature has been forged, the photograph of somebody else has been annexed. In
All these deeds are contemporaneous or one?
all these deeds contemporaneous. All 2022 around April.
What have you challenged? The registration?
The registration, because there's an infraction on the part of the registering authority's duty under section 34. My lord, in my lord, permitting this registration to be done, my lord, without my lord, ensuring the compliance.
Section 34, can you place me?
Yes,
Place
your
before
lordship
me.
will kindly permit me to hand up my book, my lord, kindly.
Let us see whether it can be resolved without.
Yes, my lord.
affidavits.
My lord, I also love to, then in that event, I also love to argue on the point of maintainability of this.
You and I love these
My
things,
lord,
but
kindly,
as for
my
Mr.
lord,
Gupta,
kindly.
Mr. Gupta said that I'd love it,
My lord.
and you are loving it admittedly. So apart from Mr. Gupta, everybody loves the matter being taken.
No, no, I thought definitely.
Yes.
34.3, if your lordship kindly takes a look at.
No provision of appeal.
No provision of appeal.
No provision of cancellation.
What did the registering officer do according to you here
Kindly,
to satisfy this?
kindly takes a look at my lord, the first document, which is page 37.
If something was produced before the registering authority to show the identity,
yes.
I mean, can we look through that? Otherwise, you have different other recourses.
So
criminal.
kindly, yes, I'll take your lordship to that. Kindly takes a look at page 37 once.
Yes. Let us see what they relied on.
Yes.
According to you, I mean.
Well, before that, just one document, the death certificate. Thereafter, I'll take your lordship to that.
No, death certificate was not before the registering
Yes,
authority. So this
just
is in
to
support of
indicate-
your contention.
I understand.
I'll look into that. Yes, definitely.
Your lordship
I'll
will kindly
look
have
into
a
the
look at
veracity of it.
the first impugned deed, which your lordship will find at page 205.
No, but here, Mr. Gupta, probably the registering authority is required to file that opposition. They have to
No,
show
I
the
am not
court
saying that they
they
are
relied
not.
on what documents.
I'm not saying they are not.
It
But
depends only on that.
right.
If they show sufficient documents to discharge their onus under 34.3, then you cannot have a good case in registration.
then can you do not permit them to use an affidavit?
No, no. The limited question in the present matter is whether the registering authorities were justified and in compliance with section 34 within bracket 3 of the Registration Act 1908, comma, in permitting registration of 5 documents which were executed and registered according to the petitioner, comma, in the name of a dead person. First up, next para. Learned counsel for the respondent authorities seeks an extension of time to file affidavit in opposition. Full stop, next para. It transpires that affidavits were directed to be filed long back. Full stop. However, comma, as a last chance to the respondent authorities, comma, the time for filing affidavit in opposition is extended till September 20, 2023. Full stop. Reply, if any, shall be filed by September 27, 2023. The matter shall be listed under the same heading on September 28, 2023. Updated.
But only thing, my lord, is it your lordship's pleasure to kindly consider an interim order restraining the purchaser from further transferring? Purchaser. Well,
Whatever, that will be subject to this in any event. If
Yes,
the
but-
registration goes, everything will go.
Yes, but in the meantime, deal system, if he further transfers, then that would create
Are
multiple.
the parties here?
Yes, respond number 4.
This
They
is
have
beyond
not
the scope.
appeared. They have not appeared despite service.
Sir, kindly
The-
seize the last order passed by the coordinate bench. There is a direction already, my lord, as far as I understand, on 17th of February. My lord, due to pendency of this, my lord, kindly seize the
But
direction.
they had appeared, but today possibly they are not.
My lord, kindly seize the operative part of the order passed by the honorable coordinate bench. Like to respond number 4 or direction that shall not take any further steps in terms of yes, this is
What direction? Which
The
direction?
last
my
paragraph.
lord, the last para. Since the court is hearing the matter, it is expected that the
That is
respondent number 4
Yes,
shall
that is
not take any
that is
further
what I was,
steps
my lord,
in terms of conveyance or sale. My lord, this is there. My lord.
I was hoping that an injunction on instead of that. That's the only thing. I'm grateful.
Expectation takes the contempt to that court. Injunction would take the contempt to my court. So it's always preferable for the matter to be heard before some other court. So balance of convenience is against grant of injunction.
Grateful.
Yes.
16.
Mr. Gupta, please ask your learned junior to give the appearance.
হ্যাঁ ঠিক আছে
My lord, item number 6.
No, no, Mr. Gupta was common in both.
আমি 14তেও ছিলাম
উনি বেশিরভাগ ম্যাটারই আছেন না?
না।
Yes.
My lord,
Item 16.
16, I'm for yes, I'm praying for a not today, my lord.
No, no, no question of that.
My lord,
Upgraded matters, no, then it goes down.
my lord, I am for the petitioner, my lord. My lord, what happens, my lord, I have a proprietorship business of my lord
Oh, no,
produce.
it's 1:1. On the last occasion, you paid for time.
My lord, yesterday my mother was serious.
Acha, acha, acha.
Not happening for the respondent number 4, my lord, prohibited from authority, my lord.
You are for which respondent?
Yes, I may.
Yes, is the main answer.
main.
I'll take it up on Friday then. No, 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 Friday. Learned counsel for the ESI 6 an adjournment, full stop. Let the matter stand adjourned accordingly till September 8, 2023. Please come back on that date. If it goes beyond that, then it goes beyond a fortnight. I'll be returning from Jalpaiguri after a fortnight, but unless, would you like to mention this before the bench having urgent determination? Then I can keep it on Monday also, if because he's in difficulty on Friday.
My lord, keeps it on Monday.
Well, I also am having some difficulty, my lord.
On Friday? Very
keeps
well.
it on Monday.
Accordingly, adjourned till September 8 na kore, till September 11, 2023. Thank you. Yes.
My lord, I appear for the petitioner, my lord.
Yes, please.
My lord, the short question is that, my lord, I have filed.
Please check up whether good service has been
Yes, my lord. The service.
served on all.
Yes, my lord.
Yes.
My lord, I had filed at section 14 before the magistrate Barasat, my lord.
Right.
The hearing was done on 17 May 2022. Till now, he has not passed the order. Only
When
that.
did you file it?
My lord, I had filed the section 17 on 8. Yes, my lord, October 8, 2021. Thereafter, the matter was heard on 17 May 2022.
The grievance of the petitioner is that an application under section 14 of the Service Act 2002 is pending since October 2021 before the concerned district magistrate, that is respondent number 2. Full stop. Since the statutory period is 60 days, comma, it is submitted that a direction be passed for expeditious disposal of
My
the
lord,
same.
hearing has been done. Order is pending, my lord. Hearing has been done on 17.
Disposal, statutory period is for disposal. Disposal includes order.
Yes.
Hearing was done on 18th October. Filing.
Hearing has been done.
Hearing has been done, my lord. The order is pending, my lord.
Yes, unless the order is passed, there is no disposal.
Yes, lord.
Who's up next para? It is further submitted by learned counsel for the petitioner that the hearing has been concluded. When was it concluded? The hearing?
My lord, 17 May 2022.
22. Same magistrate is there. It has to be reheard then.
My lord,
Why did
as
you
per my-
attach earlier?
My lord, as per my instruction, the same magistrate is there, still there, my lord. As per my
Are you
instruction.
sure on that?
Yes, my lord.
Learned counsel for the petitioner submits that the hearing was concluded as long back as on May 22.
Yes, my lord.
No, which date?
My lord, 17th May 2020.
On May 17, 2022. Full stop, next para. Despite service, none appears for the respondents. Affidavit of service be kept on record. Full stop. In view of the innocuous nature of the order proposed, comma, further service is not directed. Full stop. WPA 10568 of 2023 is accordingly disposed of by directing the respondent number 2 to dispose of the pending application under section 14 of the Surface Act 2002 filed by the petitioner, comma, by passing an order thereon, comma, as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the respondent number 2. No orders to cause urgency.
Much obliged, my lord.
I can't hear you. Can you please switch on the microphone? Just please switch it on. There is a switch. Yes.
My lord, Mr. Shane is appearing, is coming.
Samrat Sen.
Yes. So,
Mr. Sen. Good. Yes.
short
But I'm back to appear on behalf of the petitioner, my lord.
Right.
My lord, on one application was a
Right.
on one application has invited for the purpose of appointment in the post of MMR under police station Jaipur. Page 42 is the advertisement. According to my lord, the petitioner along with other eligible candidates appeared before the selection process.
Right.
And during the selection process, my lord, the private respondent who was selected, my specific case is that he is not a resident under police station Jaipur. That was in the advertisement, main criteria. So, my lord, I moved the application before the Honorable High Court. And this Honorable High Court is pleased to pass an order. Kindly come to page 53, Annex P12.
Yes.
But I'm reading from the first paragraph. The only point for adjudication is whether the private respondent who was appointed as the Mohammedan marriage registrar pursuant to an advertisement dated 4th August 2019 is a resident of Jaipur, Howrah or not. The documents annexed to the affidavit of the private respondent, in that case, private respondent was so that the electricity bill, the bank passbook, the ration card, and the passport, which mention that he is a resident of Jaipur, Howrah. However, all the documents, save and except the bank passbook, were issued much after the advertisement. The bank account was opened on 26th August 2019, which was after about 20 days from the date of publication made for inviting application for Mohammedan marriage register. So, my lord, I am skipping, my lord, the second paragraph, the page 54. Since the document relied by the private respondent show that the documents were obtained after the advertisement dated 4th August 2019, WPA number such and such was disposed of with a direction on the respondent number 2, being the district registrar Howrah, to consider the factual particulars as to the residence of the private respondent in accordance with the governing act of the notification. The respondent number 2 shall hear all necessary parties and come to a reasoned decision within 8 weeks from the date of from today. A copy of the suggestion. After that, my lord, so only point for conversation was that whether the person to the notification or advertisement, the particular respondent was within the police station of Jaipur of resident, which is the main criteria of that particular post. Now kindly come to the, my lord, the order passed by the respondent authority, Annexer P15, page 58 onward. And page 60 is the last portion, from which not a single word uttered by the respondent authority, whether the direction of the Honorable High Court to the effect that to ascertain whether the particular party was a resident under the police station Jaipur or not, has not been discussed. Casually, it has been disposed of and reiterating its earlier position. Problem is that, my lord, the district registrar who was directed to consider that, he issued the license. So I don't think that he's not competent or not, but he's under some obligation. They passed the order.
without, my lord, following the order passed by the Honorable High Court. It is absolutely illegal order, my lord. And the annexer, I have again annexed, my lord, all the documents for your lordship's kind perusal. It will be clear that all the documents as mentioned by this Honorable High Court, my lord, their order, that he is not a resident of police station Jaipur.
So when he had produced the Aadhaar card issued on 17th of September 2012, page 60, the first paragraph. The advertisement is of 2019,
lordship,
whereas the Aadhaar card, his Aadhaar card is of 2012. That has been recorded by the authority, by the district registrar. Page 60, second line, second sentence. I mean, second line, first sentence. Submitted copy of Aadhaar card issued on 17th of September 2012. So that is prior to the advertisement, one. Secondly, the other qualifications have been also been done.
17th September 2012.
That is the finding.
Yes, yes. But in this other, but then if he was a resident of that particular area, then what prompted him to obtain all those documents?
So two questions I'll put to you. One is, we have to read the order of the coordinate bench in appropriate perspective. Now there it was observed, the learned judge observed clearly that since the documents relied on show that the documents were obtained after the advertisement, disposed of with the direction to consider the factual particulars as to residence of the private respondents in accordance with the governing act and the notifications. Residence has to be seen in accordance with the governing act and the notifications. Some cloud was cast on his. Now, do you say that he or she has to be a resident of that area before the advertisement itself or before the appointment is given?
Before the advertisement.
Why do you say that?
Because
what is the bar? Suppose an advertisement is given. I thereafter move to that area, or I choose to move to that area, and then I produce these documents. Does the advertisement say that? Let us see the advertisement once. Page 42 is the advertisement.
Page 42. Application invited for temporary MMR on such and such Jaipur, acquaintance with such and such.
Applications invited to, yes, acquaintance with Arabic such and such.
DR office, Howrah, last week.
Now, let us see the relevant provisions which have been quoted in this impugned order. The provisions of the circular has been quoted probably. The requirements. 4A and 4B, yes. Have you got a copy of that notification?
Yes. It should be read, my lord, 441, 42, 43 instead of 8.
Anything there regarding the residence is also there.
But preference, only thing preference. That means that when all other qualifications are equal, then only preference comes. 4-1 and then lordship 4-3 preference.
Yes, but the other point remains. Very well, Mr. Hussain, I take your other point also. The court directed specifically regarding to scrutinize regarding the residence. There is nothing about that. Only one straight line that Aadhaar card was. Let us move on to them. Let us hear them. Yes. Yes, Mr. Shen, you first.
Now, my lord,
Mr. Hussain, please take your seat. Yes.
now, my lord,
No seat.
now, my lord, it,
Yes. Yes.
now, my lord, it appears from the, my lord, the impugned order.
Yes.
That first of all, my lord, I think my lord has already, my lord, gone through the advertisement.
Yes.
Yes. Now, my lord, they are also, my lord.
Gone through the other advertisements also on that page.
Now, my lord, kindly have a look once again, lordship, kindly come to the advertisement. I think, my lord, it is
very
at
clear.
Page number 42, possibly 42, my lord. Kindly once. Because the other criteria also there.
Yes, Arabic, Mohammedan law.
Yes.
Right, right.
That's all.
Yes, you are right. Yes.
Now, my lord, kindly come to the impugned order at page 60. That the my lord, page 59, last paragraph. That is the last but one page. Have you also got it, my lord?
Yes, yes.
Heard the petitioner of the said writ petitioner, namely Jamiruddin Mullik, and the private respondent, namely Habibur Rahman, on 6th April. The petitioner submitted a written statement along with some documents for consideration of his appointment to the post of temporary MMR for Jaipur police station area. Now, the contention of the private respondent is that he is a resident of Jaipur police station area. He had submitted copy of Aadhaar card issued on 17 September 2012 by the Unique Identification Authority of India, recommending letter of in MP, other thing, certificate of Pradhan as proof of his residence. Now, my lord, proof of his residence, my lord, if my lord, the one, my lord, the identification card is, my lord, enough, then this is, my lord, the proof of residence, then, my lord, there is no need to look into any other document. Because, and another thing is that when he obtained that proof of residence, it appears whatever be the earlier, my lord, the matter, my lord, when it came to the court also. But now it's a fresh, a de novo. When it's
But
a
court
fresh,
directed specifically in the light of those observations that the proof of
at that time, it was not there.
it was not there. Not only that, he obtained all those things subsequently.
That was, my lord, I think bank statement and other thing. That
Yes,
proof,
yes.
proof of residence.
But these are
now,
new other documents.
This is the, my lord, the document which, my lord,
Aadhaar
had
card
not
is
been
there.
submitted on
Right.
earlier occasion.
Aadhaar card, unique identification.
Aadhaar card, unique, yes, this document, my lord, produced, my lord, next when the matter is taken up de novo, after the, my lord, matter remanded by the court. Now, my lord, we cannot, my lord, ignore this document. My lord, this is a government document. We cannot ignore. Then, my lord, another thing. In terms of clause 4A, it should 4.1, my lord, issued by the Judicial Registration Department, Government of
The
West
other
Bengal.
qualifications
The
have been there.
other qualifications are
As
there.
you argued, Mr. Sen.
Yes.
Preference, only preference
Now,
regarding third.
now, my lord, kindly see, this is the, my lord, the broadsheet, the panel of candidates. Now, my lord, the lordship, kindly have a look. Serial number 1 is the private respondent, Habibur Rahman. Now, my lord, the first, second, third, fourth column, his educational qualification, BA Kamil Honors. And serial number 2 is the read petitioner. My lord, he is, my lord, the in under that matching column, he is, my lord, education qualification, only Kamil. So, and my lord, it appeared that the in respect of qualification also, my lord, since he possesses a higher qualification, so it gave mileage to him. That is all, my lord. The why his, my lord, his candidature was considered as a, my lord, the first preferable candidate. And in the panel, the read petitioner's name, my lord, appeared second, and the rest of the candidates who were on the fray, the, my lord, the rest are there. But the post is one.
Very well. Yes, private respondent.
Lord, the contention of the petitioner is that, my lord, he is the resident of, my lord, Jaipur police station is not, my lord, true. Because, my lord, he is the permanent resident of Bagnan police station.
He.
Yes, my lord.
His residence is not important. Your residence was what was directly.
My residence, my lord. So far, my residence is concerned, my lord. The member of parliament of that constituency, my lord, issued the certificate on 6th of August 2000.
Member of Parliament apparently issued a recommendation letter.
2018, my lord.
Recommendation letter is not a proof of residence. No, sorry.
There is recommendation letter is also here, my lord, issued in the year 2016, my lord.
As a before this advertisement.
Before this advertisement, my lord, and 2021 issued by the Kasmoli Gram Panchayat, my lord. 2019 issued by the Kasmoli Gram Panchayat, my lord, and the member of Legislative Assembly, my lord, issued the, my lord, recommendation certificate in the year 2018, my lord, kindly have a look.
No, I won't. I will look to any
These
new
are the
document.
documents.
No new document.
So far, my lord, the
If those were not considered by this authority, then either you win or lose on that.
Lordship, the petitioner mentioned that he is unemployed, my lord, but presently he is working as the Mojan, my lord, and he is getting honorarium from the work board, my lord.
Petitioner's qualifications will come later if it is. I mean,
Basic, they have basically challenged, my lord, that since the private respondent who is appointed as the MMR is not the resident of within that
Jaipur,
station,
yes.
my lord, so he is not entitled. But what is his right, my lord? He is enjoying, my lord, electricity, my lord, in another.
These points were not taken before the previous court.
Lordship, taken, lordship. In that
Show me that.
petition, my lord, we have filed one opposition, my lord. May I?
But that has that has not been considered here. So you are barred by constructive res judicata.
Lordship, we have.
Your objection regarding his capability, that was never considered here, not reflected in the order. So you are barred by constructive res judicata from taking that point.
We have, your lordship, filed the opposition, your lordship, that was kept with the record. Your Lordship.
Maybe. Anyway, let us hear them in reply. Yes, what in reply?
Only another point, my Your Lordship.
No, another point.
No, page
Just-
47. Page 47 is the voter list,
Your residence.
his residence. Answer P10, page 47. Hana Bagnan. Right side, my lord, second column. And petitioner's name, page 48. Left hand, serial number 184, second from top. Police station, Bagnan.
Order Didi.
Your voter card, lordship, my voter card, your lordship. The residence is mentioned, your lordship, Jaipur police station, your lordship. Since the other of the private respondent is residing at that area, your lordship, may I place 2 or 3 documents, your lordship?
No documents, new documents can be placed here. Whatever you place before the authority, that is all.
Lordship.
Cannot be reopened again in writ. Learned counsel for the
Lordship,
petition.
Lordship.
Please take it.
But
Learned-
may I take permission?
Yes, yes. Learned counsel for the petitioner contends that the private respondent was erroneously appointed as Mohammedan marriage registrar for the Jaipur police station area, despite not being a resident of Jaipur. Full stop. Previously, upon a writ petition being moved by the petitioner, a coordinate bench of this court had directed a fresh factual consideration on merits, recording that the documents relied on by the private respondent show that those were obtained after the advertisement dated August 4, 2019 for such appointment. Full stop. Despite such specific direction of the coordinate bench, it is argued that the district registrar, Howrah, repeated a similar exercise, not clearly acting in terms of the order of the coordinate bench. Full stop. It is submitted that the context in which the previous coordinate bench directed the reconsideration, that is the documents produced by the private respondent were issued mostly after the advertisement, was not considered. Full stop. Next parallel, and counsel for the state respondent places reliance on the concerned notification number 10-JL dated January 6, 2017, published on January 19, 2017 in the official gazette. Full stop. In terms of rule 4 within bracket 3, as mentioned there in the residence is only a factor, subject to compliance of other qualifications, for giving preference to the claims of local people, it is argued. Full stop. Next para. Learned counsel also hands up a copy of the list of the panel of candidates chosen, which indicates that the private respondent is much more educationally competent than the petitioner for the said post and is also a resident of Jaipur. For next parallel, and counsel for the private respondent argues that the petitioner himself is not a resident of the concerned police station and is not qualified to get the post of MMR. Full stop. As such, the petitioner, it is argued, has no locus standi to prefer the present writ. Full stop. Next para. That apart, learned counsel for the private respondent reiterates the contentions made before the authorities, by placing reliance on certain portions of the impugned order which referred to recommendation letter of an MP as well as the Aadhaar card issued in favor of the petitioner and other documents, to argue that the point in contention was duly decided by the district registrar Howrah. Full stop. Although the private respondent, comma, through counsel, comma, seeks to produce certain further documents for perusal of this court, comma, such permission is refused to the private respondent, comma, since the writ court is not an adjudicating authority on facts, and since such exercise has already been undertaken by the district registrar. Full stop. Next para. Upon a perusal of the relevant notification handed over by the state, comma, it transpires that subject to being qualified on other counts as indicated in the concerned notification, comma, preference is to be given to the claims of local men of respectable character and suitable attainments. Full stop. Next para. The notification number 620-REGN 14th August, 1929, which governs the field regarding qualifications, also stipulates other qualifications, including knowledge in Arabic, Mohammedan law relating to marriage and divorce, and good moral character. Full stop. Next para. Apart from that, the candidates to be selected for the post of Mohammedan registrars have to be Indian citizens having permanent address in the state of West Bengal. Full stop. Next para. Thus, the preference to be given to local candidates is circumscribed by the preconditions and prior qualifications as indicated above. Full stop. Next para. Given that several candidates of similar stature apply for the said post, preference shall be given to local men of respectable character and suitable attainments. Full stop. Next para. We have to look into the context of the order of the coordinate bench on such score. Full stop. Although the learned single judge observed that the documents produced previously by the private respondent were obtained after the advertisement dated August 4, 2019, the ultimate direction given by the learned judge was to consider the factual particulars as to the residence of the private respondent, in accordance with the governing cap act and the notifications, close. Full stop. Hence, such factual reconsideration was to be in accordance with the governing act and the notifications. Full stop. By the impugned order, the district registrar took into consideration all the relevant provisions of the governing notification, as well as the fact that certain other documents, apart from those produced previously by the private respondent, were also placed before the authority and were considered. Full stop. The district registrar clearly took note of a copy of an Aadhaar card issued on September 17, 2012, that is 7 years prior to the advertisement, as well as recommendation letter of a member of parliament and certificate of Pradhan of the Kashmoli Gram Panchayat as proof of the petitioner's residence within the territorial jurisdiction of the Jaipur police station. Full stop. Hence, the factor of residence was duly considered by the district registrar. Full stop. However, the additional context which comes in is that the private respondent was, as per the educational qualifications before the authorities, more qualified than the petitioner, since the private respondent was BA Kamil, KAMIL, within bracket honors, bracket closed, whereas the petitioner was merely Kamil. Full stop. Next para. The preference to be given to claims of local men, read in conjunction of the other qualifications as stipulated in clause 4 of the notification of 1929, comma, as substituted by notification number 10-JL dated January 6, 2017, clearly shows that the primary consideration was possession of sufficient acquaintance of the Arabic language and Mohammedan law of marriage and divorce, and good moral character, apart from permanent residence in the state of West Bengal. Full stop. As an additional qualification, comma, the preference was to be given to claims of local men of respectable character and suitable attainments. Full stop. By necessary implication, comma, the question of giving preference arises when only in cases where people of similar qualification are available, comma, among whom one is a local resident and the other is not. Full stop. In the present case, comma, however, comma, the private respondent is more educationally qualified than the petitioner for being chosen as an MMR, and, comma, as such, comma, was more qualified, comma, without going into the question of preference. Full stop. Even on the issue of residence, comma, the district registrar recorded the production of Aadhaar card issued much prior to the advertisement, as well as recommendation letter of the MP and certificate of the local Gram Panchayat Pradhan as proof of residence, comma, which were fresh documents but issued prior to the advertisement. Full stop. Next para. In any event, comma, the relevant date to be looked into is the date of the appointment being given and the application being made, and not merely the date of the advertisement. Full stop. Next para. That apart, comma, since the private respondent is otherwise more educationally qualified, comma, the line of distinction drawn by the respondent authorities cannot be faulted on law and on considerations of natural justice. Full stop. The reconsideration directed by the learned single judge was not restricted only to the residence aspect, but also to be in accordance with the governing law and the notifications, comma, which was duly done by the respondent authorities. Full stop. Hence, comma, there is no scope of interference in the present matter. Accordingly, WPA 10588 of 2023 is dismissed without any order as to cost.
Good.
Sorry. Yes.
My lord,
May I take back that copy of notification, or it will kept in the record, my lord?
You can take back. Fair did. Notification fair did. What is evidence?
my lord,
Yes.
the next matter I am the state respondent. The next matter, my lord, that I will be engaged in court 6 at form 2, my lord. May I?
I'll take it up expertly then.
No, my lord. Kindly adjourn, my lord.
It's for the petitioner.
I am for the petition only for the consideration of my representation regarding the tender issue within the date as stipulated in the tender notice.
I'll take it up on Friday.
Friday, my lord, your lordship taking up some applications thereafter. Therefore, it may.
Oh, then it's difficult.
Subject
It has to go
correction.
down to Monday.
Then it can be taken up.
I will be in court.
You are also there for the state.
Or it can be taken up now.
Keep him there. Let me call the matter on after recess. Let us
Yes,
see.
yes.
My lord, actually.
Grateful to us.
Hmm.
থাকুক না, পাঠিয়ে দাও না তাহলে।
Yes.
ওখানে পাঠিয়ে দাও না। আমার সময় হবে না।
কিন্তু বৃষ্টি ছিল।
এটা ওতে কারেকশন হয়েছে?
এখন অসুবিধা বলে আর হবে না।
এটা কি আপলোড হয়ে গেছে?
থাকো না, জলসা কখন কোথায় আছে? এখানেও 1:58 বসবে। গেট এখানে 1:58 বসবে।
So they're in difficulty, we'll take it up on when.
May I place, it is for consideration, not judicial review and.
You're there. Mr. Goswami, will start them. Yes.
The notice inviting tender floated at page on 7th of February at page 126 for construction of some roads by the Poschimachal Unnayan Parishad. There are some criteria are there. My lord, page 27, clause C and D, that cancellation part is there. If the bidders do not meet all these criteria, then. Now, page 28 also, my lord, given some details. Page 29, given some machineries to be adopted, to be taken into, for the purpose of getting that, all these machineries. Now, the private respondents, my lord, did not get some eligibility to that extent. I have annexed some documents. Now, page 30 is the eligibility criteria also mentioned. Now,
Private respondents have been served.
Yes, notice has been served twice.
Right.
Now, one of the clauses is there. Kindly come to page 33. Yes, affidavit of service has there.
Yes.
Page 33. We are the 5 contenders are there. 3 had been made successful. I am the second. First has been private respondent. Kindly come 7.4. Page 33. To cut short it up. Intending tenderer bidder not satisfied with the decision of the tender execution committee may approach the tender committee in writing within 2 working days after the date of uploading the summary such and such. But 16, that is page 21, it has been published. Date is very vital. Page 21, my kindly says, Reboti, my client, qualified, 21, P2. I got it. Reboti, my client. Column number 3, Ganesh Chandra Patra is the number 1 has been given. Now, 5th is the another 3 qualified out of 5. Now, since the private respondent did not meet the essential qualification, kindly come to page 58. The machineries are to be provided for the purpose of construction. The private respondent, my lord, kindly sees the vehicles. One bus, which does not match with the machineries. Page 58. 15 years, 4 months, fitness expired. Barakpur RTO, this is bus, has been used for the purpose of construction purpose, but it is not matching with that schedule of this. And those are the affidavit which has been filed by the private respondent. I have got as per lease agreement just prior to the date of
private respondent has been selected.
That is the contention. Now, immediately thereafter, on 17th, we made objection to that effect. Kindly come to page 59. The day after the publication, within 48 hours, got it. Page 59, annexure P6.
Yes.
With them some contents.
What happened then?
Now, page 62 kindly says, since they did not take any decision, again, my lord, representation, page 62.
So you wanted consideration of those?
But at this stage, judicial review is not permissible. So before that, they could have, my lord, decide our representation or objection. Now, in the meantime, I must be candid, some work order has been given. Without when attending our representation, that they should have been as per law. Thereafter, it should have been given work order. Thereafter, again, I made to advocate on the letters record, letters, page 72. Elaborately made the.
Have you challenged here?
I have come before your lordship to meet our representation and pass the order. In the meantime, if any work order is given, subject to result of the decision itself. Because I cannot make.
What is the finality if you seek in the writ petition?
No decision has been taken till date.
What is the final decision you ask for in the writ petition?
In the writ petition, let them take my objection and pass the final order to that effect.
What would be the effect of that, even if they decide your representation? Now the
Otherwise-
work order has been issued.
Yes, the work order subject to, otherwise your lordship can direct them to file a report to that effect, whether they have made all my representation or objection to that effect.
No, that is why I'm asking, what is the
I
final?
give it to lordship. No, this is my,
Is the final relief you have asked for in the
I have finally to cancel the work order which has been issued, if any, in respect of the private respondent.
direct affidavits?
Yes,
My
my lord, in the meantime,
My lord, take this on Monday, my lord, kindly.
I'll direct affidavit.
in the meantime, if any decision is taken subject to result of the
Decision has been taken, work order has been issued.
This is what I have got the information from there. It is not finally, I have no
The
intimation.
counsel for the petitioner submits that the petitioner was aggrieved with the publication of the list of successful candidates insofar as the private respondent, who features as candidate number 3 in the list of successful candidates, the petitioner accordingly filed a representation. Full stop, next para.
Page 59.
Learned counsel places reliance on clause 7.4 of the tender document, which contemplates that the intending tenderer stroke bidder, if not satisfied with the decision of the tender evaluation committee, bracket TEC, bracket closed, may approach the tender committee in writing within 2 working days after the date of uploading of the summary list of the successful tenderer stroke bidders. Puts up in the present case, the list of successful candidates was published on March 16, 2023, bracket annexure P2 at page 21 of the writ petition, bracket closed, and the objection was taken by the petitioner on the very next date, that is on March 17, 2023, within bracket annexure P6 at page 59 of the writ petition, bracket closed. Subsequently, the respondents did not respond to the same, for which several similar representations had to be filed by the petitioners, but to no effect till date. It is contended that the private respondent, who was issued the tender order, the work order in the meantime, pursuant to the tender, does not qualify the eligibility criteria of the tender, and as such, the work order should be cancelled and the work should be allotted to the petitioner. Next para. In order to ascertain whether the respondent authorities have taken a specific stand on the repeated representations of the petitioner, which were issued in due time, the respondents authorities are required to file a report. I'll not direct to affidavit at this.
Yes, ma'am.
File a report. Next para. Hence, which is the tendering authority?
Respondent number 2.
Hence, the respondent number 2 is directed
Chief Executive
to file a report in the form of an affidavit, taking note of the representation of the petitioner annexed at page 59 of the present writ petition, and depicting the stand of the respondent number 2 on the issues raised by the petitioner. Next para, such report shall be filed upon circulation of prior copy to the learned advocate for the petitioner, on the next returnable date, that is on September September 26, 2023, when the matter shall be listed under the same heading.
2 weeks.
Affidavits
my
of
lord.
service filed today be kept on.
My lord,
Much obliged.
my lord, 2 weeks, my lord, kindly, my lord. And when
He has been given more than 2 weeks.
2 weeks, more than 2 weeks.
26.
I'll reduce it to 2 weeks.
No, my lord, no.
It is more than 2 weeks. 3 weeks already.
Yes.
Much obliged to
I'll
you.
tell your father, Mr. Goswami. Yes.
Grateful. Much obliged.
Item 20.
20, yes.
Lordship, item number 20 and 21, Lordship, I'm led by Mr. Shataru Banerjee. Lordship, due to
Start
some
the matter, start the matter.
personal difficulty, he's left the
No
court,
personal.
Lordship. So,
Left the court.
Yes, today he left the court. Can it be adjourned for today? And Friday's
Upgrade
loss.
matter, then I'll not take it up under the same heading. It has to go down then. Upgrade matters, no agenda.
At least for 1 day loss.
No. What is the matter about?
Monday and Tuesday, my lord, then I will have some difficulty.
Lordship, the difficulty is, Lordship,
Tribunal,
the
my
time.
lord, one member functioning set,
Yes.
and my lord, his case is not taken up regularly and the matter is.
For the
adjourned.
last 24 months, there is no division bench before this act. So the matter has been referred to hearing list in the month of September 21. And since then, the constant date has been given.
If there is no functioning bench, then what direction do you expect here?
My Lordship, the petitioner is not getting relief over that. That's why I have.
Last date was 7th June.
No, either it has to
Seven?
be, I mean, if no tribunal is functioning, whom should we direct?
No, Lordship, I have brought the entire issue over here. My prayer is the entire, I've challenged the
Matter is
disciplinary.
challenging, my lord, the
disciplinary
disciplinary proceeding after being upheld by the departmental.
Then I'll
appellate
adjourn it for the day then on Friday. On the prayer of the petitioner, the matter is adjourned till Friday, till September 8, 2023. But if you pray for time on that date, you will have to come prepared in the matter.
No, I'll come prepared on
8th.
8.
Friday.
তুমি আছো পরশুদিন
Yes, Mr. Sen, day after tomorrow.
So 20 and
21
also same.
appearing my led by Mr. Bosu Mollik. Malad, he is
21 minute I am appearing.
Same.
21.
Same on Lordship.
Same. Mr. Bosu Mollik.
In fact, they can be-
Instead of Friday, can it be on Monday, Millard?
And it can be, but I'll keep it on Friday because you're in difficult. Friday. Come back, similar matter, come back on Friday. Yes.
কি করে দেয় কি করে জানবো আমি দেখো বাবলাতে আমি দেখি
22?
20. Yes, Mr. Shaunto.
please.
Yes, please.
Lord, homestead land. The WBSCDCL has made a high tension line with transformer. We without permission. We came before my lord. My lord gave a detailed order and directed the DM that he should consider the matter. It was considered and the thing has to be shifted. That has decision is taken. Alternative site also found, but ultimately they are not acting on the basis of that. As a result, Lord, I am unable to construct on my homestead land. Lordship will see your lordship's own order, a very detailed order.
89, page 89.
Page 89.
শিফট করার জন্য
ঠিক আছে।
ফাংশন
Works of licenses, rules and all these work on. And
Now,
where is the order of the district magistrate, Mr. Shaunto?
Lord, the order is at page 98. Lord.
page 9.
No, they were given an option, either shifting or not possible, then compensation.
But that is page 86. Once lordship kindly comes to page 86.
98, that is important. Because district magistrate
Let
has
me
not,
finish.
please. But he has not completed his job.
Page 86, lordship will see, please. দাঁড়াও, 86 ওটা পুরো দেখে নিয়েছেন জজ সাহেব, ওটা পুরো দেখে নিয়েছেন।
Drawing has not been signed by you. That is there. Continue.
No,
That is
that is by the earlier.
Clear. Before moving the.
Page 86.
Yes.
Yes.
We are not the petitioner. এখানে তো page 86 তো আমরা petitioner নই নাকি?
না, আমরাই ছিলাম।
হ্যাঁ।
এটা এই অর্ডারটা আগে আর কি।
They have already identified the place for shifting.
Place for shifting is already identified, Lord.
Thereafter, this
And
order.
Lordship will,
Thereafter, inner.
After 7th of December 22, is there anything?
Lord, your Lordship's order is there, Lord.
No, my order is before 7th of December.
21st September 2022.
7th of December, the magistrate give the direction.
Yes.
After that, what happened?
Lord, Lordship would be pleased to come to
তারপরে যে joint inspection,
page, joint inspection, Lord, is at page
page হচ্ছে 100.
page 100.
Yes.
এবং তারা assure করেছিল যে they will shift it.
That was held.
Yes.
Yes.
Then
my Lord, Lordship kindly comes to page 109.
Order of
21st March.
very well. After that, nothing.
After that, my Lord,
I mean,
they
from
have,
your end, you have written.
yes, we have written another document is there.
Yes.
Lordship would be pleased to come to the
110.
100.
page 100. Yes, 112, my Lord.
110, 110.
110, then 12. This can be no reason.
And SDO has issued the order. যেহেতু DMO কে বলেছে implementation. এবং এরা দিয়েছে এইখান থেকে এই যে মালবাজার মুক্ত প্রাইভেট পার্টি পার্সোনাল মাল্টিভিশন এদেরকে দিয়েছে order to place is also there.
That direction was given by the subdivisional magistrate.
Yes, they are not implementing. Lordship kindly comes to page 112, my Lord. They
Yes.
last.
I read 112.
Yes. So in spite of this, my Lord, they are not acting on the basis of the. There is an alternative site. I am unable to do anything with my homestead land because it was granted without permission. Therefore, I am before my Lord.
Yes, what do you say, Mr. Naik?
My lord was pleased to pass this order, my lord. Again, my lord, I am just referring my lord's order dated 21/9/2022. All earlier, my lord, reports, everything were inspected, and this was, my lord, the third time litigation, and my lord was pleased to pass this order. Very specific direction, district magistrate will have to, my lord, find out, locate whether that land belongs to petitioner or not. Number one, if it is found that it belongs to, my lord, petitioner, district magistrate will pass this direction for shifting or for compensation. That was very specific, but district magistrate has not done that. He has come to the proceeding that joint inspection will be held. Thereafter, he has not done anything. He has, my lord, then all on a sudden, my lord, this SDO and all these other officers are coming, who used to, my lord, act earlier also. Be that as it may, I am not pressing on this right now. Kindly come to, my lord, page 99. Page 98, he has referred, district magistrate's last order. Page 99. We have clarified, my lord, that is on 19th of 12/2022. With reference to the subject noted above, you were directed to shift the transformer and existing electric poles from the petitioner's homestead land, as mentioned in the order dated report, without hampering the interest of the petitioner and others, as well as possible. And
that was written to you by the SDO.
Yes, this is the, my lord, subdivisional officer, not by us.
Subdivisional officer Contai wrote to you, the divisional manager WB.
He is writing you, but we want the district magistrate will make the inspection to determine whether that land belongs to petitioner or not. Number
Last order is of 12th of April, page 112. What remains after that?
That is not the order of district magistrate, lordship. That is what I want.
Anyway, district magistrate directed, you held a joint inspection. After that, what happened?
And they had accepted that it will be shifted. That is it.
No, it is not possible because lordship, we have clarified it is it is clarified that it is not possible technically. That is relied upon by the petitioner also, my lord. It is said that it is technically it is not feasible. In that event, my
Where
lord.
do you say that? Show me.
Yes, that is, my lord. That is there later, my lord. They relied upon that later. Lordship, it is perhaps, my lord, at annexed 22, divisional magistrate. Yes.
Page 110, your lordship has seen.
Yes, that is, my lord, page definition is not here, type 10. Here, my lord, with reference to the above, it is mentioned here that the work is not technically feasible, as if the high tension line from the site is removed. There will be no HT source from
Rangamati.
Rangamati Soshan to central bus stand and adjacent areas will be
That will
without
be temporary.
any power. In addition to that, Metro Retail Private Limited will remain no power due to shutdown for execution of the work.
Private
Also,
parties.
initial monetary involvement to set up such and such structure cannot be ignored.
You wrote to the subdivisional magistrate that.
This is Milord the
Since you wrote to the subdivisional magistrate, Mr.
because
Naik,
he has intimated, he has taken Milord the
no,
charge of this.
you wrote first, the reply was given on 12th of April. If you submitted to the jurisdiction of the subdivisional magistrate by writing this to him on 30th of March 2023.
But Milord, fact remains.
No.
It is clarified, it is not possible, number one, in that event compensation. WBC
No question of not possible. Now you cannot take that stand. After joint inspection having been held, specifically you have taken your stand.
My lord, kindly appreciate.
Page 109,
Not
Milord.
technically feasible, but compensation. My lord was
Where is the report of the joint inspection?
that, my lord, they have not relied upon. And we have also not received.
Is there a
my-
report at all? Why should they rely? It's your report you show.
No, all parties were there. Now,
You are the technical
Lord,
persons.
we say if it is
No.
possible at all, certainly it will be done. My lord's order is very specific. Either it is to be shifted or to pay compensation. And it is to be determined by district magistrate whether
Lord,
that
page
land,
109 once. Lordship will
whether
see
the
page
land
109.
belongs to petitioner or not. That is my lord's order. Why district magistrate has not decided that?
Do you challenge that?
No,
Did
no,
you challenge the district magistrate order?
we accept it.
If you accept it, then there is no question of
He has not
reopening that.
decided yet. Nobody has decided whether the land belongs to
Sir
petitioner.
Naik, don't play with the court. The district magistrate specifically passed an order, hold a joint
Yes,
inspection
yes.
or compensation.
No,
Now-
not joint compensation.
Let us come to the district magistrate. Page 90.
Lordship. Where is seeking compensation? Lordship? Page 98. On
Read it out.
on considering the above facts and observation, after careful perusal of the available documents and submissions, the undersigned directed WBCDCL authority to carry out a joint inspection with the petitioner to explore the possibility of shifting the transformer and existing electric poles without hampering the interest of the others. And if it is not technically feasible, petitioner may seek compensation. Yes, it is not technically feasible.
This
we
was the
have
last stand. You have accepted it. So you cannot now say that the district magistrate did not decide whether he is the owner of the land.
No, he has said
That question you cannot reopen now, Mr. Naik.
we are not opening. Let's tell exchange.
Your first submission was that the district magistrate has not decided whether he is the owner of the land.
Yes,
If you did
yes.
not challenge this order, even if you did not decide, you cannot reopen that issue.
My lord,
Your only issue
but
now
we-
is to explore possibility of shifting. There was a joint inspection. Admittedly, there was a joint inspection. Repeated communications on that. What is the report of the joint inspection?
My lord, my instruction is this, my lord, since there is no direction for if it was not, but I have taken instruction, my lord, they have clarified once
If you
again.
don't have an instruction today, Mr. Naik, it is due to appear today, then you don't have any.
No. I am appealing. They have specifically said that we have clarified to everybody. Technically, it is not feasible, but we are obliged. If the compensation part comes, we are ready and willing to comply with that. And here, my lord, hundreds of persons will be affected. That is in a letter, though in a belated stage. My lord, I bow down. It ought to have been, my lord, clarified or challenged. This is that observation. But distributor has said that either you shift it or the petitioner may seek for compensation.
Milord,
Now, if
after
it is
that,
not
page
shifted,
109 is
if it
very
is not
specific,
shifted,
Milord.
we
Page
will have to pay
109.
compensation. But my lord, the point is
Please come to page 110, Mr. Naik.
110. My lord, 110.
Now, 110, you have taken a stand with reference to the above. It is to mention that the work is not technically feasible, as if the HT line from the site is removed, there will be no HT source from Rangamati Shoshan to central bus stand,
My lord.
and adjacent areas will be without any power. Now, do you say this on a what is the report on that joint inspection? There is no reference to any joint inspection, anything.
May I
Your only reliance is on this.
may I file one short affidavit on this, lordship?
File a report in the form of an affidavit.
That will be because this report should also be before lordship.
Very well.
And that is not here.
Give a copy to them,
But
Mr.
I make
Samant
it
will-
clear, my lord, we are ready and willing. They have said me that we are, since we cannot technically kindly place this before my lord, we are ready and willing to pay compensation.
Your readiness and willingness to pay compensation, Mr. Naik, is by now legendary.
Lordship, let him
So you
file.
need not, there no authority is required for that. That you are always ready to give compensation.
No, no,
That's now legend, part of legend.
no, my lord,
So
that is,
let us see whether that applies to
they
the present.
says yes, they says, my lord, it is not technically feasible.
The
That is what they are
petitioner,
saying.
I'll direct them to file a report, Mr. Shaw.
On the last date, Lord, they had said that they will come up with a this thing.
I
It,
took time.
Took time, yes,
Yes.
time for
For
getting
instruction.
instructions.
Yes.
And my lord, can they wish away page 109?
Learned counsel for the petitioner contends that there is a checkered history in the matter, full stop. The efforts of the petitioner in shifting a high tension line and transformer from over the homestead land of the petitioner initially culminated in an order passed by the writ court, whereby the concerned district magistrate was directed to consider as to whether the homestead land belongs to the petitioner and to explore the possibility of shifting the high tension line and transformer from the said land, alternatively to consider the scope of grant of compensation. First up, pursuant to the said order, the concerned district magistrate, that is the district magistrate at Purbo Medinipur, video order dated December 7, 2022, directed the WBACDCL authority to carry out a joint inspection with the petitioner to explore the possibility of shifting the transformer and existing electric poles without hampering the interest of others. First up, it was recorded that if it is not technically feasible, the petitioner may seek compensation from the competent authority. First up, subsequently, several communications were made between the parties. First up, thereafter, the subdivisional magistrate of the area wrote to the WBACDCL, to be specific, to the divisional manager WBACDCL, Kontai Electric Division, to undertake the shifting procedure of the transformer and other relative high tension lines. However, the WBACDCL took an objection thereto and have not yet completed the transaction. Next parallel, counsel for the WBACDCL on instruction submits that the WBACDCL, although at a belated stage, had communicated to the divisional magistrate Kontai by its letter dated March 30, 2023, within bracket annexure P22 at page 110, bracket close, that due to the reasons disclosed in the said communication, it was not technically feasible to shift the high tension line from the site as, if so done, there would not be any high tension source from Rangamati Shoshan to Central Bus Stand and adjacent areas would be without power. In addition, it was stated that Metro Retail Private Limited would remain without power due to shutdown for execution of the work. Next para, whether the said contentions of the WBACDCL are sufficient justification has to be assessed in the context of the outcome of the joint inspection admittedly held by the WBACDCL with the petitioner. However, there is nothing on record to show that any report was prepared by the WBACDCL on such joint inspection. On the prayer of learned counsel for the WBACDCL, some time is granted to the WBACDCL to furnish the report of such joint inspection by way of an affidavit, with circulation of prior copy to the learned advocate for the petitioner, for a proper and complete adjudication of the lease. Accordingly, the matter is postponed till September 27, 2023, when it will be listed under the same heading, for filing of report by way of affidavit by the WBACDCL and for passing further orders. A copy of the said report shall be handed over to the learned advocate for the petitioner in advance, at least a week prior to filing of the same, to enable the petitioner to use an exception thereto, if the petitioner so deems fit. Mr. Naik, you will today we are on Fifth, sixth, sixth. So please prepare the report at least by
20th.
yes.
I'll try.
Give them a copy beforehand, before 1 week, so that they can use an exception if
My lord, I'm from the state, my lord. My lord, the police have a filed a report, my lord, and on
not necessary, Mr. Kushal.
Milord, may it be at the top, Milord, because last time.
On the same heading, Mr. Shamant.
Grateful lordship. May I accept?
They had
report
assured,
of-
they had assured that they were, that would will
That
be
is your statement, Mr. Shamant.
No,
There is
no.
no assurance on their
document.
No, if it is possible, it
on
has
your
to be done.
impression.
If it technically.
The sub-divisional magistrate that
Sub-divisional magistrate addresses the memo number.
Inspection which.
My lord, we have no personal.
And inspection was
interest.
done.
So in these matters, we also have to consider the surrounding circumstances. I mean,
No,
if
I
it's
appreciate.
really
I
not possible,
appreciate.
if a particular
Here, Milord, it
locality
is-
goes without electricity
No.
for a
Milord,
single person.
I'll tell your lordship why. They have, the other parties, they have brought in that after paying a huge amount of money. That is why they don't want that. That document will show.
Lot of consumers are enjoying.
Metro retail services appears to be a consideration.
That is one. There is others
The
also.
other aspect we'll have to consider whether that area will be without electricity if
That will be temporary, Milord. It always happens temporarily.
no, not temporary. They have taken a stand that apparently it is permanent. So let us see that report first.
For some private persons.
That's right. I'm grateful.
Obliged to lordship. Lord, may I accept one report of
And it
state?
is a before.
I do not
the
know what
wall
they are.
is constructed by petitioner,
Put-
just before that.
Who has constructed what? They have constructed what?
Boundary wall, my lord.
No, I'm not sought for any
For
report.
that, we had to go to.
I'll not look into that.
To the electricity board, my lord.
Very well.
If you collude with the electricity board, then hand over.
Grateful
Don't
lordship, I'm
call
not
it, then
accept.
don't.
I'm not
I
accept.
don't require that copy. I never directed that copy. Police, the role of police is also legendary.
I'm grateful.
Obliged to.
23.
Yes.
I like to appear for the petitioner.
Yes, Mr. Bandyopadhyay, what is that?
Milord, it's for refund
So
of.
take some time. I'll take up after returning from Jalpaiguri. Both of you are there.
This has to be decided on affidavits. I think my
That's
learned
very
friend will also.
Milord, only Milord, if I may, Milord, my client is not hearing the argument, so I will not open the facts. But if a report in the form of affidavit may suffice, then Milord, I can pray for the matter to be returnable under the same heading.
Ideally, my lord, affidavit, I don't mind.
What
my
is the
lord.
matter, Mr. Bandyopadhyay? Just open the matter.
Milord, it's for a refund of Milord service tax, which they had initially promised that they will pay us upon actual payment being made. After several rounds, Milord, of
Mr.
appeal.
Nizamuddin, that doesn't.
No, it's service tax, refund of service tax. And Milord, after several rounds before the tax authorities,
Yes.
now under a scheme of the central government named Sabka Vikas, I have made the payment of 9,76,000. After making the actual payment, now they are Milord, changing their stance and they are not agreeable to pay me the money, the refund, Milord. Though initially they had said that once you pay actually
No, it's not a case of refund, it's a case of reimbursement.
reimbursement. I'm sorry, I stand corrected by my learned senior friend, Milord.
Very well.
Milord,
You say that you acted upon their scheme and after that.
I know, not
No,
their
not,
scheme.
not my scheme.
I acted
It's
upon
a-
their
it's-
promise
it is
to reimburse.
SBLDRS scheme floated by the central government for all indirect taxes.
What are you for?
I am for HITCO.
But upon their promise, Milord, upon their promise to reimburse it to me upon actual payment, Milord. Thereafter, Milord, I have taken the statutory appeals, Milord, and under the scheme, and due of about 65 lakhs has been reduced to 9,76,000. This I've actually paid. Now, Milord, I am for the reimbursement of that amount from HITCO.
The dispute pertains, the dispute is regarding the claim of the
Affidavit.
petitioners to reimbursement pursuant to a central government scheme, which the petitioners alleged that the petitioners acted upon, on the promise of the respondent number 1. Full stop, next para. Such contentions are disputed by the respondents, respondent number 1. Full stop. Accordingly, since a prima facie case for hearing of the writ petition has been made out, the respondent shall file their affidavits in opposition within.
Within 3 or 4 weeks. 4 weeks within each other. Waited for 12 long years.
No, Milord, actually not. It's only 1 year. Only 1 year.
Within 4 weeks from date, full stop, reply if any shall be filed within 1 week thereafter. The matter shall be listed on October 17, 2023,
17th October.
17th October for hearing. Come back both of you on 17th October.
Grateful. 17 October last din হচ্ছে না?
Doctor.
24.
Only a small pair, I've served the copy.
Right.
My application under section 5(3) of the Thika Tenancy Act is not yet been decided, no hearing, nothing, it's pending since 10th February 2023. Annexure P1, page 30. Copy served. Even the miscase has not been registered. My property, without hearing that they have declared it Thika.
Why the miscase has not been registered? There is some defect in
Nothing.
it.
We have filed, we have running after.
They have not disclosed any defect in your filing of.
No, nothing, nothing, no information, nothing, no query, no letter, nothing like that.
Despite service, none appears for the respondents. The affidavit of service filed today be kept on record. Full stop. The petitioner makes an innocuous prayer for adjudication of the petitioner's application under section 5 within bracket 3 of the Thika Tenancy Act. It is West Bengal now.
Yes.
Of the West Bengal Thika Tenancy Act. West Bengal Thika Tenancy within bracket acquisition and regulation bracket close act, 2001, despite such application having been made. When did you make the application?
10th February, on the top is the seal is there. Page
On
30.
February 10, 2023, before the Thika controller, Howrah. Full stop. Accordingly, WPA 12970 of 2023 is disposed of by directing the respondent number 2, the controller, Thika Tenancy, Howrah, to allot a number to the petitioner's application under section 5 within bracket 3 of the 2001 Act as annexed at page 13 of the present writ petition, and to dispose of the said application expeditiously in accordance with law, upon giving opportunity of hearing to all concerned, including the petitioner. First up, it is expected that such adjudication shall be completed within an outer limit of 3 months from the date of communication of this order to the respondent number 2. Full stop, no rest to cause urgency. Thank you.
$25.
I pay for the state.
State, right. Yes,
Well,
Mr. Chaudhary, what is the matter?
This is my application pending, my lord. Before them, my lord, made a representation, my lord, alleging, my lord, the encroachment of, my lord, the public road, my lord, to be, my lord, taken by the Public Works Department. I have made a details complaint, my lord, that is at page 23.
So that has to be inquired into.
That inquired into, that nothing has been done, my lord. This will be inquired into, my lord, and to take step under
You're the
section 10.
enclosure.
I have.
Why did you encroach in the
I tell you, I have two submissions regarding the maintenance of the petitions. Now, kindly hear me 2 minutes.
Yes.
Now, I will satisfy your lordship. But he has made representation before whom, kindly see page 23. Executive engineer. Number 4, executive engineer. Now, kindly section Highway Act, your lordship.
I must have somewhere here. You read out.
Section 2, subsection D. Highway authority means the authority appointed under section 5. Now, section 5 provides the state government may, by notification the official gazette, appoint one or more officers to be a highway authority for the purpose of this act. Now, I am giving this notification. Kindly give this notification. Can you see this notification? This is the.
Give me half a second. I'll. Oh, no.
I have bought this book. Kindly.
Very well, I'll take it from you. Yes. A notification? What?
This is the departmental notification, not the gazette notification. This notification can you see in exercise of the power conferred by section 5 of the West Bengal Highway Act. Here to refer to the governor is pleased to hereby to appoint with immediate effect the highway authority, which is the meaning of the clause D of section 2 of this act as mentioned in column 4 of schedule below, in respect of the road as mentioned thereafter. Now can you see next page, serial number 27. Meshida Tomlug Road. My learned friend is claiming that this is the high road. Now, who is appointed? Executive Engineer Tomlug. Now, to whom he made a representation. Now, my specific submission is that this is a departmental notification. Highway authority has been defined in section 5. That has to be a gazette notification, not a department notification. Therefore, he has made a representation to a RE authority.
not an wrong authority. He is not the authority at all. Because the Calcutta Gazette notification has to be issued by appointing a higher
Who is the
authority.
authority now, as of today?
No, Gazette notification has not been published as yet.
So there is no authority.
Yes,
You say no proceeding can be taken out under the highways. Right?
yes. Your lordship cannot directly wrong authority to concern representation. Therefore, section 5 clearly provides.
What do you say on that? You are the state. Cherry do, no.
And they have written the block land and land doctor to demarcate the river.
Do you have extra copies of this?
This authority has gone to power under the Highway Act. He has not been appointed by Calcutta Gazette notification. By a department, he cannot do so.
Yes, what do you say to this point?
No, my lord, if you also kindly come to my lord representation, this was my lord made my lord not only my lord the executive engineer, but district magistrate, subdivision officer, including my lord the executive engineer. Now, my lord, also kindly come to section 10. My lord, which this provision can be invoked, my lord, section 10. My lord, if my lord, taking my lord senior friends, my lord, point my lord to be considered, my lord, even then, my lord, no communication made by the executive engineer, my lord, look, this, I'm not a person, my lord, to take into action, my lord. You take appropriate step, make an application with appropriate authority. These are the appropriate authority. My lord, she knows, my lord, in an application, my lord, even my lord, RTI today, my lord, the files are sent, my lord, to the appropriate authorities. My lord, even my lord, communications are made, my lord, to the authorities, my lord, to the applicant, my lord. You make application before this authority. I'm not the authority. I do not know, my lord, what my learned friend today, my lord, has referred to, my lord, but section 10 application, my lord, can be taken up, my lord, by any person, my lord, appropriately, my lord, empowered, my lord, to take this action.
Section 10 kindly by a higher authority.
My lord, this, my lord,
Section 10 kindly see. Section 10B. And see the higher authority or an officer authorized by him. The higher authority definition section 2D. And section 2D clearly reflects that section 5 will be applicable. And section 5 provides that the higher authority has to be appointed by Calcutta Gazette notification. Therefore, this authority who has issued a letter, he has got no authority at all. By virtue of section 5.
My lord, my responsible submission, my lord, why my lord, the respondent is signing away, my lord, for making an inquiry, my lord. He has, my lord, encroached, my lord, my entire property. I have, my lord, entire ingress and egress has been blocked. My lord, he is taking some technical point, my lord, restraining authority, my lord, to take provision under section 10.
The petitioner contends that the petitioner gave a representation to the respondent authorities alleging illegal encroachment of public land by the private respondent. Full stop. Accordingly, comma, it is submitted, comma, proceedings ought to have been drawn against the private respondent under the West Bengal Highways Act, comma, 1964. So next para, learned counsel appearing for the private respondent cites a notification, an internal notification published by the publisher. Stroke 440-R/PL dated August 11, 2015, in exercise of the power conferred by Section 5 of the 1964 Act, comma, whereby certain authorities were designated as authorities under the 1964 Act, full stop, by placing reliance on serial number 27 of the second page of the document handed over, comma, it is argued that for the Mecheda Tumluk Road, comma, which is the territory regarding which the petitioner alleges encroachment, comma, the executive engineer, comma, Tumluk Highway Division and the assistant engineers under Tumluk Highway Division having jurisdiction of the road have been authorized to act under such provision. So, however, comma, in the absence of any gazette notification, comma, it is argued, comma, which is a prerequisite under section 2 read with section 5 of the 1964 Act, comma, there is no authority as present at present, comma, which has been notified by the appropriate government under the said act. Full stop. Hence, comma, the present writ petition, it is argued, is misconceived. Full stop. Next para. Learned counsel appearing for the state hands over communication by the assistant engineer, Tomluk Highway Subdivision, dated June 21, 2023, where it has been indicated that the said official had requested the block land and land reforms officer, comma, Nandakumar, comma, post office and police station Nandakumar, comma, district Purbo Medinipur, for early demarcation of government plot, but no reply was made by the BL and LRO. Full stop. The department, comma, it is indicated, comma, will act for removal of the unauthorized encroachment, comma, if any, under the 1964 Act, after receiving the demarcation report of the government plot from the concerned BL and LRO. Full stop. Next para. Even without going into the question as to whether the respondents and or the addressees of the representation of the petitioner have authority under the 1964 Act, comma, the allegation of the petitioner is more basic, comma, to the extent that the private respondent has allegedly encroached upon public property. Full stop. Next para.
No, only one thing, only one thing. Tell me. I have got the proof photocopy. These ingress and egress has not been.
No, those are all different.
Has not been ampered.
Next para.
Has not been prejudiced.
Next para. At this stage, comma, it would be premature for the court either to go into the merits of such allegations and or to hold either way regarding the jurisdiction of the appropriate authority. Full stop. However, comma, since an allegation has been made, comma, it would only be appropriate if the concerned district magistrate undertakes an inquiry and, comma, upon the depending on the outcome of such inquiry, comma, if necessary, referred the matter to the appropriate authority under the 1964 Act for taking out proceedings for removal of encroachment. Full stop. Hence, comma, WPA 13056 of 2023 is disposed of by directing respondent number 2, comma, the district magistrate Purbo Medinipur to call for a report from the concerned block land and land reforms officer and on the issue as to whether the private respondent is actually in unauthorized occupation of or has encroached upon any public property. Full stop. Upon such report being received, comma, if the district magistrate is prima facie satisfied that there is some encroachment, comma, the district magistrate shall within a week thereafter, comma, refer the matter to the appropriate authority under the 1964 Act for taking out proceedings immediately for removal of such encroachment. Full stop. Next para. Such exercise shall be concluded by the respondent number 2 within 8 weeks from the date of communication of this order to the respondent number 2. Full stop. Next para. It is made clear that the allegations made in the writ petition and the counter allegations made by the private respondents have not been dealt with on merits, and it will be open to the appropriate authority, comma, if referred to by the district magistrate upon the above inquiry, comma, to look into the matter independently upon giving adequate opportunity of hearing to all concerned and in accordance with law. Full stop. The report be filed today be kept on record. No arrest.
Only one jurisdictional point has to be taken at the time of
Will itself at the time of?
hearing. You know,
No, at the time of encroachment. Removal of the
No,
encroachment.
jurisdictional point. Jurisdictional point has to be taken at the time of hearing. Because this is
Definitely.
that's why also kindly clear.
Everything will be taken care of.
Let it be kept, all points be open at the time.
All points have been kept open. I cannot decide any point here, Mr. Datta. I have made it repeatedly clear.
Only one thing, my lord. If any reason order be passed, my lord, that is to be communicated to the parties, my lord, by the district magistrate.
You don't have a right. You are only the complainant. You are a busybody. You are trying to disturb him.
Not at all, my lord.
No, no, you're not entitled to any outcome communication. Thank you. Please give all the appearances.
26.
Yes, 26.
Well, I am for the petition.
Right.
When a petitioner already directed my lord, station manager of Dukin Bharata CC, on page 15.
What is the affidavit of service?
Every earlier I have
File. কোথায় গো affidavit of service? এখানে আছে? হ্যাঁ, আছে। Yes, sorry. Which page?
page 15, my lord.
15.
The station manager already directed to deposit the money. Petitioner already directly deposited. In spite of my lord, they did not give the connection.
One-time waiver scheme.
Yes, ma'am.
Waiver of your dues.
Yes, ma'am.
So now what do you want?
My lord, I have deposited the money.
What do they have to do?
In spite of they did not give the connection.
Yes, what?
My lord, in this matter, private respondent number 4, written objection, my lord.
We have served the copy of the private respondent.
Who is the private respondent?
Private respondent, I have served the copy of the private respondent. But I have no objection if they, my lord taking the connection, I have no objection.
They have objection.
What? I don't know.
Not the private respondent. How do I?
No, my lord, I have already given the connection already, and I have served the copy of the private respondent. All the copy, my lord, they have received.
Even if you have served a copy on the private respondent, they may have a dispute regarding your connection. Let us see what is the dispute. I confer on you the honor of reading this out. এটা অরিত্র ওনাকে দাও। Please read it out. Give a copy to your learned friend, Mr. Ghosh.
ঝড়ে আমার ভাইপোর পাঁচু গোপাল সাপুইর বিদ্যুতের কেবল তার ছিঁড়ে গিয়েছিল। আমি উদয় সাপুই জুড়তে দিইনি। বিদ্যুৎ অফিস থেকে লোকজন এসেছিল কারণ আমাদের জায়গা জমির সমস্যা আছে বলে। জায়গা জমির সমস্যা মিটলে বিদ্যুৎ লাইন জুড়তে দেব। তার জন্য বিদ্যুৎ কর্মী লাইন।
Thank you. That is sufficient. I'll take that on record. Now, Auditro. Learned counsel for the petitioner Damadao. Learned counsel for the petitioner argues that the petitioner deposited the due amount in terms of a one-time waiver scheme floated by the state government. But despite such deposit, the electricity connection of the petitioner is not being given. Of next para, learned counsel for the WBSCDCL hands over a copy of a written objection by the private respondent number 4, which indicates that the private respondent number 4 boldly asserts that he had objection to such connection being given due to disputes regarding land and property, and that he had deliberately prevented the WBSCDCL personnel from giving the connection to the petitioner. Next para, mere existence of land dispute or property dispute is not an excuse for preventing a person from enjoying electricity, which is a basic right associated with the fundamental right to life. Next para, moreover, section 43 of the Electricity Act 2003 confers such right on an occupant. Next para, in the event the private respondents have any dispute regarding land, it will be open to them to approach before the appropriate authority canvassing such dispute. However, the petitioner is otherwise entitled to electricity connection, having deposited all dues under the one-time waiver scheme. Accordingly, WPA number 13162 of 2023 is allowed, thereby directing the WBSCDCL to give a new electricity connection to the petitioner within 3 weeks from date. In the event the WBSCDCL personnel are prevented from doing so by the respondent numbers 4, 5 and or their men and agents, it will be open to the WBSCDCL personnel to approach respondent number 3, the inspector in charge of the Joynagar Bokultola police station, who will provide adequate assistance of full strength to the WBSCDCL to give such connection to the petitioner. Next para, the cost for such police help shall be borne by the petitioner. Next para, it is made clear that nothing in this order or the electricity connection, when given to the petitioner, shall operate to the detriment of the rights and contentions of the parties before any civil forum or court, comma, if approached for resolution of the disputes of the title disputes between the parties. Full stop, next para. In the event the private respondents have any other dispute to such electricity connection, comma, it will be open to the private respondents, comma, after the connection is given, comma, to approach the concerned district magistrate in due course of law and ventilate their grievances. Full stop, if so approached, comma, the district magistrate shall decide such issue in accordance with law upon giving opportunity of hearing to the petitioner as well as the objectors. Full stop, no orders to cause answer. Thank you.
27.
My lord, I'm appearing for the petitioner.
Yes.
My lord,
I
I'm,
declare for the respondent number 5.
Yes.
my lord, I'm handing over my affidavit
Right.
of service.
What is the matter, please?
My lord, the petitioner appeared for an Gram Panchayat Kormi recruitment process, my lord. And in the recruitment process, my lord, petitioner went till the interview process, and then in the merit list, his name didn't come out. So when he made an RTI before the RTI respondent authority, my lord, they rejected, they have answered certain questions, my lord, and 3 questions they have rejected on the ground that is a third party information, my lord. My lord, kindly comes to page number 36 of the petition, my lord.
You prefer the first appeal, what happened to
Yes, my lord, I have gone to the first appeal. The first appellate authority has also accepted the SPIO's order. And my lord, I went before the SIC. SIC has not answered to my petition or prayer.
So I'll direct your appeal to be decided. Your second appeal is pending now.
Yes, my lord. I made
Let us see what is the objection. Yes, what is your objection to this? Page
My-
36.
No, I have no objection. Well, I am the second appellate authority. I am yet to
No, no,
admit.
you-
Yes.
right. So I'll direct the appeal to be decided early. When was the appeal preferred?
But if your lordship,
January, my
if your
lord.
lordship
In the
is
month
of the
of
opinion that the objections taken by the SPIO is not feasible in the eye of law, your lordship can directly direct the SPIO to.
SPIO is appearing. Is
The
implicated here.
SPIO is to be represented through the state lordship.
So you are also for the SPIO.
No, not exactly. I am for the second appellate authority only. That's my number 5.
Satisfy me from the act that these are not valid grounds.
My lord, they have said that 3 points, my lord. I have asked for OMR sheet of the last impanel candidate, and I have asked for the OMR sheet of the all the impanel candidates in the merit list. And I have in my last question, my lord, in page number 37, that is point number 8, I have said names, roll numbers, and marks
Please come to
obtained.
page 38 once.
Yes, ma'am.
38. What are the points you are aggrieved with?
My lord, point number 5, 6, and 8, my lord. They have said all this is third-party information, my lord. My lord, my claim is that this is not third-party information. This is the respondent authorities. It is under the respondent authority, my lord. And I am not asking for personal details like address, phone number, blood group, or any medical information. I am asking for a transparency in the recruitment process that I have participated, my lord. And my lord, this honorable court has many times passed orders to publish OMR sheet, my lord. I have a judgment, my lord, if your lordship wants to go through it once.
Cite a judgment. Yes.
My lord, it is not reported. It was given by Honorable Justice Abhijit Gangopadhyay, my lord. And here his lordship directed the publishing of 5,500 OMR sheet in the official site of the West Bengal School Service, Central School Service Commission. My lord, I'm not asking for publishing.
There must
I
have
am
been some
just,
serious allegation in that matter.
yeah, my lord, I'm not asking for publishing. I'm just
Let
asking
us
for
see the
the
context of the judgment. Must have been some serious allegation against the entire authorities. This is not such a case.
Yes.
It's an individual
My lord,
request.
even if the OMR sheet is not given, my lord, question number 8, my lord, where I am just asking for the marks of all the candidates, which should be revealed in the merit list, my lord, that can be answered to, my lord, by the authorities. And as most recruitment process, they allow at least the giving of marks in the merit list, my lord, of the written examination, interview, and
Yes.
that is
8 is justified.
my lord. If that is also directed, I would be grateful, my lord.
5 and 6 I won't give, but 5 is you have asked for the copy of the OMR sheet, digitized data, model such and such of the last impaneled selected candidate.
Yes,
Only
ma'am.
that, no, I'll not allow. And kindly provide a copy of the OMR sheet.
Of all the
digitized-
impanel candidates, my lord. My lord,
OMR sheet, no.
then my lord, 8.
8 definitely, yes.
Keep
You're
it.
right. Thank you, Ms. Rose. The grievance of the petitioner is that the petitioner applied for certain information regarding an examination which was taken by the petitioner himself as well but the petitioner could not succeed in. Full stop, next para. It is argued that the queries were substantially answered by the SPIU, but for 3 of the queries. Full stop. By placing reliance on the queries of the petitioner annexed at page 36 of the writ petition, comma, it is argued by learned counsel that all the queries made by the petitioner were justified and could not have been refused on the ground of those pertaining to third-party information. Full stop, it is argued that the question numbers 5, 6 and 8, which were refused on such ground, relate to an interest, relate to a legitimate interest of the petitioner as a participant in the examination process and for the sake of transparency. Full stop. Upon the first authority having refused to give proper information on the said 3 queries, the petitioner approached the first appellate authority, which upheld the decision of the first authority, upon which a second appeal has been preferred but is pending. Full stop, next para. The second appeal has been pending since last January. Full stop. It is submitted by learned counsel for the second appellate authority that the second appellate authority is hard pressed due to heavy pendency of matters before it. Full stop, next para. Instead of relegating the matter to the second appellate authority, since all concerned have been served with notices, which is evident from the affidavit of service filed today and kept on record, I choose to ascertain the veracity of the claims of the petitioner on the 3 queries which have been refused. Full stop, next para. Insofar as query numbers 5 and 6 are concerned, those seek for the OMR sheets, digitized data and model answer key with regard to the successful candidate as well as all other candidates. Full stop. However, the production or furnishing of the OMR sheets themselves might pertain to third-party information and was rightly refused by the authorities. Full stop. Insofar as the last query is concerned, the petitioner sought for being provided with the names, roll number, marks obtained in written examination and marks obtained in interview of all candidates who have been selected empaneled in the district level selection committee P and RD section Uttar Dinajpur for the post of Gram Panchayat Kormi. Full stop. Next para. In any event, the said could not have been refused on the ground of being third-party information, as the results of the examination are required to be put on public forum in any event, to ensure transparency in the act of the state. Full stop. Next para. Hence, instead of keeping the second appeal pending unnecessarily, WPA 13204 of 2023 is disposed of by directing which authorities to be directed? 3.
Yes, ma'am.
Directing respondent number 3 to furnish the information sought by the petitioner under query 8 of annexure P2 at page 36-37 of the writ petition and furnish the names, roll numbers, marks obtained in written examination and marks obtained in interview of all candidates who have been selected empaneled in the district level selection committee P and RD section Uttar Dinajpur for the post of Gram Panchayat Kormi. Full stop. Such information shall be furnished to the petitioner at the earliest, positively within 4 weeks from the date of communication of this order to the respondent number 3. Full stop. The respondent number 3, over and above such compliance, shall endeavor to publish the said results on any public forum, either by newspaper advertisement or by uploading the same on any website, if available to the respondent number 3 on such score. also within 4 weeks from the date of communication of this order. No orders to cause.
Deeply grateful, my
Lord, by virtue of this order, the pending second appeal will be.
Very right. I am disposing of the second appeal.
Yes, ma'am.
By virtue of this order, comma, needless to say, comma, the pending second appeal of the petitioner stands disposed of and shall be treated to be so by the second appellate authority.
Deeply grateful, my lord.
Grateful.
Next. Oh. Original set, sir.
Matter on Friday, Mr. Dutt was appearing on the last occasion. These 5 matters, my lord, are similar matters, my lord, if they can also be listed along with
Original side.
original side, my lord. I have informed Mr. Dutt, I'll be mentioning he's not in Kolkata, my lord.
Which Mr. Dutt?
My lord, Mr. Jatinder Singh Dutt, on Monday
Oh,
with
Mr.
regard
Dutt,
to,
right, that.
my lord, 206, your lordship was hearing.
Yes.
My lord, I have tick marked, my lord, those 5 matters, my lord, from the.
Thank you. বুঝতে পেরেছি তো? একদম, একদম. Thank you.
Grateful, my
Yes.
Any other mentioning? Original side, for judgment, item number 1.
In such view dismissed, Mr. Banerjee. Dismissed. সার্ভার করতে পাঠিয়ে দিতে হবে।
Court application under Article 226, item number 2 and 3.
Yes. You are for the petitioner?
In this year. Yes, ma'am.
Yes, review committee, up to review committee or what?
After review.
Excellent.
Mr. Saha was addressing, your lordship, he
Oh, oh, oh.
completed.
Right, right.
And
Yes, Mr. Right.
I had begun, my lord.
File written notes of arguments after 2 weeks, Mr.
Yes, yes, my lord.
Yes, yes, Mr. Right.
Yes. Your lordship will kindly take. My lord. Page 272. Rather, my lord, 274.
Yes. 74.
Which was made, my lord, against the writ petitioner, my lord, rather the borrower, my lord, of whom the writ petitioner is the promoter. The borrower is a company, writ petitioner is a promoter. My lord, the allegation was that the unit has defaulted in meeting its payment or repayment obligations to the lender, even when it has the capacity to honor the said obligations. Now, my lord, this was explained as below. As per balance sheet, as on 30th of March 2016, 31st of March 2016, 31st of March 2017, and 31st of March 2018, the company was having total revenue from operations of rupees 253.98 crore during the financial year 2015-16 till 17-18 as per balance sheets dated 31st of March 2016, 31st March 2017, and 31st March 2018. But the credit summations in the company's cash credit account during the same period were rupees 25.16 crore only. Thereafter, my lord, a chart is given where the revenue from operations, my lord, has been mentioned, and the credit summations, that is, my lord, the credit entries in the cash credit account upon the sale of the teas, my lord, is supposed to have gone, my lord, have been shown. And thereafter it is said that the funds available with the company,
by way of proceeds from sales realizations have not been fully routed through the account and not used for reducing the loan outstanding. Now, my lord, this was a cash credit account. Lord, before I proceed further, my lord, may I just give your lordship, lord, a brief idea, lord, of how a cash credit account operates, lord, because that will be important, lord, to demonstrate this. My lord, this is an extract, my lord, from Tannen's banking manual. Your lordship will kindly take, lord, turn over the page. My lord, there is a heading at the bottom, cash credits, overdrafts and loans. Now, my lord, cash credits has been defined. Advances by Indian banks generally take the following three forms, that is cash credits, overdrafts and loans. A cash credit is an arrangement by which a banker allows his customer to borrow money up to a certain limit against the values of his stocks and book debts for his day-to-day requirement. My lord, it's important, against the values of his stock and book debts. My lord, those form, my lord, the securities. That is, my lord, whatever he is producing.
But it will have to be a carved line.
My lord, there is,
If I underline, it has to be a carved line.
my lord, there is a typed copy also, my lord, I missed.
Yes. Thank you.
I'm sorry, my lord.
Straight line I can draw if I try a lot.
My lord, I have drawn it.
Wavy line accurately, it's very difficult.
My lord, because of the thickness, my lord, this is how it comes.
You took it from the Tannen's thing.
Yes, yes, my lord.
Yes, anyway. So borrow money up to a certain limit again.
Limit
yes.
against the value of his stocks and book debts for his day-to-day requirement. This is the most favorite mode of borrowing by large commercial and industrial concerns in India, on account of the advantage that a customer need not borrow at once the whole of the amount he is likely to require, but can draw such amounts as and when required. He can put back any surplus amount which he may find with him from time to time, for the time being. The banker granting cash credit limit or CC limit and overdraft facilities has to estimate the amount of his customer's requirements, and in case the actual drawings fall much below its estimate, he may lose interest on the funds remaining idle. That is, not a limit is sanctioned. If he draws the entirety of that, lord, he'll have to pay interest. Lord, if he does not draw the entirety of it, something remains as a credit balance, then in that case, lord, the bank will be losing interest on that because that sum has been kept apart and not used. In this case, my lord, the entirety of it has been used. What was required was to be routed back through the account. My lord, it appears that the revenue from operations in the 3 years which were given were to the tune of 253.98 crore, and what has, my lord, found route into the accounts is only a sum, my lord, of 19 crore. My lord, this is what was asked, my lord, to the borrower to explain. And the borrower, my lord, goes on explaining in my lord, in different paragraphs, saying that, my lord, it was a company which suffered losses. This is not a question, my lord, of having suffered losses or not. My lord, you have sold your teas. Upon selling the teas, my lord, the cash which you received is something which is tangible. My lord, loss or profit, my lord, is an accounting concept, my lord, an accounting method. My lord, the money which comes from the teas sold, that has come. Where has that money gone? It has not found root in the accounts. You said that you have sold this much of amount. The tea, my lord, stood security for the amount that we sold. Lord, I shall show, my lord, from the balance sheet also that, Lord, that was the case. Where has the sum gone, Lord? This is the question, Lord, which the bank puts. The answer to it, my lord, is nothing. It says, my lord, that we have suffered losses. And, Lord, we are asked to believe this. And we are said, my lord, that since you have not dealt with this, the order is unreasoned order. My lord, the question itself is the answer, if, my lord, it is not explained. Now, my lord, kindly take, my lord, volume 4. Lord, kindly take, Lord, page 446. Or I'll just, my lord, recapitulate. This was lastly placed also.
Yes.
Lord, page 446. Your lordship will find, my lord, at the top 10A, long-term loans and advances. At the left-hand side top.
Right.
Now, my lordship will kindly, my lord, scroll down to, my lord, there are 3 blocks. Under long-term loans and advances, there is 1 block. Then after, my lord, there is something starting with C, my lord. I cannot make out what it is. Your lordship will leave that. Thereafter, my lord, there is another block which says loans and deposits, note I below note 21. My lord, in the same line, my lord, about the, if we can call it a paragraph, my lord, the 3rd paragraph from top. Loans and deposits.
Under long-term.
Yes.
Under
my lord,
that.
Yes, my lord. Under long-term loans and advances, my lord, long-term loans
Loans
and
and
advances.
deposits, note 1 below and.
Yes. This. There, my lord, your lordship will kindly see the second heading, considered doubtful,
Yes.
including related parties, of rupees 1791.75 lakhs. Therefore, my lord, this is loan given by the company to related parties. This is considered doubtful. My lord, the company has capacity to lend out money. The company, my lord, says that it is suffering losses.
This is a part of what?
This is a part of the company's balance sheet.
Right.
So, my lord, lordship will find at the right-hand side, the sum lent by the company is 2519.45 lakh. Therefore, my lord, 25 crore. Of this, my lord, 1791.75 is doubtful, which the company will not be able to recover. And your lordship will kindly, my lord, scroll down a little more. My lord, there is something which is called total. Thereafter, my lord, loans and deposits include rupees 1080.97 lakh outstanding from Santipara Tea Company. My lord, this Santipara Tea Company is a related party. Given in the earlier years, pending restructuring and other prospects then under consideration, considering the financial position and recoverability, etc., the amount has been fully provided during the year. So, my lord, provision has been made. We will not get it. So, this, my lord, forms a part of losses. This will be projected, my lord, to vouch for the revenue for operations, the amount, my lord, received in revenue for operations not being routed, my lord, through the bank account. Lord, where has the money gone? I could have understood.
I don't understand the last point, Mr. Rai.
My lord,
loans and deposits include rupees such and such outstanding.
Yes.
From Shantipara Tea Limited, Company Limited.
Given in earlier years.
Yes.
Pending restructuring and other products then under consideration. Other prospects then under consideration, considering the financial position and recoverability, etc., the said amount had been fully provided for during the year.
How does it have a bearing on this?
Yes, my lord, this has been provided for means it's written off. Provision has been made that this amount will not be recovered by the company anymore.
Bad debt sort of.
Yes. So, my lord, the company has suffered loss to this tune. My lord, this loss is attributable to what? Attributable to a loan which is given by the company. My lord, loan is given by the company when the company takes a stand that it could not repay the loan because it is suffering losses.
No, loan. The question is whether the loan was given prior to the taking of loan from you.
No, my lord, my loan is from 2006-07.
Fair.
And this, my lord, this is of this balance sheet, my lord, pertains to the accounting year if your lordship turns over the turns, my lord, the previous page 445. This is as on, my lord, right hand side top 31st March 2016. So, my lord, this is the year under consideration, my lord, of the willful defaulter, my lord, committee. So, my lord, it is in this year, my lord, that they have made provisions for it also. My lord, this accounts for a portion of losses that is, my lord, that the company, my lord, states to have suffered. Lord, this your lordship will find in the losses also. If your lordship sees, your lordship will kindly take 449.
Yes.
But 449, my lord, the first caption, revenue from operations. Lordship is fine. Yes. Sale of tea, 12045 from 38. My lord, this is the amount which they have, my lord, got upon selling the teas. My lord, these teas were the stocks. My lord, which I showed to your lordship, my lord, that the money which has been loaned out by the bank is against the value of stocks and book debts. Stocks and book debts. Then thereafter, my lord, sale of green leaf.
Total comes to 12 crore.
Yes.
12.8.
And my lord, thereafter, my lord, this is by way of, my lord, accounting methods. My lord, things are set off. Your lordship will kindly take page 450. My lord, other expenses. Your lordship will scroll down. Provision, my lord, about
For doubtful advances.
yes, doubtful advances. So, my lord, what I want to submit, my lord, before your lordship is this. My lord, this having suffered loss, setting off one against the other, my lord, these are all accounting methods. My lord, the money that has come from the selling of teas is real.
But can you isolate the money which they earn? I mean, from their entire business operations. It's a business. It's not a personal loan.
Yes.
Now they're running a business. Balance
Yes.
sheet is maintained.
Yes.
These loans are coming back. I mean, in any event, they have to set off those loans.
Yes, yes. Let them set it off.
So
Lord, but if I so
business operation cannot be waived by them all on a sudden because
not at all. I'm not saying that.
they cannot isolate that in income and
Definitely.
pay it to you like that.
Definitely, I'm not saying that.
Hmm.
Lord, what I'm saying is, if I have sold teas,
Yes.
if I have sold teas,
That is
Lord,
their
that's-
income. That is their business.
Yes, my lord, where has that money gone? That will not find vent, my lord, in the account from which the money has been taken to, my lord, procure the teas, or, my lord, to manufacture it. My lord, the cash credit account is for that purpose only. It is against the value of stocks.
So you say even if it is adjusted or whatever
Yes,
is
it has.
reflected
It
in the
should
balance
be.
sheet,
It should have
be
been
routed through you.
Yes, yes, that is what it means.
All right. The payment has to come
Has
to
to
you.
come to you, or it has to be shown to me, my lord. Then I can understand.
After
Lord.
that, whatever adjustment they make.
Yes.
All right.
I can understand, my lord, that from the same parties from whom they have, my lord, purchased, to whom they have granted loan, my lord, they have purchased teas and they are setting it off. Lord, where is that case?
So this amount never came through to your
It
bank.
doesn't show, my lord. That is what your lordship will kindly take, my lord, the page once again, page 274. Page 274.
Right. That revenue from operations.
Revenue
is
from
referred to
operations, my lord, is 129.39.
Yes, yes.
The credit summation below that, my lord, is 19.45. My lord, where has the balance 119 crore point 119.39 crore gone?
So you received only this
Yes.
19.45 was channelized to you.
Channelized through my account. Not in the next year, it's 44. My lord, what has been channelized is 2.64.
Very good.
So this is the pure, my lord, this is the simple question that has been put to them. Whether you have suffered losses, whether you have gained something or not. My question is, where did that money go? Where is the explanation?
Right.
My lord, in the my lord, in the second column, your lordship will find the explanation given by them. My lord, I labored hard, my lord, I could not find anything on this, my lord. My learned friend also, my lord, on the last occasion did not show this. If your lordship recalls, my lord, what was submitted was that the company has suffered losses. Therefore, my lord, in my very respectful submission upon this kind of a question being answered in this fashion, no other reason is required. I say that you have not been able to answer the question. My question was very perfect, my lord. My question was explanatory. The questions themselves contain the reasons, my lord, if they are not answered in the manner they are required to be. I have put a detailed question that this is the revenue operation. This is the credit summation. Where did the money go? You have not routed the entirety of it.
They have said something regarding to defray operational expenses and running tea estates.
Lord, where is the calculation? Defray operational expenses, Lord, out of 19.5 crore and 129. How much? There has to be a ratio. Where is this explanation, my lord?
Very good. Forensic audit. Yes.
No, my lord, it is in the light of this that the second ground, my lord, becomes important. Your lordship will kindly turn over the page, my lord, 278. routing of funds through any bank other than the lender bank or members of consortium without prior permission of the lender. Now, my lord, said the company is maintaining a current account with ICICI Bank, Darjeeling branch, as informed by the resolution professional in the notice of 6th COC meeting. Hence, it is evident that the company did not route the entire sale proceeds with the lender banks. Instead, the funds were routed through banks other than the lender banks without the prior permission of the lenders. Now, my lord, an answer to this is, to ICICI Bank, whatever was routed through the SBI CC account only.
You don't have a branch in Darjeeling?
Lord, I should have. And my lord,
What was placed by them is that the ICICI Bank Darjeeling branch was maintained for operational convenience of gardens.
Very well.
Because it was physically proximate. I mean,
then also it does not explain, my lord, if this is for operational operation, and my lord, the defrayment, my lord, of the operational expenses, and the contention here, my lord, is that through ICICI Bank only a paltry sum, my lord, was transferred. Then in that case, my lord, it answers your lordship's first question that, my lord, it was used for operational convenience, or my lord, for defraying operational expenses. My lord, if this is paltry, what fines went, my lord, in the CC account is paltry, then, my lord, where did the, my lord, major amount go? My lord, I am fully justified in putting this question, my lord, to the borrower, because this is not my money, it's public money. My lord, I stand, my lord, responsible to it, my lord, for it, my lord, to the public. I have to pay my depositors. Somebody, my lord, who does this, my lord, has to answer it in the manner required. This is not the manner of, my lord, answering. Then you come up before the court, my lord, and you argue that, my lord, this is unreasoned. Your answer has no reasons worth being dealt with. Now, my lord, this takes us, my lord, to the third ground. The third ground was page 279.
Yes.
The unit has defaulted in meeting its payment or repayment obligations to the lender and has also disposed of or removed the movable fixed assets or immovable property given for the purpose of securing a term loan without the knowledge of the bank or lender. The borrower company entered into a marketing cum management contract agreement with Nagrigram Tea Company Limited for the Maribong Tea Estate on 5th of July 2013. Further, the borrower company also entered into a management contract agreement with Merico Agro Industries Limited vide agreement dated 29th of January 2018 for Hantapara and Garganda Tea Estates, 20th of July 2018 for Tulsipara Tea Estate, and 19th of August 2018 for Dhumchipara Tea Estate. Under the above agreements, the borrower company gave entitlement for entire realization from the sale of tea produced and manufactured from the said gardens to the assignees, and also the company shall pay a sum of ₹1 per kg in respect of the green leaves grown and or produced in the said tea estate to Nagri Farm Tea Company Limited and to Merico Agro Industries Limited for the respective tea estates managed by them. Further, the borrower company also authorized the above mentioned parties to pay all the dues of the workers, employees, etc. for the operations of the tea estates and the amount received from the borrower company under the agreement. All these agreements were entered into by the company without approval from the secured creditors, and this leads to alienation of the properties charged to the secured creditors as income generated from these tea estates did not go towards reduction of loan availed by the company. My lord, the teas, my lord, at the cost of repetition, my lord, I say that the teas which were produced in the farms, and my lord, even the made teas, as it is coined, my lord, stood security for the bank's loan. My lord, these were supposed to be routed through the accounts of the banks. My lord, through these agreements, the entire management, my lord, of the tea gardens was, my lord, handed out or doled out to a third party. My lord, so far as the other agreements are concerned, my lord, I don't have a legible copy, but one copy, my lord, which was furnished by my learned friends, my lord, in their affidavit, supplementary affidavit, which they used in the first round of this litigation, my lord, is there. It's available. My lord, this is the second round. At the show cause stage, my lord, this matter had come up before your lordship. They had used a supplementary affidavit to which, my lord, this was an annexure. I'm handing up to your lordship, my lord, this agreement, which is dated 5th of July 2013. I'm reading from their affidavit only. Lord, on the last occasion, Lord, if your lordship kindly recalls, Lord, it was sought to be submitted before your lordship that because of a notification issued by the government of India, Lord, whereby, my lord, the tea board was supposed to take charge of the tea estate, Lord. The matter had come up before this honorable court. The company itself had challenged the notification, and Lord, it was by dint of the honorable High Court's order that these agreements were entered in. Lord, this
Workers
was,
were not being paid and all this.
yes. Now, my lord, your lordship will kindly have a look at that order once, my lord, just for the sake of completion and continuity. But the order is at page. What is 241? No. Not 241, Lord, I'm sorry.
297.
297. Yes. Lord, 297. Your lordship will kindly take, my lord, 298.
Yes.
But kindly see, my lord, the notification which was issued by the government that has been quoted. Lord, paragraph 2 of the order. The dispute commenced with a notification dated January 28, 2016, issued by the Ministry of Commerce and Industry, Government of India, by which the following order was passed. Now, therefore, in exercise of powers conferred by subsection 1 of section 16E of the Tea Act 1953, the central government hereby authorizes the tea board to take immediate steps to take over the management or the control of the above tea estates as per the provisions of chapter IA of the Tea Act. The aforesaid order was passed on the grounds that, and whereas the central government is of the considered opinion that the tea gardens as listed below are being managed in a manner highly detrimental to the tea industry and to the public interest. We find some force in the submission advanced by Mr. Mitra, learned senior advocate appearing for the appellants, that the allegation that the 7 tea gardens were managed in a manner highly detrimental to the tea industry and to public interest could have attracted an order under section 16B or section 16D of the Tea Act 1953, but it could not have justified an order under section 16E. It was therefore submitted that the notification is bad. The other aspect of the matter is that by virtue of the said notification dated January 28, 2016, issued under section 16E of the said Act, and by operation of subsection 2 of section 16E of the said Act, the provisions contained in section 16A and 16B of the Industrial Development Regulation Act 1951 became operative, in consequence whereof the persons in management of the tea gardens are deemed to have vacated office. Therefore, the appellants who were running the aforesaid 7 tea gardens are no longer in possession thereof, whereas Mr. Bose, learned senior advocate appearing for the tea board, submitted that his client does not have requisite expertise to run the tea gardens. His client, he added, does that by appointing entrepreneurs, and for that purpose, tenders were invited 4 times. Mr. Chondo, learned additional Solicitor General of India, submitted that the tenders have now been finalized and managers of 4 gardens have been approved. As regards the balance, 3 steps have been taken by the central government. The picture which emerges is that the appellants in lawful possession of the gardens were removed. Now, my lord, lordship will kindly mark these, my lord. They were in possession of the gardens. My lord, it says that they are in lawful possession. They have been removed. My lord, it is on this basis that the court is proceeding. My lord, this order, your lordship will kindly take note of this order's date. My lord, this is 20th of September 2016. The agreement which I handed up to your lordship, my lord, dates to 5th of July 2013. Therefore, my lord, it predates the order which has been passed. Therefore, my lord, that agreement is not an agreement in terms of this order. This is the first point, my lord, which I am making. The picture which emerges is that the appellants in lawful possession of the gardens were removed without any adequate arrangement for taking over the day-to-day management thereof, either by T-Board or any other independent agency. Consequence is that the situation is worse than what it was on the day when the notification dated January 28, 2016 was issued. In that view of the matter, subject to result of the appeals, the following interim arrangement has been made, and therefore thereafter, my lord, an arrangement is made. My lord, there are agreements which have been taken note of, my lord, by the Willful Defaulter Identification Committee, some of which, my lord, definitely fall within the purview of this order. My lord, but this agreement does not. Not because this agreement is one which is dated 5th of January 2013. Therefore, this is an independent agreement which was not entered into by dint of this order. It had already been entered into, and in fact, my lord, this tea estate also does not find mention in the order. Your lordship sees page 298. And Lord, kindly match it, Lord, with the second page of the agreement. Clause A, capital A, the company is presently the owner of all that the tea estate commonly known as Maribong Tea Estate. My lord, Maribong Tea Estate is not the subject matter, my lord, of either the notification or this order.
Yes.
Therefore, my lord, this order will not, my lord, make good this agreement. What has happened, my lord, in this agreement? Your lordship will kindly see a few, my lord, clauses of this. My lord, I have shown clause A that it is the owner of the tea estate. Therefore, my lord, this submission that we were not in possession, it says it is the owner. Your lordship will kindly take, my lord, the clause 1.2 rather. 1.2. Agreement. 1.2, my lord, this is under the caption commencement and duration. It says none of the parties shall be entitled to cancel and or rescind this agreement before the expiry of the period of 3 years. So, my lord, for 3 years, this is an irrevocable agreement. None of the parties will be entitled to revoke it. Thereafter, my lord, clause 2(v). This agreement is for the benefit of the company. That is, my lord, clause 2 at the same page.
Yes.
V.
V.
V. My lord, 5,
V,
Roman
yeah.
5.
Yes. Yes.
Is for the benefit of the company. And my lord, 2.2. At or before entering into this agreement, NFT, my lord, is the second party to whom, my lord, the management is being given, has assured and or represented to the company that they are entering into this agreement for acquiring the exclusive right to market and sell the made teas and or green leaves produced and or manufactured at the tea estate for the entire term of this agreement, with the intent and object of ensuring that there is a continuity of supply to enable them to meet their commitments to overseas buyers, and the company, after having appreciated the same, has committed itself that during the term of this agreement, they shall not sell and or transfer the said teas, whether made teas or green leaves produced and or manufactured at the said tea estate, to anyone else.
What was the consideration for this agreement? Is
1
it
rupee.
mentioned?
1 rupee. Now, my lord, your lordship will see the consideration, lord. This is very pertinent, lord. I was coming to that. Kindly have a look, lord, 4.2. My lord.
Yes.
Finance and consideration is the heading. In consideration of this agreement and or arrangement, it has been agreed between the parties hereto that the company will be liable to pay to NFT a sum to be calculated at the rate of rupee 1 per kg.
So you say they transferred their rights.
This, my lord, this amounts to Lord, what else has been done, my lord, in my very respectful submission, if this is not, this is removal of the entirety of it.
This was in 2013.
Yes.
Your period
2013.
of allegation is
That was my period of allegation for revenue generation is 16, 17, 18, because from there, my lord, this I have, because the accounts, it is not that my loan was not there, that the default was not there.
but this is not your allegation period.
Yes, yes, it's there. Kindly have a look, my lord.
Show me that.
Yes, yes. The lordship will kindly take page 270.
Yes, Maribongti estate is there.
Yes.
That is the first allegation.
Yes. And my lord, the
Merico Agro, what about the others?
others, my lord, may be covered by the High Court order. My lord, I will not trouble your lordship with that, my lord. I could have made out a case, my lord, but I think I have a better case. Why should I run after, my lord, something else? My lord, if your lordship is, will see, my lord, this 1 rupee thing.
And even one of these, if even one of these grounds
yes,
are
my lord,
satisfied, then-
that was again, my lord, I was coming to it. Your lordship will kindly take the RBI circular now.
No, it is only any of the grounds.
Yes, RBI circular itself, my lord, because I have to make submissions on that. The lordship will take the circular.
Yes.
Lord. Lordship will take, my lord, 2.1.3. My lord has a copy of the circular.
Yes, yes, you handed over on the last.
My lord. My lord, it's the 3rd page of the circular.
Yes, yes, absolutely. Got it.
2.1.3 willful default.
Hmm.
A willful default would be deemed to have occurred if any of the following events is known.
Yes.
Any one. Now, my lord, what was the purpose, my lord, of this circular? My lord, this I will, I would like to make submissions on this because this is important. My lord, your lordship will turn the 1st page, my lord. Purpose. There is a stated purpose. The purpose is to put in place a system to disseminate credit information pertaining to willful defaulters for cautioning banks and financial institutions so as to ensure that further bank finance is not made available to them. My lord, this has a very important bearing. My lord, this circular and the purpose, my lord, was taken note of, my lord, by the Honorable Supreme Court in the earlier avatar of this circular. My lord, your lordship will kindly take this once. This is 2013, volume 7 SCC, page 369. Lord, paragraph 55.
Yes.
Your lordship sees, when we look at the master circular, we find that the purpose of the master circular is to put in place a system to disseminate credit information pertaining to willful defaulters for cautioning banks and financial institutions so as to ensure that further bank finance is not made available to them. My lord, this has been copied ditto, my lord. The Honorable Supreme Court, my lord, was considering the earlier version of this circular, my lord. This was revised. Lord, the circular which is now under consideration of your lordship is dated July 1, 2015. The circular, my lord, which was then being considered by the Honorable Supreme Court was, my lord, one of, my lord, I think 2014.
But that clause has been
Yes,
repeated here.
the same, my lord,
Purpose remains.
purpose, my lord, remains. The same purpose remains. My lord, here, interestingly, my lord, the recent most judgment of the Honorable Supreme Court, which was not cited, but my lord, was uttered by my learned friend several times during his argument, JAR developers. My lord, their JAR developers has gone to the extent of saying that this has a bearing, my lord, on the person's right to do business under Article 19. My lord, this exact argument was, my lord, made before the Honorable Supreme Court, my lord, in context of the 2014 circular also. My lord, it was dealt with and not dealt with. My lord, if your lordship sees, my lord, paragraph 61 of the judgment. Rather, my lord, 62. 62. We are also not impressed with the argument of Mr. Soli Sorabji that the master circular contemplates grave consequences affecting the right of a person under Article 19(1)(g) of the Constitution to carry on any trade, business, or occupation, and should be strictly construed, otherwise it will be exposed to the challenge of unconstitutionality. Thereafter, my lord, it says, since no
What
challenge
according
is-
to you is the sanction behind this? If one is marked as a classified as a willful defaulter, what happens?
My lord, then in that case, my lord, they will not be entitled, my lord. Under the circular, there will be a prohibition for them to get any financial help from any financial from any bank or
Can
financial
you please show me
institution.
that?
Yes. If lordship sees, my lord, 2.5.
But the DIN remains.
My lord,
DIN remains.
yes.
Director's identification number.
Yes, yes, yes. That will. 2.5.
2.5.
Penal measures, my lord.
Yes.
The following measures should be initiated by the banks and financial institutions against the willful defaulters identified as per the definition indicated at paragraph 2.1.3 above. No additional facilities should be granted by any bank or financial institution to be listed willful defaulters, to the listed willful defaulters. In addition, such companies, including their entrepreneurs, promoters, where banks, financial institutions have identified siphoning, diversion of funds, misrepresentation, falsification of accounts, and fraudulent transactions, should be debarred from institutional finance from the scheduled commercial banks, financial institutions, NBFCs for floating new ventures for a period of 5 years from the date of removal of their name from the list of willful defaulters as published or disseminated by the RBI CIC. Lord, this was taken note of, Lord, by the JAR developer in the case of JAR developers by the Honorable Supreme Court, and Lord, the Supreme Court inserted, Lord, this provision of making representation before the review committee. Otherwise, Lord, the review committee was only to look at the decision of the identification committee or either to approve it or reject it. Now, a further step was given to make a representation, and the review committee will consider the representation and pass an order. Lord, that stage has been completed here. They made a representation before the review committee. Review committee has considered it, passed an order, my lord, which has been placed before your lordship. Now, my lord, having stated this, my lord, I showed to your lordship, my lord, the purpose of the circular, my lord, with a purpose. My lord, even otherwise.
But dissemination of arguments.
My lord, this purpose,
Right.
even otherwise, my lord, under the Right to Information Act, has been said to be made public. If your lordship sees, my lord, this is the judgment of the Honorable Supreme Court in 2016, 3 SCC 525. Lord, it was a case under the Right to Information Act, where, my lord, somebody had made, my lord, an application before the RBI seeking a list of the defaulters, not willful. There the bank said that we are in a fiduciary capacity, we will not be able to give it to you. My lord, the matter walked up to the commission, and the Central Information Commission held in favor, my lord, of the information seeker. My lord, that judgment given by the CIC was upheld by the Supreme Court in the following words. Your lordship will kindly see, my lord, paragraph 80.
Yes.
In another case, where the respondent PP Kapoor sought information inter alia about the details of default in loans taken from public sector banks by industrialists, out of the list of defaulters, top 100 defaulters, names of the businessmen, firm name, principal amount, interest amount, date of default, and date of availing loan, etc. The said information was denied by the CPIO, mainly on the basis that it was held in fiduciary capacity and was exempt from disclosure of such information. Allowing the appeal, CIC directed for disclosure of such information. CIC in the impugned order has rightly observed as under. I wish the government and its instrumentalities would remember that all information held by them is owned by citizens who are sovereign. Further, it is often seen that banks and financial institutions continue to provide loan to to industrialists despite their default in repayment of an earlier loan. This court in UP Financial Corporation versus such and such noted that promoting industrialization at the cost of public funds does not serve the public interest. It merely amounts to transferring public money to private account. Such practices have led citizens to believe that defaulters can get away and play fraud on public funds. There is no doubt that information regarding top industrialists who have defaulted in repayment of loans must be brought to citizens' knowledge. There is certainly a larger public interest that would be served on disclosure of the same. Lord, this is whether willful or not. Default itself, Lord, should be brought to the knowledge of the public. Lord, something has been made impermissible under the willful defaulter circular, Lord, issued by the Reserve Bank of India. The impermissibility is for a certain period, you will not be able to get finance from banks, Lord, whose names, or whose classifications have been given here, banks and financial institutions. But not anything that is not impermissible is generally not right. Lord, that is what has been commented upon here. Lord, the Honorable Supreme Court also endorses this. Lord, even today, as by way of a general practice, Lord, he will not get loans if he is an NPA, Lord, of a particular size. Lord, if he's a small defaulter, Lord, he can try his luck. But Lord, if he's an NPA with so many banks, he will in any event not gain loan. Lord, today, if your Lordship, Lord, even if your Lordship allows this writ petition and sets aside, Lord, the willful defaulter declaration, by dint of mere default, they will not be able to get loans. Lord, this is my submission, Lord, in the alternative. And this is the judgment for that. Now, my Lord, I had indicated to your Lordship on the last occasion that, Lord, since your Lordship is sitting in judicial review, your Lordship will not reappreciate evidence, and your Lordship will not, my Lord, see as to whether the finding that has been arrived at by the committees, my Lord, whose conclusions are being tested by your Lordship today, are correct or not. The test, my Lord, which your Lordship will put to these orders, or my Lord, the orders your Lordship will put to such a test to see as to whether, my Lord, the conclusion that has been arrived at by the committees would or could be arrived at by any reasonable person on the basis of the evidence that is there. Whether it is a case of no evidence or it is a case of some evidence, or, my Lord, taking all the evidence in totality, whether this conclusion could be arrived at. If there is a possibility, my Lord, your Lordship will uphold the conclusion. Now, my Lord, for this purpose and before moving further, my Lord, the authority, my Lord, whose action is in question before your Lordship is an administrative authority. My Lord, I also submitted, Lord, and I repeat this, that, Lord, application of mind and application of judicial mind, my Lord, are two different things. My Lord, the difference may be very fine, but, my Lord, it's a real difference, my Lord, which exists. My Lord, the Honorable Supreme Court in Jar Developers case has held that the authority, my Lord, both the authorities, the review committee as well as the identification committee, my Lord, are administrative authorities. They are not even quasi-judicial authorities. Therefore, my Lord, when your Lordship is analyzing their judgments or their conclusions, my Lord, your Lordship will not analyze them on the anvil, my Lord, of a judicial, my Lord, of a judicial mind, my Lord, writing a judgment, or, my Lord, a quasi-judicial authority writing a judgment.
Right.
Now, my Lord, to just show that they have been held to be an administrative authority, my Lord, I am relying on Jar Developers. This is 2019, Volume 6, SCC 787. My Lord, paragraph 14.
Yes.
Applying the aforesaid tests of the facts of the present case to the facts of the present case, it cannot be possibly said that either in-house committee appointed under the revised circular dated 1st of July 2015, which is the circular, Lord, which your Lordship is also considering, with the judicial power of the state, the impugned judgment's conclusion that such circulars have statutory force as a result of which the state's judicial power has been vested in the two committees is wholly incorrect. First and foremost, the state's judicial power as understood by several judgments of this court, is the power to decide a list between the parties after gathering evidence and applying the law, as a result of which a binding decision thereon is reached. This is far from the present case, as the in-house committees are not vested with any judicial power at all, their powers being administrative powers given to in-house committees to gather facts and then arrive at a result. Secondly, it cannot be said that the circulars in any manner vests the state's judicial power in such in-house committees. On this ground, therefore, the view of Delhi High Court is not correct, and no lawyer has any right. Not the question was whether lawyers will not have right to participate in the proceedings before the willful defaulter identification committee. Now, my lord,
This is probably the second time I'm reading the para 14. The first time I read the entire judgment, and thereafter I've been reading section 24. I have para 24.
because lord,
Only paragraph cited and only paragraph.
lord, that is why I did not cite 24, lord, because that was
Please don't.
and lord, 24, lord, is everybody's lord. No, my lord. Kindly take, my lord, this constitution bench, lord, 3 lines, very instructive. Lord, this is AIR 1964 Supreme Court 477.
Yes.
477.
Justice Gajendra Gaj.
Kindly see, lord, paragraph 16, 16. Sayyid Yaqub. Lord,
What is
paragraph
happening?
16.
Any 3:30 on Friday? What is happening? Some announcement is being made.
Lord, maybe, my lord, I was hoping you will have one. We haven't had it for
Let
long.
me ask the government pleader. Yes.
I'm the government leader, my lord. I-
Yes, you are the state. You are responsible for all the demises which happen in it.
Yes, my lord, I am the head, though my notes.
No.
There are
Not
none. No,
you're shaming the profession of a certain section of society.
I'm not shaming.
You are
my
a
lord.
state, yes.
No, I'm not shaming.
Why do you
I
refer
get
to
the
yourself
first
as the head dome with
I
such
get the first
hung
information.
head and all these things?
I get the first information, and then I move the offices, my lord. But there are none, my lord. We are.
Nothing, yes.
I think, my lord, there is something I heard, my lord. I'm not too sure, my lord.
No, that's not happening.
এগুলো চলছে তো এটাই problem. But I've heard
This cannot be labeled as wishful thinking.
something with the bar council, some lawyer. I was hearing.
No, that's
something.
it.
Strike is
That
No,
was
no,
something.
that's different. Probably resolved by Justice Shenmukta.
Yeah.
Yes, my lord, I was there, my lord. Yes.
You should have opposed.
My lord,
If
yesterday
there
I
was no resolution, then your
yesterday
wish could
I
have.
got very scared, my lord. Personally, I was very scared, but I won't mention it here, my lord. It's very
No.
scary, my lord.
Right. Para 17, yes.
16, lord.
16, I'm sorry.
16. Lord, about 12 lines from the bottom.
Hmm.
If that be so,
Yes.
my lord has found.
Yes.
If that be so,
Let it be so then.
a decision based on facts found by the tribunal cannot be reappealed on the plausible plea that a further inquiry should be made because that would be thus. If the findings of fact were allowed to be disturbed by high courts in such writ proceedings that may lead to an interminable search for correct findings and would virtually convert the high courts into appellate courts competent to deal with questions of fact. That is why we think in entertaining petitions for writs of certiorari, it is necessary to remember that findings of fact recorded by special tribunals, which have been clothed with jurisdiction to deal with them, should be treated as final between the parties, unless, of course, it is shown that the impugned finding is based on no evidence. Therefore, we do not think the plea made by Ms. Such and such. My lord, your lordship will have to see whether.
This has been diluted now, widened. I mean, not only no evidence.
Yes, my lord.
This very principle and other things are
Yes,
there
yes, my
also.
lord. I'll show those judgments also, my lord. Because
No, don't.
No.
What does that?
The other judgments also, my lord, how it has developed. Lord.
I'm not
too
interested,
many.
Mr.
Not too many.
Believe
not too
me.
many.
Yes.
Not too many, my lord.
Yes.
Because they are germane for this. Lord, this is 1995, volume 6, SCC 749.
Yes.
Judgment Para 12.
That will be yes.
Judicial review is not an appeal from a decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion with the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court or tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with. Whether the findings or conclusions are based on some evidence, the authority entrusted with the power to hold inquiry has jurisdiction, power, and authority to reach a finding of fact or a conclusion, but that finding must be based on some evidence. Neither the technical rules of evidence nor proof of fact or evidence as defined therein apply to disciplinary proceedings. When the authority accepts that evidence and conclusion receives support therefrom, the disciplinary authority is entitled to hold that a delinquent officer is guilty of the charge. The court or tribunal in its power of judicial review does not act as the appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court may interfere where the authority held the proceedings against the delinquent officer in a manner inconsistent with the rules of natural justice or in violation of statutory principles prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding be such as no reasonable person would have ever reached, the court or tribunal may interfere with the conclusion or the finding and mold the relief so as to make it appropriate to the facts of the case. Lord, I shall not multiply on this.
What do you mean by that?
No, because there are several others. I will not, my Lord. Lord, this is 2021, volume 2, SCC 612.
Yes.
Paragraph 28. Lord, the Constitutional Court, while exercising its jurisdiction of judicial review under Article 226 or Article 136 of the Constitution, would not interfere with the findings of fact arrived at in the departmental inquiry proceedings, except in case of malafides or perversity. Lord, that is explained. That is where there is no evidence to support a finding, or where a finding is such that no man acting reasonably and with objectivity could have arrived at those findings, and so long there is some evidence to support the conclusion arrived at by the departmental authority, the same has to be sustained.
Yes.
So, my Lord, if your Lordship sees the orders, my Lord, of the two committees, one by the identification committee and the other by the, my Lord, review committee, the review committee, my Lord, has agreed with the orders, my Lord, of the identification committee. In case it's, my Lord, an order of agreement, my Lord, no further separate reasons are required to be given. My Lord, if it
Did
agrees,
they take any new point in their representation? Sir?
nothing, because that, my Lord, your Lordship can compare. My Lord, I shall be giving your Lordship the pages. My Lord, I have done it. Nothing new. The only new thing is that the willful defaulter identification committee has not considered what I have stated before them. And therefore, my Lord, I am repeating it before. And that is the submission before your Lordship also, my Lord, that none of them have considered. Now, my Lord, on this, Your Lordship will take, Lord, 87 supplementary SCC 582. Paragraph 7. It has been pointed out by the High Court that the punishing authority has passed a lengthy order running into 7 pages, mentioning therein the contents of the charge sheet, the detailed deposition of the witnesses as recorded by the inquiry officer, and the findings of the inquiry officer. All these are quoted. Thereafter, the explanation submitted by the appellant has also been reproduced. Thereafter, my lord, this is the reason. The punishing authority stated as follows: I have considered the charge sheet, the reply filed to the charge sheet, statements made during inquiry, the report of the inquiry officer, the show cause notice, the reply filed by the delinquent and other papers, and that no reason is available to me on the basis of which reliance may not be placed on the report of the inquiry officer. Therefore, keeping these circumstances in view, I terminate his service with effect from the date of issue of the order. In view of the contents of the impugned order, it is difficult to say that the punishing authority had not applied his mind to the case before terminating the services of the applicant. The punishing authority has placed reliance upon the inquiry report of the inquiry officer, which means that he has not only agreed with the findings of the inquiry officer, but has also accepted the reasons given by him for the findings. In our opinion, when the punishing authority agrees with the findings of the inquiry officer and accept the reasons given by him in support of such findings, it is not necessary for the punishing authority to again discuss evidence and come to the same findings as that of the inquiry officer and give the same reasons for his findings. Lord, your Lordship will kindly take this also. 2020 SCC Online Supreme Court 847. No? 847. 847. But kindly have a look, Lord, paragraph 39. Yes. Lord, on what could be, my lord, considered as violation of principles of natural justice, fair hearing, my lord, difference between no hearing, no adequate hearing, no opportunity, no adequate opportunity. Lord, on this, my lord, your lordship will kindly take, my lord, clause 4. In cases where facts can be stated to be admitted or indisputable. Lord, facts are indisputable. Lord, something has come in, something has been done. They may not have admitted it, but Lord, this cannot be disputed. If facts are indisputable and only one conclusion is possible, the court does not pass futile orders of setting aside or remand when there is in fact no prejudice caused. If the same conclusion would be arrived at, again, my lord may be supporting it with a half page of reasons. Your lordship will not exercise your lordship's jurisdiction to send it back. Lord, if the records, my lord, reveal reasons, my lord, the reasons may not, my lord, have been so expressly stated in the order impugned that it appeals, my lord, to the intelligence of the reader. Yet, my lord, upon going through the records, my lord, it can be, my lord, the reasons can be discerned. Then in such cases, my lord, your lordship will not interfere with the findings. Lord, on this, your lordship will take 1991 supplementary volume 1 SCC page 161. paragraph 6. It is undoubtedly true that the notice does not prima facie disclose the satisfaction of the two conditions precedent enjoined under section 147A, but in the counter affidavit filed by the income tax officer in the High Court, he stated all the material facts. Lord, is supporting something. The respondent had inspected the record, and the record also bears out the existence of the material facts. The proceedings drawn, which was abstracted earlier, also shows that the income tax officer had applied his mind to the facts on the record and was prima facie satisfied that reopening of the assessment for the assessment year 1957-58 was needed due to those stated facts. Thus, though ex facie, the notice does not disclose the satisfaction of the requirement, but from the record and the averments in the counter affidavit, it is clear that the income tax officer had applied his minds to the fact, and after prima facie satisfying himself of the existence of those two conditions precedent, reached the conclusion to reopen the assessment. It is settled law that in an administrative action, though the order does not ex facie disclose the satisfaction of the officer of the necessary facts, but if the record discloses the same, the notice or the order does not per se become illegal. Lord, I would rest at that, Lord. Lord, if my learned senior film Lord shows, Lord, Mr. Saha, Lord, in course of his arguments, any judgment, Lord, your Lordship will kindly, Lord, give me an opportunity to rebut it, Lord, because
only one thing, we had argued both the writs together. So if he wants to finish one, and then your Lordship desire is we address your Lordship on that first, on reply.
Both the writs are on same points.
No, there are additional points in the second one.
yes, Lord, so
There
far
are
as the
jurisdictional issues
second
in
writ
regard
is
to the
concerned,
second.
Jurisdiction.
With regard to the second. Yes.
yes, Lord, second writ is concerned, Lord, I am, Lord, your Lordship will record my objection to that. That's all, Lord, because I will not trouble your Lordship with that, Lord, they have a point. Lord, because they have said that he is not a promoter. Lord, our inspection shows that it is a promoter. Lord, I shall be relying on that document. Lord, I don't have it now. I shall be producing it, and that is, Lord, from the ROC records. If it appears that he is a promoter, Lord, then all these points hold good. Lord, Lordship will give me a day, Lord, because I have asked the bank, Lord, to get those records. Lord, if the ROC records, Lord, show that he is a promoter, Lord, then all these points, Lord,
Get those records by Friday, day after tomorrow.
Lord, I'll get them.
Shall keep for further hearing on Friday. Conclude your arguments on the second one also.
Yes.
Either concede to that point or place your.
Lord, I will not, Lord, officially concede, Lord, your Lordship.
No. Yes, right.
Lord, because I will not waste your Lordship. Lord, if I myself am not satisfied that he is a promoter,
No. Thank you so
then
much.
in that case, Lord, I will not.
To say that probably that can be disposed of and we can proceed with
Yes, yes.
final
Lord,
disposal
your
of
Lordship
this.
will dispose of both together, Lord, for.
Very good. Put that on something on record. I mean, whatever.
Yes, definitely, Lord, I shall.
Good. So we'll continue on Friday.
Friday.
Let him conclude first, Mr. Rai. Then.
Yes.
We heard in part for
Sir,
further
only one
hearing
thing, this
on September
the
8th.
supplementary affidavits in both the matters, we've served them in advance copy.
For further hearing on September 8, 2023, supplementary affidavits filed today be kept on.
Lord, I have received it only today, Lord. If something is relied on, submitted on this,
Come
Lord,
back on Friday.
Yes, Lord, but I don't know what will be submitted on this, Lord. If something is submitted, Lord, because these are documents, Lord, which
No,
are coming.
supplemented affidavit for what, Mr. Banerjee? At this stage, we have advanced in the hearing.
Those agreements that my learned friend was relying on.
I was relying on one of the agreements.
Those agreements we've disclosed.
But after your hearing, Mr. Banerjee,
I myself don't know. Give me
please
one
check up
minute.
because after at the hearing stage, I won't permit otherwise. Yes.
Oh,
I concluded your argument.
Typed copies of illegible documents. There are no new documents. Which is why we were also not favored with the copy.
There was no supplementary filed earlier, Lord. This is the first time supplementary is being filed because they sought to file.
একটা line add করে নিন তো, ইয়ে।
My instructions are that there are no new
Learned
documents.
counsel for the petition, learned counsel for the petitioner clarifies that the supplementary affidavit only annexes legible copies of documents which are already on record. Full stop.
নতুন কাগজ আছে না নেই?
নতুন আছে কাগজ, I have seen.
That is the reason for my recording. Yes.
No, this appears I've made a wrong submission.
Keep the supplementary affidavit with you then.
Then I'll look it
Supplementary
up.
affidavit
Let
লিখবেন
it
না।
be. No, let me have a
Supplementary
look at
affidavit
it.
file today ওই শুধু যেটা
ফেরত
hard
দাও।
in part for further hearing on September 8. Don't use any supplementary affidavit. না আর কিছু না। Hard in part for further hearing on September 8, 2020. September 8, right.
दे रही है, क्या दिक्कत है?
I'm appearing for civil in this.
Grateful, not grateful.
Item number 4.
Item number 4, I am for the petitioner.
Yes.
I have some confusion regarding maintainability of this petition. Kindly allow me to come back on Monday.
Monday, very good, please.
Monday or any day, well, as it.
No, Monday I don't have any difficulty. I won't be there for 2 weeks, but come back on, I mean, I'll keep it on the list.
Good.
On the prayer of the petitioner, the matter is adjourned till September 11, 2020.
Great.
Happiest.
ও তো সার্ভার হোসেন, ওর নাম সার্ভার হোসেন। পিটিশনার সার্ভার হোসেন। সার্ভার হোসেন না,
Sir, Jahan.
সার্ভার
Jahan.
জাহাঙ্গীর। সার্ভার জাহান।
Item number 5.
May it please your lordship, in item number 5, I'm for the private respondent number 6.
May it please your lordship, I'm appearing on behalf of the writ petitioner, right? My lord, in this writ petition, we have challenged.
6 is the main respondent, the contested respondent.
No, my
private
challenge, my lord, is
respondent.
against, they are the private, but he's appearing on behalf of the private respondent number 6.
My lord, before my learned friend begins, only one thing, I'm challenging maintainability of this writ petition, my lord. It emanates from an RTI application, my lord, application under Right to Information Act. Non-disclosure of information, my lord, the RTI Act itself provides for a statutory remedy. There is an appeal mechanism, my lord, that has not been exhausted, my lord.
Yes, come against the first authority, the SPIO.
Against
Oh,
the
no.
first authority, SPIO.
What are you challenging here?
But kindly comes to, my lord, page 21, that is the order impugned according to us. It is an order passed by the competent authority under the Smugglers and Foreign Exchange Manipulators Act. We had sought for information under an RTI application, and we have been favored with such information. So my challenge is this, not my lord, non-inaction in the part under the part of the RTI Act. This is, I'm aggrieved by this particular order.
So have you filed your affidavit of service? All have been
Yes,
served?
my lord. May I
Check up,
file my
please.
affidavit
Yes.
of service?
Please check up.
And my lord, pursuant to filing of this application, my lord, we had applied for an RTI to the authority. The RTI has replied. May I, my lord, file that through a supplementary affidavit? We have prepared it.
You are relying on that.
My lord, we
But I'm not per se relying on that because what I sought for has not been answered. I was asking for documents. But however, my lord, for the comprehensive adjudication of the matter, it is better, my lord, that I put that on record.
My lord, we should be served a copy of
Yes,
that
yes, most
reply. my
certainly.
lord.
Sure.
Yes. At a copy. If your lordship is at page, my lord, 21, I am agreed, my lord. Page 21 is annexure P1, my lord.
Yes.
My lord, your lordship will find name of address and affected person.
Right.
My lord, that is, my lord, Shri Vishwanath Bhattacharya, who is the father of the petitioner. Now, my lord, this is a document dated 1st of February 2023. And, my lord, it says that whereas an order under section 7 of the Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976 was passed on 27th February 2020, declaring the property, leasehold property at plot number such and such, my lord, to be illegally acquired property within the meaning of section 3 under the Act of 1976. And hence, the same was forfeited to the central government free from all encumbrances. It is now therefore being ordered under subsection 1 of section 19 of the Act that Shri Vishwanath Bhattacharya, having resided at plot number such and such, shall surrender within 30 days. And then, my lord, it goes on to write the manner in which the such surrender has to be done. My lord, kindly turns the page, my lord, comes to the next page, my lord. My lord, it has only been served to Vishwanath Bhattacharya and the subdivisional officer, which I am told, my lord, is the executing authority. Now, my lord, I am Shivli Bhattacharya. I am the daughter. Because Vishwanath Bhattacharya has long died in 2020 in the month of June. But this order, my lord, which is passed on, my lord, I'm led by Mr. My lord. But this order which has been passed, my lord, your lordship has seen the order of 27th February 2020, which is the order declaring that the property has been illegally acquired through illegal income and, my lord, was forfeited. I have not been preferred with a copy of this order. My father may have been, but he has died. But I have not been, my lord, given a copy of this order. I keep on writing representations.
But the order was passed during his lifetime.
Order may have been passed during his lifetime, my lord.
They are not duty bound in law to serve it on you.
If I see, my lord, the definition of affected person which they themselves use,
yes,
my lord, the affected person Vishwanath Bhattacharya was during his lifetime. But today they have served me. This property is a vacant land, but I have been served. Today I have gone into the shoes.
Achha, this has been served on you.
Yes. No, my lord, I am being led by Mr.
You are wanting a copy of that order only.
Principal order, my lord, 27th February 2020.
Yes.
I have not been served.
You are wanting a copy of that order.
So that, my lord, I can prefer the statutory appeal.
Right, right. Only
And-
that.
Yes, because my lord, I cannot come to the writ.
You cannot, yes, right.
I cannot challenge it otherwise. And another thing, this order is in the nature of execution of the order of 27th of February.
Yes, yes.
Property has been forfeited. I am asked to surrender. So, my lord, for execution, notice is being served upon me. And kindly see the time gap, my lord, 27th February 2020, the order was passed. My lord, the person died June 2020. And then they are aware of the heirs. They have served it upon the heirs for execution.
Right.
My lord, if your lordship sees the act, my lord, once act But I am very sorry.
For the Union of India, respondent 1 and 2.
Very good.
Lordship will see, my lord, section down.
Give a copy to them of that order.
No, no,
It's not the order.
I am sorry, my lord. It is my fault, my lord. I ought to have given your lordship the copy of the act.
I have
My lord,
Not that. I mean, I'm asking you. I'm asking him to give a copy of that order which you asked him for.
Yes.
27th February.
They have made an application under the Right to Information Act before the competent authority of Mumbai.
I'll render that infractuous. You give a copy. They want to challenge it. Give a copy. Yes.
Authority has transferred to the Kolkata authority. Now they have on 11th August they have paid for the disposal of their Right to Information application. If your lordship kindly give the direction, they will consider and whatever information it is.
No information. Just give them a copy of that order.
They are asking several information. If your lordship kindly see that.
I'll not touch those.
I will lordship, I will-
Only give the. I cannot touch those because your learned friend is right on that because there the jurisdiction writ would not be maintainable. But only this order copy because they have been served. They are undoubtedly agreed. Yes, which any particular provision, Mr. Sen?
Yes, my lord, the provision of appeal,
Yes.
12, my lord.
section 12,
Yes.
kindly says 12 subsection 4. Any person aggrieved by an order of competent authority made under section 7.
Yes, yes, definitely.
So, my lord,
No, you have a right of appeal. Yes.
but only, my lord, I am, my lord, in some difficulty. If your lordship sees the proviso.
Yes.
Proviso is
Yes.
the appellate tribunal may entertain any appeal after the period of 45 days,
Yes.
but not after 60 days from the date aforesaid. If it is satisfied the appellant was prevented by sufficient cause from filing the appeal in time. And, my lord, it is time starts from the date on which order is served on him. But I do not, the order.
But then, Mr. Sen, you are in difficulty because during the lifetime of your father, he was alive for 4 months after that.
But the question is, when was the order served upon the deceased person? That also they have not informed. That was also my information, which I have asked for. But after all, my father's property, which I have inherited, that is going to be forfeited. They are saying. So this is a substantial right which is being taken away. And, my lord, this section, my lord, my most respectful submission, my lord, it has to be given a purposive interpretation. What is the purpose? Purpose is to enable.
That question we cannot go into here, Mr. Sen. Because unless you prefer an appeal and make such an application, it will be decided there, then ultimately may come to someone.
Your lordship will only say this, my lord, subject to what falls from your lordship, that the order is being served on me now pursuant to the order of court. Therefore, whatever rights I will have upon service of the order.
But this cannot operate as the first service, Mr. Shen. That is your client's intention. You cannot reopen the limitation from today. Unless your predecessor did it. I mean, if he failed the chance, he has failed the chance. He got 4 months during his lifetime after the order. So if 45 days is the limitation, if he was served, we don't know that. We cannot entitle, clothe with entitlement every representative of the person whenever he comes.
There is also a fact, my lord, which nobody can ignore, that the person died on 27th of June.
22nd. Yes.
22nd on June.
Yes,
So, my lord,
yes.
even if they can show service on a particular date after 27th of February,
yes,
the person has not been able to exercise that
At
right.
Mr. Shen, if you approach the appellate tribunal, then only you can canvass.
Very well, my lord, but
Obviously, you know what to do. I mean, you will allege that it was not served and all this. Then they have to
the
show.
lordship will only record this, that the order was not served upon the heirs, the affected
That will
party.
create difficult.
So, but because that is what they have never disputed that.
There was no occasion to serve on the heirs. Why should I observe that? That would reopen the scope of
Obligation to
appeal.
serve on this. It has not been served. They have not denied it ever. That it has not been served on this.
But they are serving the order of execution on the heirs.
Yes, because you are in possession now.
The vacant land.
It's a vacant land.
Milord, if I may point out paragraph 2 of their writ petition. Paragraph 2, Milord. Milord, the second sentence of paragraph 2.
Yes.
The applicant and the said opposite parties have never been and are not in possession of the said property, which is sought to be forfeited. So, my lord, where is the contention really? In the sense that if they have never been in possession of the land, and moreover, my lord, if my lord comes to page 30 of the writ petition,
Not in possession, I will be divested of my ownership.
my lord, if my lord comes to page 30,
My learned friend is
they
appearing
had
for the executor. He should not
He's my brother.
make submissions,
one
my lord, which
second.
are contrary to the.
You are also one of the heirs.
That is what
I'm also one of the heirs. What I'm alleging right now is
So the executor has not taken steps. It's the legal heir who has come to take steps at least.
my lord, my learned friend is leveling allegations at everybody under the sun, including the executor, including the respondent numbers 1 and 2. But where is the bone of contention? If the bone of contention is merely the receipt of the order, then, my lord, a simple production of that order will suffice. Apart from that, my lord, the rest of the prayers which have been
Mr.
sought
Shen, I'll
for in this
direct them to
petition.
give a copy of the order to you, but regarding the other aspects of the matter, those will be kept open. This, I'll make it very clear
Very well.
on this limitation, that you will be entitled to agitate that before whatever.
You order to set aside.
Learned counsel for the petitioner argues that the petitioner was served with a notice under the Smugglers and Foreign Exchange Manipulators within bracket forfeiture of property bracket closed act 1976. Full stops. The date of such notice was February 1, 2023. Full stop. Apparently, the respondent authorities placed reliance on an order passed on February 27, 2020 against the father of the petitioner, since deceased, of which the present notice is one for execution. Full stop. Next para. It is argued by the petitioner that since the petitioner was never served with a copy of the original order dated February 27, 2020, and the petitioner's father met his demise in the month of June, 2020 itself, a copy of the order needs to be furnished to the petitioner to effectively give an opportunity to the petitioner to challenge parent order. Full stop. It is argued that in the absence of any proof of service of the order on the petitioner or the predecessor of the petitioner, the period for preferring an appeal within the contemplation of section 12 of the 1976 Act ought to commence from after the copy of the order is served for the first time on the petitioner. Full stop. Next para. Learned counsel for the respondent authority submits that an application filed by the writ petitioner under the Right to Information Act was turned down, against which an appeal is now pending. Full stop. The same contention is also advanced by learned counsel for the private respondent, who submits that the writ petition is not maintainable to seek a relief which is sub judice before the first appellate authority under the Right to Information Act. Full stop. Next para.
But I have not preferred any appeal.
I said that an appeal is available to them.
Oh, acha.
We have not preferred any appeal.
ठीक आगे सेंटेंस की बोला?
Submits that an application filed with the petitioner under the right to information act was turned down against which
Was it turned down?
They have,
No, no,
they have given
It is pending.
not
They-
answered all queries.
Which was turned down থেকে কেটে দিন। আগে পর্যন্ত যে সেন্টেন্সে থাকবে
right to information was turned down.
and they
was turned down থেকে কেটে বাকিটা কেটে দিন, ওই সেন্টেন্সটা কমপ্লিট করে দিচ্ছি আমি।
My lord, I believe that they
Your Lordship will see the supplementary affidavit
Hmm.
where they have given a reply but not the order.
Was filed. Full stop. Next para. Hence, comma, it is contended that no, hence it is contended that the writ petition is not maintainable, comma, in view of the petitioner having availed of a remedy under the Right to Information Act. Full stop. Against any order passed by the first authority under the said act, comma, an appeal it is submitted is available. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is evident that the petitioner apparently stepped into the shoes of her father, comma, against whom an order was passed under sections 7 within bracket 1 and 3 of the 1976 Act on February 27, 2020. Full stop. The petitioner has rightly contended that since an order, comma, since a notice, comma, virtually for execution of the said order has been served on the petitioner, comma, the petitioner falls within the category of within double inverted affected party, double inverted clause, comma, empowering the petitioner to prefer an appeal, comma, if the petitioner so chooses, comma, against the parent order. Full stop. Next para. However, comma, in the absence of any copy of the said order dated February 27, 2020, comma, the petitioner would not be equipped to prefer such appeal. Full stop. Next para. Even without going into the question as to the starting point of limitation, comma, since it will be premature to adjudicate on the issue as to whether a copy of the order was ever served on the petitioner's predecessor, to commence the starting point of limitation, comma, it is clear that the petitioner, comma, being an affected stroke aggrieved party, comma, is at least entitled to get a copy of the order to enable her to prefer an appeal, comma, if otherwise maintainable in law. Full stop. Next para. Insofar as the other queries made by the petitioner under the Right to Information Act, comma, pertaining to whether any notice was given to the predecessor of the petitioner or regarding some other queries, comma, the same are not being touched in the present writ petition, comma, since an alternative forum has already been chosen by the petitioner by making an inquiry under the Right to Information Act 2005. Full stop. Next para. In such view of the matter, comma, WPO 1564 of 2023 is disposed of by directing the respondent number 2.
My lord,
Yes.
one and for Union of India, kindly take up one Union of
You will give the copy of the order.
the competent authority.
Directing the respondent number 2 to serve a copy of the order dated February 27, 2020 passed against the predecessor in interest of the petitioner under sections 7 within bracket 1 and 3 of the 1976 Act to the petitioner within a fortnight from date, full stop, next para. However, comma, it is made clear that the said date shall not, the said service shall not create any special equity in favor of the petitioner.
This will go against, well, if even the appellate authority may exercise any discretion on my pleadings or otherwise.
আচ্ছা, however থেকে however টা শুরু করুন, however থেকে বাকিটা কেটে দিন, however দিয়ে অন্য, however comma, the question of limitation shall be open to be adjudicated by the appellate authority in the event the petitioner prefers a challenge against the said parent order dated February 27, 2020, comma, within the contemplation of section 12 of the 1976 Act. Full stop. No address to cause urgency.
For a
My lord,
limited
just one thing.
period, my lord, no coercive action should be taken.
My lord, just one thing. They handed over a supplementary affidavit containing a purported reply, my lord. However, there is no annexure.
Fresh copy.
Here's it is.
Not received any copy.
Supplementary affidavit you are filing today?
Yes, only to show this order, which reply which has come.
No, Mr. Shen, I am not
Very
filing that. A supplementary affidavit for it. Yes.
Well,
My lord, one indulgence, my lord, if your lordship recorded to give the copy of the order 15 days from date. If your lordship kindly.
Fortnight, yes.
From date, today. If your lordship kindly record from the date of communication order, it will be better, my lord.
You are appearing. Where is the
And I don't know what is the communication. Till today I am unable to communicate the order. This is the whole.
No, no question of communication.
I have to intimate the order, my lord.
Intimate, yes.
This is the thing. If your
I'll give you
lordship
3 weeks then. Instead of fortnight,
that can be done.
fortnight এর বদলে ওটা 3 weeks করে দিন। দেখুন তো যে WP is disposed of যেখানে বলেছি।
but before, at least before giving the order, my lord, they should not take.
Accordingly, writ petition এ যেখানে dispose of করলাম যে লাইনটা।
Passed against the petitioner interest of petitioner under section 7 within bracket 1 and 3 of the 1966 Act, the petitioner within a period of 3 weeks. Grateful, my lord.
Well, at least till such time I get it, my lord, I must get some.
Supplementary affidavit হবে না।
ওটা my-
No, Mr. Shen, yes.
Well, that, my lord, my lord, without getting the order, my lord, it will be taken away. But that only that aspect, well, your lordship will consider.
Lord, may I just mention the very next item, I mean, led by the learned Advocate General. Lord, Friday, my lord, he's not here for personal reasons. He was and I'm also being led by Mr.
No, not me. He's totally ignored me. But I am for the respondent. My lord, I'm just, my lord, perhaps my lord is not there, my lord, the week.
Next 2 weeks I'll not be there, Jalpaiguri bench.
Oh,
So,
no, perhaps my lord, no point, my lord, in continuing with our arguments tomorrow then, my lord, and the Advocate General is also not there tomorrow.
whatever, I mean,
If it's possible, my lord, then on
so
the,
should I keep it when?
after, my lord, on the 3rd of October, my lord, is it possible? It's a Tuesday, my lord.
Yes, no difficulty. তাহলে ওটা পরের ম্যাটারটা কোনো অর্ডার রেকর্ড করছি না। You are all of you are present.
Yes.
So I'm recording an order then.
Yes, yes, yes.
একটু বোর্ডে দেখিয়ে দাও। হ্যাঁ। পরের ম্যাটার। এক লাইনের অর্ডার হবে। On the prayer of learned counsel for the parties, the matter is adjourned and shall next be listed on October 3, 2023. Yes.
Very grateful.
I'm grateful.
মানে হচ্ছে মানে ক্লাসিক কভার ড্রাইভ দাদা কি করলে দাদা